Good morning and welcome to the Nevada State Board of Pharmacy April 2026 meeting. Today is Wednesday, April 15th, and our meeting will now come to order. My name is Helen Park and I'll be the presiding officer. We'll start with the Board of Pharmacy mission statement. In regulating the practice of pharmacy, the Nevada State Board of Pharmacy has a duty to carry out and enforce the provisions of Nevada law to protect the health, safety, and welfare of the public. Next, we'll do our roll call. Mr. Adam Porath,
Here.
Mr. Richard Tomaso,
Here.
Ms. Jade Jacobo,
Present.
Ms. Anna Carr,
Present.
Ms. Crystal Freitas.
Here.
Okay, and then I believe Ms. Shanice Taylor.
She said it, whoa. Shanice had a excused absence.
Thank you. We do have a quorum present, so we'll go ahead and move forward. And with that, I will turn it over to Mr. Weiss for any announcements.
Good morning, Madam President. I'll try to control my voice here. Good morning. As usual, the board will be held in compliance with Nevada open meeting law. We will have some appearances on Zoom today, both for stipulated agreements and for applications and other required activities. I will tell the public that I think that we have a couple items that we expect some public comment on, which is great. But there'll be multiple opportunities for public comment. And so if you're here to comment on a particular workshop or hearing, I request that you save that to the public comment for that time so the board has the information in front of them when you're making your public comment. And with that, I'll wish you a good meeting and turn it back over to you.
Great, thank you, Mr. Weiss. As our next order of business, the board will open up the floor for general public comment. So if we have anyone in the room or online who wishes to make a public comment, I ask that you come forward now if you are in the room, or if you could raise your hand on Zoom or press *9 or *6 to get your line unmuted. Okay, it does not appear that we have anyone in the room wish to make public comment. Do we have anyone online or on the phone?
No, Madam President, not at this time.
Okay, we will have an opportunity for public comment again at the end of today's meeting. But seeing that there's no public comment for now, we'll close the period for public comment and we will move on to the approval of the meeting minutes from our March board meeting. The board members, I had a chance to review the minutes. I did not have any questions or concerns. All looked okay to me and it'd be comfortable moving forward.
Neither did I, Madam President. I move that we go ahead and approve the meeting minutes from the March meeting.
For a second.
Okay, we have a motion by Ms. Jacobo, a second by Mr. Porath. Any further discussion? Okay, hearing none. All those in favor?
Aye.
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 Any opposed? Okay, the board meeting minutes from March have been approved.
Madam
Next,
President,
yes.
we have one late public comment if you want to indulge that, or you can have them do it at the end of the meeting. They've just raised their hand.
If we could do it at the end of the meeting, that would be my preference.
Right.
As we move forward. Okay, we'll go on to the consent agenda now. And then for the consent agenda, I did not have any questions or concerns, but I think Mr. Porath has a.
Madam President, we could separate out item KK, so I could recuse myself from that item.
Yeah, if I could just lay the foundation for that real quick, Adam. 8A is something that was noticed for appearance, but in review by board staff, it's an ownership change, but the owner it's going from two owners to one owner. So it wouldn't require appearance. It would qualify for the consent agenda if you choose to add it. 8A, the title of it is Carson Valley Health. And so just to save time, you could add that to the agenda, and I would just make the motion to, if you want to add it to the agenda, that you do. So two ownerships going to one ownership. I think Adam has a relation to one of the owners that is leaving, so I'll turn it to Adam for his.
Yeah, I'll go ahead and recuse myself from 8A as well.
Okay, all right, we'll take care of 8A first then, and so I'll make a motion to add 8A to the consent agenda. Is there a second?
Second.
Second by Mr. Kobo. Any further discussion? I reviewed the application and I agree it could go to the, it's appropriate for the consent agenda. All right, all those in favor? Aye. Any opposed? Okay, that motion passes. So 8A is added to the consent agenda.
Should we have approved 8A separately?
You can do it either way, but Todd will tell you, the path you're going is fine. You could have always you could just approved it too, but Todd will take care of it.
Senior Dag Todd Weiss. Adam, you're recusing yourself from 8A. Is that correct?
Correct.
We just added 8A to the consent agenda?
Yes, but there's another item that Mr. Porath is recusing himself, so we could lump those two together.
What was the
Yeah.
other one? Sorry, KK?
For KK.
Or KK.
Okay, so Jay Jacobo, I move that we approve consent agenda items for KK along with 8A.
Okay, second by Mr. Tomaso. So motion by Mr. Kobo, second by Mr. Tomaso. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes, and then we have the remainder of our consent agenda.
I move that we approve the remainder of the consent agenda.
Okay, motion by Mr. Kobo, second by Ms. Carr. Any further discussion? Okay, all those in favor? Aye. Any opposed? Okay, that motion carries. All right, the consent agenda has now been approved. And we will move now to our regular agenda. Okay, we'll go with agenda item 5C and 5D. 5C is for Renowned Pharmacy, and then 5D is for Oliver Swafford. So if we could have representatives please come forward.
Madam President, I'd also like to recuse myself from this item due to my employment at Renown.
Okay, we have noted that for the record. Thank you, Mrs. Borat. All right, hi, good morning. Good morning. If I could have each of you state your full name and titles for the record.
Good morning, Madam President. My name is Marie Ellerton. I'm an attorney with Hall Prangle in Las Vegas, and I'm here representing the county.
Great, thank you.
Good morning, everyone. My name is Isra Mahmood. I am the pharmacy director on the outpatient side for Renown Health.
What was your last name again?
Mahmood, Mahmood.
Thank you.
Bill Stilling representing Oliver Swafford.
I'm Oliver Swafford. At the time, I was the PIC of the location at Renowned Pharmacy, currently a PIC at CVS Health.
Thank you. I'm going to swear in those of you who are not attorneys, so for our pharmacists. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes, I do.
Thank you. All right, Mr. Cant.
Greg Camp for the record, prosecuting this matter on behalf of the state. For the record, these are case numbers 25-139 PHN and 25-139 RPHN. Respondents Renowned Pharmacy, pharmacy license number PH 04283, and Oliver Swafford, registered pharmacist, registration number 17452. The charging document appears beginning on page 4004 of the board book. Both respondents, separately represented by counsel, are willing to enter into a stipulated settlement resolving the matter in lieu of filing an answer and notice of defense. So the stipulated settlement document with respondent Renowned Pharmacy begins on page 4014 of the board book. The stipulated settlement with regard to respondent Swafford begins on page 4030 of the board book. So I'll take you through both of them, and I'll leave it up to you whether you want to consider them both together or separately. But the charges stem from respondent Swafford's erroneously dispensing the wrong prescription to a minor patient, resulting in patient harm, and also failing to provide medication counseling to the father of the minor patient. And then, of course, as the pharmacy owner, respondent Renown is also responsible for those incidences. So what we are proposing by way of stipulated discipline with regard to respondent Renowned Pharmacy, there would be payment of a $10,000 fine and payment of $1,000 to partially reimburse the board for recoverable attorney's fees and costs. Both of those payments would be due and payable by June 1st of this year. With regard to respondent Swafford, the respondent would be placed on probation for a period of 1 year, would pay a fine of $2,000, pay $500 to partially reimburse the board for recoverable attorney's fees and costs. Once again, both those payments are due by June 1st of this year. And respondent complies with all applicable laws, and then upon successful completion of probation, his certificate of registration will be fully restored. So these are the stipulations we're bringing to you for your consideration and possible approval this morning.
Thank you, Mr. Cant. I'll start with Ms. Ellerton. Did you want to add any additional comments, remarks, or?
Do not.
All right, Mr. Silly?
We appreciate Mr. Cant's willingness to work towards a settlement, and we think this is fair. Ask the board to approve it.
Right. I do have a question for Mr. Swafford, just based on the error in terms of, if you could explain just the circumstances that led to the error.
So working in the pharmacy, we dealt with patients being discharged from the hospital. I felt like I was the last thing standing between him and the door. I was rushed. I felt like we had a missing prescription. One was filled at a different time than the other. 2 meds sent at different times and bagged in different locations. I couldn't find a prescription for prednisone. I searched throughout the pharmacy, looking in all possible areas, and I couldn't find it. I was rushing and felt pressured to help the patient get out of the hospital. There was a prescription I had located that I thought was the correct prescription. Had I had taken the time to inspect that more carefully rather than just look at the name, we wouldn't be here today.
Thank you for that explanation. And then for Renown, if you could just provide a comment in terms of, have you made any changes, or was that a singular incident, or how do you ensure that these types of errors are prevented in the future?
As any error rises, we have to take the steps forward to mitigate this from happening in the future. It is possible that these errors would happen in a fast-paced day, but it is our responsibility to imply policies and procedures to prevent that from happening and safeguard our patients and our own providers and pharmacists. After that incident, we did move forward with a few changes. One of them was we have now a policy specific for barcode scanning and the importance of barcode scanning. That policy focuses on barcode scanning in the outpatient pharmacy specifically, and it covers every single step for prescription filling, from typing the prescription to filling the prescription to all the way where the prescription makes it to patient's hand. There are multiple barcodes scanning throughout the process, and the policy covers that. Second thing that we went ahead and we did is We changed a little bit we implemented a new field in the barcode scanning when the pharmacist is prompt to skip barcode scanning. There is no more drop-down menu for them to quickly choose from. Now we have added multiple steps where the pharmacist has to stop and document 3 comments, the reasoning for skipping the barcode scanning, which will force the end users to slow down and think about why am I skipping that. This will then lead to the third implementations that we did, which we implemented a dashboard metrics that is visible to all pharmacy end users and all leadership. That captures any barcode scanning override that happens. The report refreshes per minute. It goes down to end users level and prescription levels. This one is then monitored on daily basis. And as we see any rise in barcode scanning in any of our locations, this one then looked into, and it is communicated with site leaders for these pharmacies and the end users who did the barcode scan. So we have a very, very strict oversight now to barcode scan.
Good, I'm glad to hear that. And then the barcode scanning, you mentioned there's multiple times that happens. And are one of those instances to confirm and validate the patient that you have the correct patient?
So the first barcode scanning event that happens is to verify that the label that is printed actually matches the stock bottle that is being grabbed to fill the medication. Second barcode scanning is actually utilized when the pharmacist is verifying that the product inside the vial is the truly product that was filled. The very last barcode scanning that happens is at the point of sale at the register, where we are verifying we are selling the correct vial to the correct patients. And that barcode scanning matches the patient's demographic info.
And then is there a mechanism in place to ensure the counseling takes place as well?
Yes, so counseling is mandatory for all new prescriptions in the system. It will not be sold unless the counseling question is answered. Counseling must be offered by the pharmacist, not the technicians. And the patient have to move to the consultation station before they can actually hold their medications in hand. If they would like to deny later on, they can deny the consultation to the pharmacist themselves.
All right, very good. Thank you for answering my questions. Board members, I don't have any additional questions and I'm comfortable with the stipulations as presented. Any additional questions, board members?
None for me, Madam President. I agree, and I would move that we accept the proposed stipulation for Empower and Mr. Allerton.
For Renowned Pharmacy,
Said Empower.
Renowned Pharmacy and Oliver
Pharmacy,
Slafford.
yes.
Okay.
second.
All right, so we have a motion by Ms. Jacobo, second by Ms. Carr. Any further discussion? Okay, hearing none, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes. Thank you all for your time and appearance today.
Thank you.
Thank you all. Appreciate it.
Right, next, we're going to go to agenda item 5E. That is for Martin Farrell. If Martin Farrell or representatives are here, please come forward.
Lynn Beggs on behalf of Martin Farrell.
Hi, good morning, Ms. Beggs. How are you?
Well, thank you.
Good. Will your client be joining remotely or?
Not today, no.
Okay. Okay, so with that, then I will turn it over to Mr. Cant.
Brett Camp, for the record, prosecuting this matter on behalf of the state. This is case number 25-233 RPHO. Respondent Martin James Farrell, registered pharmacist, registration number 22316. The charging document begins on page 4036 of the board book. This is a reciprocal action based upon discipline taken by the Pennsylvania Board of Pharmacy, and that action begins on page 4046 of the board book. The respondent's license to practice in Pennsylvania has been fully restored. He successfully completed probation in that action, so that reinstatement document is on page 4078 of the board book. And in lieu of filing an answer and notice of defense, the respondent's willing to stipulate to discipline. And we have a proposed stipulation for your consideration this morning, which begins on page 4080 of the board book. By way of brief background, once again, this is reciprocal action taken in response to an action taken by the Pennsylvania State Board of Pharmacy last year. It's stemming from the respondents admitting to altering certificates of analysis and misrepresenting to US FDA inspectors that the levels of the items were within acceptable ranges. And so once again, the Pennsylvania Board of Pharmacy entered a final order and imposed discipline on respondent. However, on February 4th of this year, they terminated the respondent's probation and returned his Pennsylvania license to unrestricted status. So in order to resolve this matter as to his license or his registration here, we're proposing that the respondent be placed on probation for 1 year. He pay a $1,000 fine for the violations, complies with all applicable laws, and upon successful completion of that 1 year probation, his Nevada registration will be fully restored.
Ms. Beggs, any additional remarks?
Just briefly, Madam President, we would ask the board to accept the settlement as presented to the board today. Mr. Farrell is not currently working as a pharmacist. His intent is to return to the practice of pharmacy eventually. I would say that Mr. Farrell has been diligent in timely reporting the Pennsylvania action to all his other licensing, the states in which he holds licenses, including Michigan, Texas, Kansas, and Arizona. Michigan, Texas, and Kansas have already taken their action, and he has reported those properly to the board. So he's trying to take care of this, trying to be diligent to take care of everything before contemplating a return back to pharmacy. So we would ask the board to accept the settlement as proposed today.
Thank you. And you answered part of my question. If he was working somewhere, and it sounds like he's not currently working, but he may have plans to work in Nevada, is that possibly?
Not necessarily in Nevada. I think he does not reside in Nevada, so he does reside, I believe, in Pennsylvania. So I think right now his plans are a little bit up in the air, but I don't necessarily think that his plans include practice in Nevada, but does wish to keep that registration and that license active.
Great, thank you. Board members, any additional questions?
I do have a question, Adam Porth, for the record. Do we know, did any of the, I guess,
Horses?
adulterated product, did it end up in Nevada at all? Do we know?
No, I don't believe so. It was a Pennsylvania focused order, and this action is solely reciprocal based on the Pennsylvania action.
I don't have any additional questions, and I feel comfortable with the stipulation as presented.
I would agree, Madam President. I would move that we approve the stipulation in order as presented by board staff for Martin Farrell.
Second.
Okay, we have a motion by Mr. Porath, a second by Ms. Jacobo. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Aye. Any opposed? That motion passes. All right, thank you. Right, next, we're going to move on to agenda item 5F and 5G for CVS Pharmacy number 8792 and Joshua Lee.
Madam President, I'd like to recuse myself from this matter due to my former employment with CVS at the time of the allegations.
Okay, we'll note that for the record, Ms. Jacobo, thank you. And then do we have, Mr. Convery, are you here representing both CVS and Joshua Lee?
Not representing CVS. I'm here as representative of
Oh,
CVS.
sorry.
Mr. Lee, though, is no longer employed. I have not ever had any contact with him. I believe Mr. Kant, if he reached a settlement, would have done so directly.
Oh, right, here he is. Okay, great. And thank you for that clarification.
Of course.
All right, so if I could have you both state your full name and titles for the record.
My name is Joshua Lee. I'm a former staff pharmacist at CVS, store number 8792. Currently a clinical pharmacist with Reno Sparks Travel Clinic.
Great, thank you.
Good morning, Ms. Park. Brian Convery, I'm a senior legal counsel for CVS Health. I'm here as a representative of CVS 8792.
Very good. I'm going to swear you both in at the same time. Just need a verbal affirmation from each. Do you swear that the testimony that you're about to provide will be both truthful and complete? Thank you. And I will turn it over to Mr. Cant.
Rick Camp, for the record, prosecuting this matter on behalf of the state. These are case numbers 25-247 PHN and 25-247 RPHN. Respondents, CVS Pharmacy 8792, pharmacy license PH 00637, and Joshua Lee, registered pharmacist, registration number 24163. The charging document begins on page 4087 of the board book. We do have stipulated settlements negotiated separately with each of the respondents that we're presenting for your consideration. This morning, the stipulation with respondent CVS Pharmacy begins on page 4096 of the board book, and the stipulation with respondent Lee begins on page 4111 of the board book. So by way of brief background, there was an intern pharmacist at the pharmacy who, not a named respondent, but was acting under the direct and immediate supervision of respondent Lee. That intern pharmacist erroneously dispensed a prescription. Respondent Lee is responsible, as is the pharmacy owner, CVS Pharmacy 8792. So in order to resolve the matter, in lieu of filing an answer and notice of defense, respondent CVS Pharmacy is willing to stipulate the following penalties: payment of a $2,000 fine and $1,000 to partially reimburse the board for recoverable attorney's fees and costs, both due and payable by June 1st of this year. And respondent Lee is willing to stipulate to payment of a $1,000 fine and $500 in to partially reimburse the board for recoverable attorney's fees and costs, once again, both due and payable by June 1st of this year. So these are the stipulated settlements we're presenting for your consideration today. Thank you.
Great. I'll start with CVS Pharmacy. So Mr. Convery, do you have any additional remarks?
No, as always, I thank Mr. Cant for his courtesies. I'm happy to answer any questions the board may have, but otherwise I would ask that the board accept the stipulation or the settlement as discussed.
Great. And then the same question goes for you, Mr. Lee. Any additional comments or?
Additional comments, accept the stipulations.
Okay, great. So I do have a question, and my question is for you, Mr. Lee, similar to before. Can you give us, or can you explain the circumstances that led to this error?
Well, my intern pharmacist, my intern, he had been with CVS company for a while, so I trusted him doing the clerical work up front, dispensing medications up front, and he was only an earshot from me, so I could hear if the conversation he would have with patients. And I don't know how he bypassed the systems, because every prescription requires you to scan them individually. However, another patient's prescription got into the patient's bag. So I had this conversation with him too, and asked him, he didn't know how it happened, and I wasn't there to see it individually.
Just for my understanding, it was a mix-up. There were more than one medications, but the medications, they were verified. They were just to the wrong patient.
Yes, they were completely verified. The last step was just handing it to the patient after checking them out at the register. Yeah, I don't know how he got passed through the system, giving it to the patient.
And does the system allow overrides for that, or?
I believe so. It stops you, if you scan the wrong medication.
And that didn't stop him in that case.
Yeah, it didn't stop him. So what I'm guessing is he might have just accidentally just bypass the whole system, just put it in the bag.
Ms. Park, what we think happened by process of elimination, because I believe we provided the video to the board, and you can't see from the angle. What we think happened was the prescriptions are each individually bagged. And we think that, again, that he grabbed the bag and the second prescription in a separate bag was grabbed at the same time. So as he picked up the bags, he scanned the correct bag for that patient, but the second bag was behind in the hand, and he handed
Both of them.
both of them to the patient. So the system never got bypassed. The trazodone was never scanned. It was never shown as scanned, but the correct drug that the patient was supposed to get did get scanned. It went through POS and was handed to the patient.
Yeah, that's what I'm trying to say. Not that he bypassed the whole system, but like, yeah.
All right, thank you. Just, it's helpful to know, to see if there's anything we can do to kind of prevent these things in the future. I don't have any additional questions, board members. Any additional questions?
I don't. Adam Porth, for the record, I move that we approve the stipulation agreement for CVS Pharmacy 8792 and Joshua Lee as presented by board staff.
Second.
Okay, we have a motion by Mr. Porath, a second by Ms. Carr. Any further discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed? That motion passes. All right, well, thank you both for your time today.
Thank you.
All right, we will go to our next agenda item, which is 5U and 5V. I was just wondering if I should give Mr. Convery a break, but are you okay coming back? All right.
Sure.
So CVS 9586 and Mark Pardini.
Still warm.
Can I echo my recusal, Madam President?
Yes, we'll note for the record that Ms. Jacobo has recused herself from this matter. Okay, and then Mr. Convery, you're still sworn in from earlier. And then Mr. Pardini, is that you? Okay. Just wanted to confirm if you could state your full name.
It's Mark Pardini.
I'm going to swear you in. Do you swear that the testimony that you're about to provide will be both truthful and complete? Thank you. All right, Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. This matter begins on page 4427 of the board book. This is items number 5U and 5V. It is for case number 25-350-PH and case number 25-350-RPH-N. This is for respondent CVS Pharmacy number 9586, certificate number PH01821, and Mark Pardini, certificate of registration number 08849. The accusation, which can be found on page 4427 of the board book, involves a misfill where a pharmaceutical technician inadvertently filled a prescription for lorazepam, which is commonly prescribed for anxiety, that contained at least some tablets of Cytomel, which is commonly prescribed for hypothyroidism. RPH Pardini was responsible for checking the prescription and failed to notice the different tablets. The patient went to urgent care for excessive sweating, anxiety, shakiness, and loss of appetite. In the accusation, we charged Mr. Pardini with unprofessional conduct for errors in dispensing, and CVS was charged with pharmacy and pharmacy owner responsibility. We've got two stipulations for this case. The first one is with CVS, which can be found on page 4438 of your board books. The terms are a $1,000 fine and $500 fees and costs due within 30 days of the date of the stipulation. The stipulation with Mr. Pardini can be found on page 4455 of the board books. And the terms for that are also a $1,000 fine and $500 fees and costs due within 30 days of the date of this stipulation. As such, we present this stipulation to the board today for approval with an effective date of today, April 15th, 2026.
Okay, I'll start with Mr. Convery if you wanted to add any additional comments.
I'm always happy to answer any questions the board may have. I thank Ms. Tucker for her cooperation, for her courtesies, and I would ask that the board accept and approve this stipulation.
And Mr. Pardini, same for you. Did you want to add any additional comments? I do have some questions. Mr. Pardini, in this case, when you verified the prescription for the lorazepam, could you tell us about your verification process?
For the final verification, pharmacist will look at.
Could you turn your microphone on or is your microphone?
I'm not sure it is. Just move it a little bit closer. Can we get him a water too? Just take your time.
As I was stating, when you do your final verification on the prescriptions, the system will allow an image of those, of that medication that you look at. And in the field, I had failed to see a discrepancy of tablets, one being the lorazepam and the other medication I had missed. And I had presumed just from the look of the medications, they were white in color. The tablets were similar in size, but one of those tablets was a little thicker. And I did not pick that up.
Okay, so your final verification was an image of the tablets.
That's correct.
And then there are two tablets or two different medications mixed in, but the tablets looked somewhat similar.
That's correct.
And then in that verification process, are there other, do you see the stock bottle or do you see the patient's file or what other images do you use that to compare that?
Typically, on the left side of that image, it'll show the actual medication that's being filled. In this case, it was a lorazepam. So it gives you usually the stock bottle or even an image of what to look for. But as I was looking, the image was not real clear. It was blurry, as I recall, and trying to check the whole field that we all try to do. I just missed the different shape of the secondary medication, and I didn't pick it up.
Okay. And then the prescription, was it filled at your physical pharmacy?
It's correct.
Okay. And then did you look at the final product?
I did not physically look at the final product. I had felt my interpretation of that final check through that image that I had. And I didn't realize that there were two different medications just because of the size and shape. They were very identical. And I missed it. Like I said, the image was blurry.
And then when you looked at the image, how long does it take you to look at the image to verify?
I think each person is different. I try to spend per prescription maybe 5 to 10 seconds scanning over the image, trying to make sure there's no discrepancies. I know since that time I've been even more diligent in my checks. You try to make that time and try to make sure you're looking at numbers and any other verifications on the tablet that will help you identify what's in that file.
And then I guess I'm curious too, because with the lorazepam, then your control counts would be off.
If you had done an actual control count on it, that would be correct. There had not been any control counts at that point because there was no, at that time, there was no cause that there was a discrepancy in the number of tablets for the lorazepam. As we went back, I'm sure we did a check on that and had found that there was a discrepancy in the number of lorazepam.
You keep a perpetual inventory of your controlled substances?
I'm sorry, could you repeat that?
You typically could have a perpetual inventory of your controls?
That's done at least once or twice a year. And then whatever is deemed throughout the course of CVS's policies and procedures.
Thank you for answering my questions.
So,
Any additional questions for Mr. Pardini?
Yeah, Adam Porth for the record. So my question is, you mentioned in your testimony that the image was a little bit blurry. In that instance, would you ever in your verification process do a visual inspection of what's in the vial?
most times you're able to find that what you have is proper. But there is a ability to go in there and physically go in and check those prescriptions. I can go in and pull that prescription from a waiting bin and then physically check the medications for verification of what was actually in that vial. Unfortunately, I did not do that that day because I had felt what I had looked at was proper. Certainly, if I had felt there was any indiscrepancies or discrepancies, I should say, I absolutely would have checked. And I have since that time gone in and physically checked medications and made sure that that was what was being filled.
Thank you. Just kind of thinking upstream from the error, do we think that there was a return to stock situation where that Cytomel got added to the lorazepam stock bottle, or how do we think that those pills got intermixed?
It's hard to say. Over my career, I've seen where medications had been placed into a wrong stock bottle. And CVS tries hard to make sure that we do a one-in-one fill where you're filling one prescription always and nothing else is in that area. There's also a chance that two stock bottles are in that same area fill. And when they're filled, they're not placed back in the proper stock bottle. So there's always a couple potential possibilities which could have caused that error. To reiterate, one would have been that the lorazepam had incorrect medication in it, and or two, the stock bottles were in that same area where the tech had filled it, and they were filled in incorrectly.
Mr. Tomaso?
Yes, Mr. Pardini. Did I hear you correctly when you said that since that incident?
I'm sorry, sir, could you?
Did I hear you correctly when you said that since that incident, that the corrective action you took was to just look a little harder at the photograph and study it a little longer? Is that what you said?
For myself, that is actually very true. I have become more diligent in what I've done. I feel that I am being more responsible in making sure if I have any need to check a actual medication, I will, and I have done that to make sure this doesn't happen again. My concern certainly was for that patient. But unfortunately, I learned the hard way that we just need to be more specific on looking at what we have in front of us, and you can't always feel that what you have there is always correct. You have to be more specific, more concise, take a little bit more time and certainly check those fields out.
Sure. I sense, great. But this was a year ago, and I understand that it happened a year ago, but today, what are you doing today? Have you received notice from the pharmacy board that you, as of a couple of weeks ago, you must examine or look at the final product itself?
I'm sorry, I didn't hear the last.
Did you receive a notice from the Board of Pharmacy that you must look at the final product? Have you received that notice?
I had received that notice from the pharmacy, Board of Pharmacy about a month ago that this had occurred, and I had seen the image at that time through my district leader, and we had looked at that, and I realized that, again, and I'm not making any excuses, but the image was blurry, and it was a little bit difficult to make out that image on both those prescriptions. But again, I should have gone to the waiting bin and double check that if I had a question.
And Mr. Tomaso, are you asking about the notice that the board sent out to all pharmacists regarding final?
It was emailed.
Yeah, that was emailed. Okay, I think Mr. Tomaso is referring to the general email from the Board of Pharmacy that talks about final verification or final product verification must take place by a pharmacist. Did you receive that email?
I received that email, and I have read it over a few times and am aware of what the Board of Pharmacy is looking for. And I even had a call from a colleague about that situation. Not that she was aware of my situation, but what we were to do concerning that new email by the Board of Pharmacy. So yes, I in fact have it with me, and I do refer to it, and even more diligent in what I'm doing.
Okay, so you're more diligent. How are you more diligent?
I'm taking more time, as I stated earlier, that I'm looking at the product on that image. I'm scanning it slower. I'm not sure what you're looking for, sir.
So after you received that email from the Board of Pharmacy telling you you must examine the final product, you're saying that you're taking more time looking at the picture. Is that what you just said to me?
I didn't hear your last.
Taking more time looking at the photograph, is that what you're saying?
I'm trying to take more time for each prescription to make sure what I have on my screen, based on the example that I have from the CVS program and what I have in my image, is accurate.
You know what that email said, Mr.
Yes,
Person?
sir, I do.
Said that you have to look at the final product. Do you know what the final product is?
Yes, sir, I do.
What is it?
Final product is looking at the actual final product.
What is it?
Ms. Park, if I may interpose, we're stepping outside of the four corners.
I'm not. I want to know what he thinks the final product is.
Yeah,
Mr. Tomaso is asking the witness to interpret something that came out a month ago, and we're here talking about a case that happened a year ago.
We're talking about corrective action, Counselor.
We are talking.
Corrective action,
No,
he has to look at the
all
final
due
product.
respect, you're asking how he's interpreting an email that came out from board director a month ago, less than a month ago.
I don't think that's
I think there's different paths here, so if Todd can help, recognize your comment, if Todd can help you there's paths that you can take.
Yeah, I mean, there's ways we can ask the witness to describe how he's changed practice since the incident. If we probably shouldn't get too far into interpreting something that recently happened, but and as part of corrective action, asking what have you done differently since this incident, that's totally appropriate. So we just gotta be conscious of that line, and we can't go too far into what's happened recently because it's kind of a different line of inquiry.
And what would be their path if they want to do that? Because we have a stipulation in front of us.
So hopefully my mic is working on.
It's difficult. It is difficult to hear you.
All right, I'll hold it for a second. It'll turn green.
There it goes. Okay, is that better? Sorry, I normally just have a little button I press. So, we got a stipulation in front of us. If the board is interested in getting more in-depth into stuff like what Mr. Tomaso was asking about, the options would be to reject the stipulation and let this go to a hearing. then it'd be more appropriate to get into these kind of, more recent lines of inquiry. But when we're only considering right now the stipulation, we should probably limit it to, what were your immediate corrective actions after the incident. So rejecting the stipulation, going to hearing is always an option. Adjustment of the stipulation, if it's deemed necessary, is always an option. But the full gamut of options are available to the board here.
So, Mr. Tomaso, if I may, I think I know where you're going. So Mr. Pardini, moving forward since then, we know that that was an error that took place in the past, but we want to ensure that it's safe moving forward. So in your practice today, how do you verify prescriptions? Have you made any changes to what you've done since the past?
Since that incident a year ago, I feel I've slowed down. I've been more diligent in looking at the image. If there's a concern on that image, I will go to the actual vial and check it. But you don't have to understand one thing in the practice of pharmacy. When you go to that image, you don't sit there and pour out the whole entire vial. Okay. Most of the time, pharmacists, and this is even with pharmacies that aren't even using the imagery that we use at CVS, they may pour a few into a tray or a few into the cap of the vial, and they say, this is what I've got. So my comment is that, how do we pull a prescription that you have a question on? Okay, should you, and the answer to that is yes, check the whole vial. And we hope the imagery that we're using at CVS is going to be adequate for my situation and what I've done, going back to the original questions that were stated on your email that I have here in front of me. I am doing due diligence to check each prescription, and I am now going to those vials, and I'm not just checking 3 or 4 tablets. I'll take it back and check the whole thing if I have a problem with it. So yes, I've learned from this mistake, and I hope this doesn't happen again. And as I stated earlier, my concern first is with my patient. And whatever the consequences for me, I give myself to the board, and I can tell you that I can only do better, and I apologize to this body.
Thank you for that, Mr. Pardini. And if I heard you correctly, you are, in addition to using the technology that you have available to you, you're looking at the medication in the vials. You're looking at the final product, the prescription medications.
Typically, on most prescriptions that you get at CVS, if it's a product that's counted out, you'll see the whole entire quantity of medication on that image. So if you have 30 tablets or 180 tablets, that image will be contained in front of you.
Right.
And each section of that image, if there's a question that you've had that something looks difficult to ascertain, then you go to the actual prescription on the waiting bin, pull it, and then look at it physically.
Okay, so you look at it physically only when you have a question.
Typically, because the image is such that you can make out the tablets and the information on those tablets.
Okay, and that's how you've handled it since the error took place, as your measure. Right, thank you. Ms. Long, yes.
Thank you, Madam President. Yan Long for the record. For Mr. Pardini, one question for you. In your testimony, you stated that the tablets, the lorazepam and the Cytomel, are white, similar in shape, but the Cytomel is just a little bit thicker, right? They're round tablets. Do you think if the image was clearer, that you would have caught that there were 2 different types of drugs on that tray? Because they do look very similar.
I agree with that. I think if the image was clear, and I think there's ways we can make images clearer, we can hopefully just with CVS, take the image and just kind of sharpen it which will help all of us so we don't have these problems. We can go forward and make sure that what we're doing through the imagery, which is certainly newer in most cases, to help decrease and even stop these errors.
You didn't answer my question. Do you think that if the image was clearer, because they are very similar in shape and size and color, do you think you would have caught it even if the image was clear? Do you think you could have caught that there were two drugs on that tray with the image if it was clearer?
Yes, I would have caught that.
And you would be able to decipher that one was thicker on the 2D image?
Yes, I would have caught that.
I have the image in front.
Yeah, we can't use the image, it's not part of the evidence.
Ms. Long, I will point out that the pills do have different markings on them also. They are the same, similar shape, color, and size, but they also have different markings.
I agree, and I can tell in the image that it was blurry, that I can actually depict that and decipher that they have different markings.
I would just, because you didn't mention the markings were different, that's why I was just.
Oh, okay. I'm just stating that the image is clear enough to me to.
He answered your question.
It's okay.
No,
Adam Porth, can I make a comment?
Of course.
I think I would remind the pharmacists on the board, I mean, when you think about the circumstances of this particular case, we're talking about, for the record, 17 tablets mixed in with a total quantity of 120. I think I would have a hard time if I was doing visual inspection of a vial, looking in there to be able to pick out that there were 17 that were different. Even if I was physically inspecting the vial, I have a hard time believing I'd be able to do that. So, should that have happened? Yes. Would it have prevented the error in this case? I don't know that it would have.
Well, Mr. Forrest, I understand that. I grant him that. I'm not satisfied with the corrective action, that the public is still in danger. He already endangered him one time. He's still going to do it tomorrow because I'm not satisfied with the corrective action. That's where I'm going here with this, not would it happen or wouldn't have happened. And because I don't think they've taken the corrective action, I don't feel that we should just move forward with this step until they take the corrective action.
I have a question for Anna Carr for the record, for CVS. Did CVS issue any course of action or directive regarding the board's recent release that was sent out to all pharmacists in Nevada? Was there any direction that the pharmacists in course of their professional duties should be visually inspecting that product in person, or did they issue that the photo was still sufficient?
We issued I'm not going to say guidance, we did issue a blast, for lack of a better way of putting it. I'm not 100% sure of what that actually said.
I'm glad, Dave Weiss, I'm glad you answered. It's fine. I'm not sure it relates to this particular case. I will remind you that at the last meeting, we had a case where we required certain things from CVS, and we're in that still process of the requirement from the prior misfill that was related, that they had some time to re-educate their staff. And so I think that time period has not come back to us yet.
Thank you.
so this is Helen Park. I do think that this is a prime example of when solely using virtual verification has failed. In this instance too, the image was blurry. I hadn't considered, that images, just even if they're clear, I think they're problematic, but when they're blurry, I think that's just another example that reaffirms that looking at images are not sufficient in order to accurately verify prescriptions. I do think that the tablets, although similar, both being white, and similar shape, but they look different enough that I think, had you looked at them, that's something that could be identifiable. tricky, and I admit that, there's a lot of tablets in that vial, but a lot of times those things stick out when the shapes and sizes look a little different. So I think for Mr. Pardini at that time, he was, following the policies and procedures of CVS. I think what I'm more concerned with is, so with Mr. Pardini, I'm not too concerned with the STIP. I guess I'll start there. I'm more concerned with the stipulation for CVS Pharmacy, as this has been becoming a reoccurring issue over the certainly the last couple of meetings, last couple of years. And so that's the STIP that I have more concerns about. I think Mr. Pardini, he made an error, and an error that was based on his policies and procedures of his current employer at the time.
Yeah, Dave Weiss for the record, just as it relates, if Brian's okay with it, to the stipulation. I think that, I take responsibility for the stipulation. I don't want to speak for Laura, but I'll speak for myself. So all these things were weighed. I think my weighing went back to Adam's weighing, which was, they need to physically check it. There's no issue. Would that have done it? So that's how we ended up charging this case. You have every ability to deny the STIP, and then we will act off of that. I will remind you too that we had the last case where we made requirements of CVS to do certain things that was related to that. And I thought that was a catch area for this particular thing. And the notice, I said at the last meeting, I will provide the notice, but the notice wasn't out. And then you have different testimony today that you're getting in front of you that I didn't have when I was doing it, and you should weigh that too. So that I'm just trying to explain from our perspective, that we're fine with the STIP, but if you deny the STIP, that we will take the appropriate actions that we feel related to the denial. So, and I'm not promoting either one, fine with the STIP going through.
If we just okay this step, we're just saying, okay, the next time it happens, so what? I mean, they're not correcting the mistake. But David, they're not correcting the mistake.
And you should deny the STIP based off of the testimony that you had today, which we don't have, I don't have that testimony because we had the original interview during the evidence. And then I didn't have the ability to talk to him. And you have more data than I had when I did the stipulation. That's what I'm telling you. You already know that. If that's the feeling, and it's the beautiful thing about the board, you'll vote on it and then we'll take the action that is required afterwards. But I think that as far as the virtual verification, they should follow your notice, and it's a work in progress to get that out there. But I'm glad that he had the notice and listened to it. I was concerned that he didn't have the notice. So
Here's the thing, Madam
Yes.
President, look. The notice that went out was to the pharmacist. CVS, if they were going to let them, if they want to take images or photographs, they could do it. We didn't say they couldn't take, we didn't say that the pharmacist couldn't look at the photograph. We never said that. Fine. It's another step for verification. Go ahead and look at the photograph. All we said was, but you also have to look at the darn final product, which is the pill in the bottle and the prescription, everything else. So unless CVS told Mr. Pardini, no, you can't go back and look at that bottle. You gotta do it with just that photograph. They didn't do anything wrong. It's Mr. Pardini. It's on him to look at the bottle. CVS, we don't care if he looks at the photograph. We don't care if CVS takes pictures of everything and hands them to the pharmacist. That's okay. That's a good thing. It's an extra check. But he still has to look at that bottle, and he's saying, no, I'm not looking at the bottle. I'm going to keep looking at that photograph.
So I think
That's what I'm upset about.
Mark, if I may point out, Mr. Pardini and the pharmacy are being charged for actions that occurred on August 21st, 2025.
so.
I recognize that Mr. Tomaso is saying that what may be happening now, he may not be in agreement with. But Mr. Pardini is being charged with something he did or did not do on such and such a date almost a year ago.
I understand what you're saying. And so I think,
For the record, the notice went out the third, so
Right.
I just want to make the record.
so in terms of Mr. Pardini, Mr. Tomaso, I think at that time, he did what his company's policies and procedures, where it was consistent with his company's policies and procedures. Were his policies and procedures correct or safe or accurate? I think that's, you know, that's a separate discussion, but at that time, he was following his company's policies and procedures. And when following it, he made an error. And we know that virtual verification alone has led to a number of errors. So I think asking about, you know, what he's done then and what he's since done then to correct it, Mr. Pardini has answered that. Now moving forward, I know that your concern is his safety moving forward, but I think it is somewhat of a separate matter with the recent notification, not related to the stipulation.
Thank you. I understand,
Well-
I understand what you're saying.
Yeah, and we'll see what our DAG says.
Senior DAG Todd Weiss. So, you know, if the board were to reject the stipulation and we go to a hearing, it's important to remember that we would have to evaluate the alleged conduct on the basis of what the standard was at the time of the incident, not what it is now. At the same time, I would imagine that failure to make proper corrective action with the current standards could also be considered an aggravating factor when it comes to discipline if there was conviction. So that's not to say it's totally irrelevant, but it's irrelevant for the purposes of only considering the stipulation. So if that is a matter that the board is interested in going into more in depth with, then my recommendation is to reject the stipulation and let this go to a hearing.
Getting back to
Mhm.
what you're telling me, Madam President. Okay, we're looking back in August 25th, and after that, he continued to do it because this notice, like Mr. Weiss said, didn't go out to the pharmacist until a couple of weeks ago, or third. Okay, so, all right, I understand that. But I want this board to understand that, okay, we'll accept that step. I'm not gonna fight it. I'll accept it because of you and the general counsels had to say that this, and what Adam had to say to happen back then. Okay, so I'll accept that step. But I want this board to understand the general public is still in danger because he's still not looking at the final product today, although we can't talk about today. But he's been noticed. So if he's going to appear before, if he continues on that path, pharmacists are going to start appearing before us on incidents that happened after that notice went out. And it's not going to be so easy on them as it is on this one step. I just want to make that a matter of record. It's going to be a lot different when they appear before us after the third for doing the same thing.
I agree with you, Mr. Tomaso. I think that messaging from the board has been clear, and so if the pharmacists do not verify the final product consistent with our regs, then I think that's a different issue. Again, I'm okay with Mark Pardini's stipulation. I do have more concerns about the CVS stip because it's been a reoccurring issue with CVS.
Can I ask Todd a question too for your benefit? So you have the ability to accept a stip but modify the terms of it if there's some path that you want to add to that. And then, of course, it has to be agreed on. If it's not, we can go to hearing. But I just want to make sure we're addressing both yours and Mr. Tomaso's. If there's a fix that needs to be put in the stip, that is, Todd can explain that to you. So.
DAG Todd Weiss, certainly, if the majority of the board members are in agreement that some amendment to the stipulation would make it acceptable, then we can have that discussion, let the parties go, take a break, let the parties go back and see if they will agree to that and see if we can do an amended stipulation. If there's no amended terms that would make the stipulation acceptable, then obviously the the choices to decline it and go back into the hearing process.
So for the CVS stipulation, I think based on the reoccurrence of these similar types of virtual verification issues, I would propose that the fine be raised to $5,000.
Anna Carr for the record. I would be in favor of that as well. I was also wondering if something could be added to about having an updated policies and procedures, because my concern is that the pharmacists are still being directed to solely utilize the photo, as opposed to being instructed to check that final product, physically. And so without seeing those policies and procedures, I can't obviously speak to that, but I would like to see those updated and see a copy, because my concern is what the pharmacists are being directed to do.
That's a very good point, and I would agree with that as well.
Dave Weiss for the record. I think, Mr. Tomaso, did you want to add anything else or, okay. So, like, the board staff can't be there filling the prescriptions, right? So that's the challenge. Like, we can't go with Mr. Pardine and be there with him. I do think that they're in the process of changing the policies and procedures, and so they may agree to that if they've already done that, and then that would solve the problem, and then we can talk to him about the fine. I think for Mr. Pardine, I think that just talking to you today will probably change his thoughts on the practice, and I think that it's pharmacists understanding what you're saying about checking. So that's why we sent the notice out, so that they got it. So we can talk to them about that if that's what you want. But I can't, to Mr. Tomaso's point, I hope Mr. Pardine listens to what you're saying and changes his practice. But I can't put that in a stipulation, right? Like, that's the issue. So
I understand that.
Yeah.
It's clear to me what you're saying, that, yeah, the general public's still in danger. Well, nothing I could do about it, or this board could do about it, because it happened on August 25th, and they still don't understand the situation. And getting back to but talking about CVS, this board, Anna, we don't care if CVS continues to have a policy where they ask the pharmacist to look at the photos. That's fine. It's an extra check. We're not against that. It's just if they tell them, and you can't, you're not allowed to look at the final product. That's the difference. But they could keep taking their pictures. That's how I feel. But I get what you're saying. You want to make sure that they're not telling them policy is that, and this is how you're going to do it, not this final product, right? Contradicting our directive to all the pharmacists in the state of Nevada.
Yes.
Right?
Yeah, I just want to make sure that.
Right. Okay. Yeah, agree.
Correct.
And I agree with what you and Helen would like it added to the step.
Any thoughts, Mr. Borath?
Yeah, I think that, as we've talked about a lot, I think that the stipulation against Mr. Pardini is appropriate based on what happened there. I just want to make sure that you understand, Mr. Pardini, that moving forward, that the opinion of this board is that solely looking at the image is not final product verification.
I would argue too that it's not the opinion of the board, it's within the law. That's what the law states. That it must.
different ways to say it, but it's the law, right? Yeah.
Yeah, so having said that, I would be supportive of the stipulation as written by board staff for Mr. Pardini. I'm not opposed if the majority thinks that we need to see more within the CVS stipulation to be happy with that. Maybe pending what's going on with the policy and procedure change. I'd be okay with waiting to see that before we make a decision on that.
Great. And then for Ms. Freitas, if you have any comments, if not, that's okay. Just wanted to give you an opportunity to chime in if you'd like.
She's online.
Yeah, just echoing everybody else's statements. I do agree with the stip for Mr. Pardini. I'm not opposed to raising the fine for CVS. I just think it is something that we talked about last time where they are updating policies and procedures already? Did we not already ask them to update us on that from the last stipulation?
Dave Weiss for the record. There was requirements that they would set policies and procedures not to solely drive the pharmacist to check the verification. I don't have the language in front of me, but I know that it was addressed at the last board meeting and they had 60 days to do that. So we have not checked in on that yet.
April 30th was the deadline for that.
Okay, yes, I'm not opposed being it multiple occurrences already that the fine is increased.
Great. All right. So procedurally then what we'll do is we'll move forward with Mark Pardini's stipulation. I think we're ready to do that. And then Mr. Convery, you have feedback from the board, and then that afterwards we'll take a break where you could.
You have feedback from, I'm not quite sure what you're asking me or you're asking of us. So I just would need some clarification on what that may be or what actual final.
Can provide that. It may be, Todd can tell us, it may be best just to take a break and then we'll come back and do both of them, but it's up to Todd to advise you.
There's no motion, right? There's
no motion at this.
That's why I'm a little confused about what you're asking of me at this moment.
I understand it.
No, I agree. It sounds like the board members are in favor of an increased fine, but there was also the mention of, forcing a change of policy. And then we have the previous matter that also required a policy change, and there's still a few weeks left for that to be implemented. So, I wouldn't really advise, again, we don't want to cover too much of the same ground that we covered in the last one for sake of not having contradictory terms. We gave them till April 30th in the previous matter. So we should honor that deadline and not, force a sooner thing with this stipulation. So I would advise that if increased fine is in favor, that's fine. But I wouldn't strongly recommend the stipulate, including a policy change requirement in the stipulation. Another option the board could have with CVS is they could reject the stipulation at this time, see what comes forth by the April 30th deadline from the previous matter. And we can always consider a settlement stipulation down the road after the board's had a chance to look at their new policy. And, board's satisfied with that, they may be in favor of a stipulation for CVS at that time. So that's another option we have, in addition to seeing if we want to just raise the fine and have this settled today.
Adam Porth for the record. So Todd, can you clarify in that case, procedurally, would we just be continuing the case against CVS until next board meeting so that we would have a chance to review those policy and procedure changes, or will we be rejecting the stipulation?
Procedurally, you'd be rejecting the stipulation. It would theoretically go back into the hearing process, but that doesn't preclude CVS and our council from agreeing to a new stipulation. It'd be down the road. So the board have a chance to review the April 30th, whatever comes out on April 30th for the change policies. And that may give the board a better idea of what's been done. And that, what I'm trying to say is there's no prohibition against doing a different settlement down the road if this stipulation is rejected today. If the parties may not agree to that, we may have to go to a hearing. That'll be between them, but we can certainly reject the stipulation now, and then hopefully they will reconsider a different stipulation after April 30th.
Okay, I think I know what we need to do.
Is there any value in me reading the order or the agreed stip from the before so that we can
That would be helpful.
Yeah, that would be helpful.
I have it, it's paraphrased, and Brian can correct me, but I'm sure I have the essence of it. CVS Corporation Management shall provide the board staff with copies of written policies, procedures, training manuals, and other materials, if any, that confirm or collaborate its contention that all CVS pharmacists in Nevada have the discretion to perform visual inspections of the physical or manual manipulation of the prescription drug products before dispensing them to their patients. If no such policies or procedures or training manuals or materials exist, CVS management shall provide a written statement to that effect by April 30th.
You say, when you say discretion, you're saying if they want to, they could look at it? Because that's not what we put out. We said they have to. They don't have discretion. They have to.
Yeah, again, that's the agreed upon stipulation terms from the last board meeting related to a CVS case.
Well, you could give your simplification, and let me tell you my think way we should go. I think we should go ahead and do Mr. Perdini. We all agree on that. There's no argument there. And board member Anna didn't say that she wanted to change anything that CVS was doing. She just wanted to see what they were doing. That's all she asked. Just, is my right, Anna, that you just wanted to see what their policies and procedures are now?
Correct. I'm just concerned that there's a push to bypass that physical check and to solely rely on the imaging. That's my concern.
But we're gonna get that answer. You are gonna get to see it. You don't have to put it in the step because you are gonna get to see it on April 30th. So we are gonna see it. So we don't need that in the step. So what we're down to is we could go ahead, since we agree on Mr. Perdini's, we could do Mr. Perdini's step. And the only thing that this board has to discuss at this point, do we want to increase the fine to 5,000 for CVS, or do we want to just wait until after the 30th and move after that date? Now we know what we're going to do from that date forward. That's all the board has to discuss.
We need a minute to talk to CVS about the fine.
Yeah.
Can I ask a final question, please? If I could, to the board. I'm a little confused based on this email that was given to all of us from the Board of Pharmacy. It states a physical check. So now we're looking at a visual check that we use at CVS. So is this being superseded back to a physical check? Or is it only if there is a question that we have of a prescription that we need to do a physical check?
The law states a physical check. We can talk to you after this meeting about that.
Well, I'd like to make a motion that we just accept the step as it pertains to Mr. Perdini.
We have a motion by Mr. Tomaso. Do we have a second?
Second.
Second by Mr. Porath. Any further discussion? Okay, all those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes. And then for the.
Just for the
CVS.
record, sorry, just for the record, Crystal, did you vote in favor of it or opposed to it?
In favor of the
Thank you.
approval for the stipulation, Mr. Pardini.
You're just a little delayed. I just want to make sure we have the record correct.
It's up to this board. Do we want to push the 2,000 to 5,000 on this particular one? Or do we want to just approve it as it is right now and wait till we see what they have to say on the 30th?
I think my preference would be to increase the fine to 5,000 and we could keep it at that and keep it separate from the 30th. We know that the 30th is coming, but I don't think we need to wait for that. I think we could move forward if CVS Pharmacy is agreeable to the increase in fines. So we could take a break to discuss that. All right, so we'll take a quick break. Thank you. Okay, so we're continuing our discussion for CVS number 9586.
Just for the record, if we can confirm that Crystal's online and can hear.
I'm here.
Thank you.
Great, thank you. All right, Mr. Convery. Did you have an opportunity to discuss changes to the stipulation?
With the understanding that the only change is the change in dollar value of the fine, or are we changing costs too?
It's the only change being the dollar cost to the fine.
No other changes anywhere else in the stipulation?
No other changes to the.
We are amenable to that change.
All right, then with that, happy to entertain a motion.
Make a motion that we approve the step regarding CVS, with the exception that the change the fine from 2,000 to 5,000.
It's 1,000 to 5,000.
1,000, from 1,000 to 5,000.
All right, we have a motion. Do we have a second?
And a car second.
Okay, so we have a motion by Mr. Tomaso, second by Ms. Carr. Any further discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes. Thank you. All right, next we'll call for agenda item 5J for Patrick Awa.
Good morning.
All right, hi, good morning.
Good morning.
Hey, Mr. Awa, will anyone else be joining you today?
Not just myself.
Okay, then for the record, could you please state your full name?
Patrick Awa.
Okay, I'm going to swear you in. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Okay, great. Thank you so much. All right, with that, I'll turn it over to Mr. Zanino.
You could, but we don't have. So we're fine. We're going to find him right now.
Okay.
He's here. There, Skylar's got him. He's on pre-retirement mode.
Mr. Awa, we just need a few minutes and we'll get started.
Okay.
All right, Mr. Zanino, Mr. Awa has been sworn in.
Thank you, Madam President. For the record, Greg Zanino, the board prosecutor. In this case, this is listed as is item number 5J on your agenda. The notice of intended action and accusation begins at page 4162 of your board book. And the so the allegations, you know, in a nutshell, are that Dr. Awa failed to document counseling. So that I think in this case, the evidence was equivocal as to whether the patient had or had not been offered counseling. But it's clear that there was no documentation concerning the counseling and whether that had or had not been offered or provided to the patient, or in this case, the patient's spouse. I would note in this case that Dr. Awa has submitted an answer with quite a good amount of supporting material, kind of in support of his answer, and that appears that it begins at page 4175 of your board book, and it goes through page 4188 of your board book. I think it demonstrates that Dr. Awa takes this matter seriously, and he's serious about kind of correcting his behavior going forward. The stipulation in this case begins at page 4189 of your board book, and I will cover that. So, and I would emphasize that the stipulation pertains to Dr. Awa only. It doesn't concern Rayleigh's at this point. We're still talking to Rayleigh's. The key provisions in this stipulation begin at paragraph 6. Respondent does not contest the allegations stated in the accusations on file herein, and he admits that evidence. exists and that the board staff prosecuting this case could present such evidence in a hearing to establish a factual basis for the violation alleged against him in count 2, specifically between 2022 and 2025. Respondent was employed by Rayleigh's Pharmacy 123 in Yerington. He processed and filled a new prescription for patient RS for antibiotic eardrops. He dispensed the drug to the patient's wife, who later complained that he had not offered her counseling. He didn't recall whether there was any counseling offered or provided. However, he admittedly did not make a record of whether the counseling had or had not been offered. To resolve this case, respondent has agreed to pay a fine of $750, which is actually comes right off of the schedule of fines that appears in the NAC. He has also agreed to pay the costs of prosecution and investigation in the amount of $500. And he has agreed that on or before May 31st, 2026, he will complete 2 credit hours of continuing education on the topic of pharmacy record keeping, and he will supply proof of that. Dr. Awa, I believe, understands that the stipulation will be reported to the National Practitioner Data Bank in accordance with federal law. And that completes my presentation, Madam President.
Great. Thank you, Mr. Zunino. Mr. Awa, did you want to add any additional comments for the board? Was that a correct recitation of what happened?
Yes. And prior to, I'd just like to comment that prior to the incident particularly happening, when I first moved to Yerington and I was working with Rayleigh's, the system, they were doing that documentation on a piece of paper. You handwrite the documenting counseling on handwriting. So they were, McKesson changed the system and they were then transitioning to that electronic system. I'd worked in several states and with several companies prior to moving to Yerington and working with Rayleigh's. So when I had to use a new dispensing system, I have to put in a lot of effort to study the electronic system to ensure that it could help me to be able to comply with state and federal regulations. Apparently, McKesson at one point felt that I was reading too much into something that might be hidden secrets in the dispensing system and blocked the Rayleigh's 123, blocked us from being able to access help on the McKesson system. That was around summer 2023. That's about a year prior to this incident. So from that point onward, that particular store was never able to click on the help button to be able to read on anything or to learn more on how to do anything on that system. So our hands were tied from then. I did not tell Rayleigh's at that point because when I noticed that only that particular store was blocked and the message we were informed that it was because we were reading too much, I felt that McKesson could not have done that without telling Rayleigh's if they blocked only one of the Rayleigh's store. So I just had to struggle and do everything without being able to learn anything. But I did understand that we failed to do manual annotations alongside with the automatic electronic signature captures on that prescription.
So just make sure I understand you correctly. You're saying that the Rayleigh system didn't allow you to document the counseling?
No, it did.
It did. Okay.
There was space for a comment, but it was taking automatic electronic signatures to indicate that the counseling was offered. Just a comment was not added to it. So there is electronic capture that counseling was offered, but there was no comment added to it.
All right, thank you. Are you in agreement with the terms of the stipulation? Do you agree with the stipulation?
Yes.
Board members, any questions for Mr. Awa?
For the record, I don't have any. I would move that we approve the stipulation order for Patrick Awa as outlined by board staff.
Second. Okay, we have a motion by Mr. Porath, a second by Mr. Kobo. Any further discussion? Okay, hearing none, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes. All right, your stipulation has been approved today. We appreciate your appearance.
Thank you.
Okay, thank you. All right, we'll move to our next agenda item, which will be 5Q for Michael Stelmacher. So if we have Michael Stelmacher or representatives, if you could please come forward.
Yes, hi. This is Anthony Cortez, counsel for Michael Stelmacher.
Okay, great. And is that Mr. Michael Stelmacher with you as well? Or on the screen, it
Correct.
looks like? Okay,
Yes, on the screen.
okay, great. So Mr. Stelmacher, if you could state your full name for the record. Oh, I think we are having some sound issues. We can't hear you.
We've unmuted you, Mr. Stelmacher. Can you just make sure on your side you've unmuted yourself with your device?
No, we
No.
still can't hear you.
It's trying to reconnect. Can you try now? So no. Mr. Stelmacher, you can leave your camera on. I can give you a phone number that you can dial in with your phone if you want to get a pen and a piece of paper there. No.
Oh.
I think it's your particular internet, sir. So get a pen and a piece of paper and I'll give you a phone number and you can dial in on, do you have a cell phone with you?
Can you hear me now?
Yes.
Yes.
Okay,
Yeah,
you can hear
great.
me? Okay, good.
Yes, and then if you could please state your full name for the record.
Michael Stelmacher, PAC.
Okay, I'm going to swear you in. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Great, thank you so much. Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. This matter can be found on page 4359 of the board book. This is item number 5Q. Mr. Michael Stelmacher, case number 24-364-CS-S. Respondent Michael Stelmacher's certificate of registration number is CS 21884. The allegations contained in the accusation that begins on page 4359 allege that Mr. Stelmacher, as medical director of the med spa Premier Beauty, he permitted the unlicensed owner and employee to have independent access to dangerous drugs and to access and administer those drugs without his supervision. Additionally, during the investigation, board investigators found that there were a number of foreign non-FDA approved drugs at the facility. In the accusation, we charged Mr. Stelmacher with 5 different counts. The first one was a failure to maintain security of dangerous drugs. Count 2 was a violation of state law for unlawful possession and administration of dangerous drugs. Count 3 was a violation of federal and state law for using drugs not approved in the US. Count 4 was unlawful possession and administration of dangerous drugs. And count 5 was commission of acts that render registration inconsistent with the public interest. We do have his stipulation with Mr. Stelmacher, which can be found on page 4371 of the board book. In that stipulation, respondent agrees to pay an administrative fine of $2,500 and $1,000 fees and costs, all payable by June 30th, 2026. As such, we present this stipulation to the board today for approval with an effective date of today, April 15th, 2026.
And I'll turn it over to Counselor Cortez for any additional comments or remarks.
Thank you, Madam President. Well, first, I want to thank the board for their time today, and then also Ms. Tucker for significant efforts in reaching a resolution. I guess I would point out that in addition to this action against Mr. Stellmacher, there was an additional action initiated against Premier Beauty and the RN who actually administered the alleged substances. Mr. Stellmacher, as medical director, had no knowledge of any of this occurring or even that those drugs were on site. It was not part of his contractual obligations as medical director for this spa, which was specifically for aesthetic oversight, esthetician type oversight. Nevertheless, as medical director, Mr. Stellmacher does recognize the importance of ensuring the safety at whatever sites or facilities he serves as medical director, and has taken the appropriate measures to not only guarantee and verify that nothing like this has happened again since this time at this particular spa, but to guarantee that to the extent he has any additional clients in this area, would be sure to do the same with those clients. And I thank the board again.
Great, thank you. Mr. Stellmacher, are you still the medical director there at Premier?
Officially, I'm still the medical director. However, they're not doing anything that really requires a medical director anymore. She's kind of pulled back on the things she does. She doesn't really do advanced aesthetics things.
When you say she, who are you referring to?
When I say she,
Who
oh,
are you?
Betty Dare. Betty Dare,
Okay.
the
and
the owner
she-
of Premier Beauty.
Okay. So I am concerned in this case that we've had a number of issues with med spas, and then in this case, you allowed an unlicensed person to access and administer. So Betty Dare is not a medical professional. Is that correct?
She is a medical professional. I'm not sure what her certification is, but she does have a license. And like I said, she did also receive a hearing or a notice, and she admitted to the charges and has paid a fine.
Laura Tucker, for the record, if I could just clarify, Ms. Betty Dare, we had that she was an esthetician, not an RN. And also the action that we're referring to is a citation because she was unlicensed. So that's the action that we take against unlicensed individuals. So she did not have a license with us, just.
Okay, that's what I thought from my readings.
Nor did she qualify for a license with us.
Okay, so that being the case, I think that this is a lot more concerning and riskier to the public in that we have unlicensed, non-professional, or unregistered individuals fully accessing and administering dangerous drugs without any oversight. I don't think that this stipulation is, I don't think it is enough. I think the $2,500 is significantly less than what we typically see in these cases. And in this case, perhaps it's even a little more egregious since they're unlicensed practitioner, or they're not practitioners, they're just unlicensed individuals.
May I address that?
Yes.
I think that the reason for that is because there were additional fines issued to the people that were primarily responsible. Mr. Stellmacher had no knowledge of this whatsoever. As I stated in my opening statement, his contract and what he understood was happening at the spa had nothing to do with any of this. And it wasn't something that was advertised or promoted on their website or that he was informed of. He was actually shocked to learn of it right from the beginning. So I think that the stipulation, the other fines that were higher, I think $5,000 for Ms. Dare, and I think another $5,000 for the owner of the facility. But in recognition of the fact that Mr. Stellmacher was completely caught off guard and had no knowledge of this. And that's why I believe council and I were able to reach the agreement as is. It does look, I guess, low, but when you take into account that there were three respondents in this matter, and that Mr. Stelmacher of those three had absolutely no knowledge of that context. In other words, he didn't permit the use of those drugs. He didn't procure it. He didn't buy it. He didn't deliver it. He had never seen it on site. It was never presented to him in a cage in a back room that he didn't even know, frankly, existed on that facility. It was not in the normal area of the spa where he would visit or where customers would visit. So it's very difficult to pin the majority of the blame for this on Mr. Stelmacher.
President, can I ask some questions?
Certainly.
Adam Porth for the record. Mr. Stelmacher, are you a medical director of any other medical spas?
No.
To your knowledge, you said they've pulled back on some of these activities. To your knowledge, are there still prescription drugs within this spa?
No. I guess what I would say is, so when Betty came to me and said, I need somebody to say, I know what I'm doing with this channeling. It's a way to treat the skin and then apply different collagen, let's say, things you can actually buy over the counter, but it's called Channel Pro, and it's not quite microneedling, but there's some dangers, but if you know what you're doing, you're okay. And she's an advanced esthetician. That's her actual title, her licensure. And and she was training for this. And so during the training, I thought, hey, I'll get a treatment too. And it does wonderful stuff to your face. And, oh, okay. So you need someone to sign off and say, you know what you're doing. Okay, I'll sign off. I think you know what you're doing here. I'll sign off. She's a very knowledgeable, advanced esthetician. And so that's what I signed off on. Now, in the building where she's at, it's almost like salon suites where people rent different areas. So there is somebody else there, and that's where the supposed, these drugs came from, and, things left out. I didn't see in her little cubby hole where she has her bed and her products. I didn't see any like injectable drugs or anything like that. It seemed pretty, it just seemed like another spa that you go to and get a facial or a haircut or whatever. So, the way I understand it is she was just, this person came in, the person who had an injection came in to pick up product from another vendor in that area, but that vendor couldn't be there. So she just picked it up for her, but she wasn't sure how to do it. And she would explain how she gave herself injections. And somehow that led to, some people just have a problem injecting themselves. And so I think she was just like showing her how she injected her kind of without injecting herself. And then evidently got talked into, well, hey, could you just do it for me? And I think that's what happened here. And I know she's like really embarrassed. I was really taken off guard. As far as ongoing, this had been delayed several times. So the idea was, let's have this resolve, decide how this comes out, and then let's talk about maybe, if you're not going to do anything that requires a medical director, which they're not doing anymore because this whole thing has scared them, do you really even need a medical director? So that may come to a conclusion, and that could even be part of the stipulation. But right now, we're going to wait to see how this ends. And then we'll have that conversation about, do you even really need? If you're just going to go back to like eyelashes and things that that you don't even need an advanced esthetician licensing for, then you really don't need a medical director. And so that's where I'm at with that. But
so maybe just a couple more pointed questions to that.
Okay, thank you. Yes.
Is there currently Botox on site?
No.
Is there currently tirzepatide on site?
Not in her area. I can't speak for the other clients who either own or rent that space.
But to be clear, those clients are not in any way, it's just a shared office space, and not even in one unit. It's like a building with partitions. And so Mr. Stelmacher is talking about the other, I guess, entities or companies that have no relation to us.
So in the space that you have, Mr. Stelmacher, the tirzepatide, how is that stored?
There is no space in Betty Dare's salon suite, if you will. There are no medications. Other than, I
Okay.
mean, you might have personal medications, but any medications in her suite, well, no, I mean, there is none. There would be none because why would it be there? I can't speak for the other clients in that building.
Sure,
'Cause I don't
right,
know
not
what
the
these
other clients. We're
sell.
just talking about your space and for the Premier Beauty. So
Yes.
it sounded like previously you were saying that there might be some tirzepatide, but are you saying there are no prescription medications
I
to
would
your
say there were
knowledge?
no tirzepatide.
Are there other prescription medications?
No. Not in
Are
Premier.
there other, I guess what I'm concerned about is the other foreign non-FDA drugs.
Which I think if you walk into that space, you might say, oh, that stuff is here. Excuse me, that stuff is here. But there's separate spaces here that are not Premier Beauty. So there might be stuff in those other spaces, but not in
Yeah, but
Premier Beauty.
Just to, again, I think we have, just to clarify it, for the stuff that you're responsible, there's no prescription drugs or illegal drugs in that space. Do you have knowledge that there is others and that is that you're trying to say you think you've seen it at other places, but you're not sure, or you just don't know that there's products?
What's outside of Premier Beauty, I don't know.
Okay, that clarifies.
So what's that?
Sorry.
Yeah, but it sounds like, are you sharing a space?
No, it's more like a salon suite kind of situation.
Okay, and then in that salon suite that is Premier Beauty, you're saying there's no other drugs or prescription medication?
No prescription drugs, no.
Okay, thank you.
Can someone clarify for me who Mr. Gillis is and what his role is with potentially these other salon suites that are in this space?
Mr. Gillis is the owner of the larger building, and then he rents out suites or spaces, cubicles, whatever you want to call them, to various other entities.
Does Mr. Gillis, I guess the accusation is that Mr. Gillis purchased medications utilizing Mr. Stelmacher's credentials as the medical director. Would there be anything to preclude him from doing that in the future?
I could comment on that. I mean,
well, yes.
If he bought anything under my name, I'd be really angry and I would be going after him legally because that individual is like over there and and kind of like, yeah, don't get involved with that individual. Stay away from that individual. You've got Pro Beauty. Stay away from that individual. I don't know what he's up to back there, and I don't want to speak against the man. I don't really know him, but no, he wouldn't be buying anything under my name, and if he did, I would be very upset and would have to go after him legally.
Yeah, and I was going to say that's not my understanding that Mr. Stelmacher's credentials were used to purchase anything, but I do know unequivocally that no such transactions have occurred since all of this transpired. I have spoken to both Mr. Gillis and Ms. Dare. I can confirm that there are no such substances present on that facility. And I guess I would just echo what Mr. Stelmacher said. He would be aware if his licensure was being used to procure any substances, but to my knowledge, that has never occurred. And there's no contractual relationship or professional relationship between Mr. Gillis or Mr. Stelmacher.
Anna Carr for the record. Can you clarify to me then the relationship between Dr. Stelmacher and Dr. Amin, whose NPI number was used to ship these products?
I'm not aware of there being any relationship.
I would say zero.
do we know how how Mr. Gillis obtained this NPI or the information of this other provider?
Well, I do know that Dr. Amin is a physician and has had a contractual relationship with Mr. Gillis. The contours of that, I'm not quite certain. But as respects Mr. Gillis, he himself has his own citation issued. And I believe that those questions, frankly, would be more appropriate in that context because for this purpose, Mr. Stelmacher doesn't know either of these people at all and has had no contact with them and it's not really in any way shaped the issues that are within the four corners of the stipulation at issue today.
Just one more element I'd like some clarification on. Within the allegation, it appears that some drugs were purchased from OUISA Pharmacy Corporation out of Florida. Were those drugs purchased with Mr. Stelmacher as the provider in that case, or was that under a different provider's name?
It was not under Mr. Stelmacher's name. I think it was a different provider, but I'm not certain of who that might be at this moment. I think it was Dr. Amin. I'm not sure.
Yeah, to answer your question, Ms. Dr. Morak, it looks like Dr. Amin's NPI, who is a doctor in California, was utilized by the unlicensed people to order drugs for the clinic. You want to clarify?
Yes, Laura Tucker for the record. That's on paragraph 8, 4360 in your board books. It states that respondent, so Mr. Stelmacher permitted Gillis so in this case, Mr. Stelmacher was the medical director. And as medical director, he is responsible for any conduct that happens within the facility. And so it said respondent permitted Gillis to purchase the drug products using the national product identifier number of Dr. Jayendra Kumar Amin and had the product shipped to California. Amin is located in California and does not hold any license or registration with the board.
And there is an action concurrently pending against Dr. Amin and Mr. Gillis in California.
Ask a clarifying question to the Attorney General.
Yes.
So in a case like this, is there an option to put Mr. Stelmacher's controlled substance license on probation?
If he is willing to agree to probation as a term of the settlement of the stipulation, certainly. But it'll be up to him as counsel. As usually with the stipulations, if there's interest in amending what is currently out there, the board should have that discussion. So it's clear what the majority is interested in, and then we'll give the parties a chance to go back and see if they are amenable to that. So certainly it can be done. It just has to be agreed to by all sides.
Adam Porth again for the record. I would just tend to agree with President Park's sense that given the circumstances of this particular medical spa operation, it seems a little bit more egregious than we've seen in other cases. So I'm not sure that I'm supportive of the stipulation as written today.
Yeah, I think that there's a lot of complicating factors here. We had a chance to hear from Mr. Stelmacher, and while he maintains that this was unknowing to him, he's still responsible as the medical director. And so in this case, the access to the medications, the unlawful administration, using products that are not FDA approved, and it certainly doesn't sound like the med spa services were secure. So I think the stipulation as presented is not sufficient. It sounds like moving forward, Mr. Stelmacher might not have involvement in the business, but for what occurred in the past, I think consistent with other similar issues, the fine at a minimum should be $5,000. Board members, any other thoughts?
I would be open to increasing the fine. I have some serious concerns too about if other patients were injected but just didn't have adverse reactions. I mean, there could be a lot more.
It sounds like we just don't know, like, no, there's,
Right.
the oversight didn't take place, and so
Right.
that's,
And then, yeah, record keeping, we just don't know. So the depth of the public risk could be more than we know.
I don't know if there's other
Hey, can I-
questions,
Go ahead.
if you want to consider, just a moment, please, we're doing board discussion. If there's other things we could do to make it safer for the public.
I'm Jade Jacobo for the record. I'm just not personally comfortable with Mr. Stelmacher serving as a medical director. There was no oversight. He relied solely on contractual terms, and that's not the role of the medical director. And directly contributed to that was patient was harmed.
I think for Dave Weiss for the record, I think that I can empathize with what you're saying. I'm just gonna remind you that we as a controlled substance, is he? Never mind. I'm sorry, I shouldn't have said anything.
Did we lose his attorney, Mr. Cortez? I just noticed.
Didn't do it.
We did, and we may have to take a break and come back, but I mean, I would like to make a couple comments once your discussion is finished.
Okay, let's wait for Mr. Cortez to come back. So we'll take a quick break to make sure he can get on, because we'd like him to be present for you.
Okay. Give him a call.
We're looking for him.
Okay.
Do you have the ability to call him?
That's what I'm trying to do now, yeah.
Thank you. He may not know he's not on.
You've fallen off the screen and we're looking for you. So I was able to text.
Thank you.
He's not, the voice went right to recorder.
Okay.
Oh, okay.
Do you want to just, I mean, I think we'll need to talk to him.
Right,
So, I
because
don't know if-
it sounds like I'm getting,
Sure.
it's like we're condemning you for this guy named Joe, who I barely know.
Sure.
He's not part of the, the beauty shop. I was saying, Betty, I know you can do that micro channeling. You've done it on me.
Mr. Steelmacher,
Do it on
Mr.
others.
Steelmacher.
Yes.
I know you have statements you want to make.
Okay.
And that's.
Oh, here we're back.
For your sake, we need your counsel to be on.
I appreciate that.
I apologize. Just when Madam President informed me that she wants to double the fine, my power went out. The timing was quite impeccable. That was the last word that I heard. It looks like my Wi-Fi is back up and running. I do apologize.
All right, so do you want to give board staff some direction and then we'll contact them out and then we'll go to the next item and we can work on that in the background.
Yeah, I think the feedback from the board is just, we're very concerned about the nature of what took place, and with the allegations that, allegations. And so with that, we're not comfortable with the stipulation as presented. We think it's At a minimum, the fine should be $5,000. We may not, there's not a lot of confidence in Mr. Stelmacher's ability to be a medical director. We're not sure if there's other things that can be done to ensure that patients are safe. And that's kind of where our discussion ended.
Yeah, so I'll go, but Dave, wait for the record. I'll go back to my comment. You give the ability to prescribe and possess dangerous drugs and controlled substance. So you could put a limitation on that if they agree to it, to Todd's point. But you just related to drugs, you wouldn't have the ability to migrate into things that were not related to drugs. And that was what I was trying to clarify, but I'll just wait and see what you have to say.
May I just make one final comment before we, I guess, adjourn to discuss the modification proposal? And that is in the context of I do understand the board's concern, but there are two other additional entities that have been issued citations, both $5,000. The context with which this happened, the timing of it, right? If this was, say, a years-long endeavor or even a months-long endeavor where Mr. Stelmacher could have been there upon a visit and witnessed this transpiring, perhaps then one might think that the transgression is worthy of a doubling of the settlement proposal. But this was almost like a one-off occasion. It was not something that was reoccurring or happening with multiple people. There was no internet website traffic. There was no advertisements for it. It was really a very, within a matter of weeks, this happened, if that, maybe even days. And so and Mr. Stelmacher has been a PA for 33 years. This is not like his business where he's doing this for a lot of other spas. This is the one and only spa that he's worked for. And it was only supposed to be for esthetician services. He had no way of knowing that there were any type of injections being performed. And in fact, they were only performed for a very, very short period of time. And two other people have been issued $5,000 fines. So in that context, I don't think that a $2,500 fine, and I certainly don't think any sort of restriction of his ability to practice medicine is warranted for something like that. But with that in mind, I'm happy to discuss further with council. What is the process? Is it something we go offline and do now? Or do we just get put on the next board hearing to see if we can agree on additional terms, or how does that work?
The Senior DAG Todd Weiss, if the board is proposing changes to the stipulation, you guys will have a discussion on your own in private. And when I say you guys, I mean you, your counsel, your clients, and the board's counsel will have a discussion in private as to whether you are amenable to those changes. If you are amenable to the changes, you'll come back before the board, you'll communicate that, and the board will take a vote on approving the amended stipulation. If that is not amenable for you or your client, then there is no then the board will have to take a vote on the current stipulation. And if they reject it, it goes back into the hearing stance. Sorry, counsel, did that come through?
You were breaking up quite a bit. I'm not sure if that was on my end, but I think
I saw it freeze a little bit.
I got the gist of what you said. So, okay. So would we drop off this call and sidebar with Ms. Tucker now, or do we have to wait till the hearing concludes and then meet with Ms. Tucker? Or?
No, we would handle that right now. Yeah, you would drop off the call right now and have that discussion with Ms. Tucker, and then come back before the board once you have a decision.
Laura will call you. Ms. Tucker will call you. Then you can three-way in your client, and then the board staff will be with Ms. Tucker. So she'll call you in about 3 minutes.
And can you clarify, Madam President, what is it that you guys wanted to increase the fine and
Minimum fine of $5,000.
Minimum fine of $5,000 and some other action that mitigates the risk to the public moving forward. So there's a couple different possibilities for that, and I can. Do you know what they are?
I'll probably need your help.
I'll go with you, and then Yan will stay here. Thank you.
Okay. Great. So while they meet, we'll move on to our next agenda item and we'll turn it to one of Mr. Zanino's cases. All right, so I will call for agenda item 5M for Sean Aurora. If Sean Aurora or representatives are here, if you could please come forward. Hello.
Lynn Beggs on behalf of Dr. Aurora, who will not be joining me today.
All right. With that, I'll turn it over to Mr. Zanino.
Thank you, President Park. For the record, this is the case of Nevada State Board of Pharmacy versus Sean MD. Specifically, this is case number 24509 CSN. The accusation in this case begins at page 4233 of your board book. And to kind of summarize the allegations at a very high level, this accusation concerns a medical spa, another medical spa in Reno. It went by the name of Youth Inc. Dr. Aurora assumed the role of medical director for that medical spa. Ultimately, it was determined by our investigators that there were prescription drugs at the facility and that there were no practitioners on site. There were registered nurses that were administering the drugs, but there were no nurse practitioners or physicians on site. And we have a statutory definition of practitioner that includes only physicians, PAs, or APRNs. So registered nurses generally don't have authority to store or possess drugs, nor does the owner of a medical spa. So Dr. Aurora was based in Seattle, and he didn't have a great deal of contact physically with the RNs or at least he didn't visit the site, I think, by his own admission. We've reached a stipulation in this case for your consideration and possible approval. That stipulation begins at page 4189 of your board book. No, that's wrong. The stipulation begins at page 4262 of your board book. It pertains only to Dr. Aurora. There are 3 other respondents in this case. They are also represented by Ms. Beggs, and I think Ms. Beggs and I are anticipating that there'll be a contested hearing in June involving those 3 respondents. But Dr. Aurora, I think, is eager to wrap this matter up. So I'll cover the key provisions. And then I'll elaborate a bit. But at paragraph 7, as to count 1 and count 3 of the accusation, respondent denies that he had the requisite knowledge of events to have committed the violations of law stated therein. Regarding count 2 of the accusation, respondent disputes the characterization that he assisted or abetted in the practice of pharmacy, but he acknowledges and admits that the board staff prosecuting this case could present sufficient evidence to establish a factual basis for the claim that he assisted or abetted in the unauthorized possession or administration of dangerous drugs. And I think that I'll go back to count 1 and count 3. There are three counts that pertain to Dr. Aurora in this case. Count 1 is specific. It relates specifically to some drugs, some GLP-1 drugs that were purchased from an unlicensed wholesaler. And we have no evidence that Dr. Aurora kind of procured those drugs or knew that the owner of the spa was procuring those drugs. So I think at a minimum, I think Ms. Beggs and I agree that we would have to show that there was at least some knowledge or perhaps notice that this was going on, and the evidence perhaps does not suffice to prove that. With regard to count 3, again, it's a specific violation. It alleges that Dr. Aurora kind of assisted or abetted in the use of single vial products on multiple patients. And again, I don't think that we have the evidence to show that he knew or necessarily that he should have known that that was going on. However, the crux of this case is count two. I think it's undisputed that that Dr. Aurora knew that there were drugs on site, that he had assumed the role of medical director. He knew that there, or at least he should have known that there were no practitioners on site. I think he knew that there were RNs on site, but he did not make sure that there were practitioners on site. So to settle these allegations with regard to count two, respondent agrees to the following facts. Respondent, a physician, served as the medical director for Youth Inc. During his tenure, he was based in Seattle and did not visit the spa's location at 691 Sierra Rose Drive in Reno. During his tenure, the employees and or the owner stored and possessed prescription drugs, and there were no practitioners present at the time. During his tenure, they administered injectable drugs without practitioners on site. Of course, I think that I'll reiterate that the registered nurses were administering the drugs, but there were no APRNs on site. So to settle those claims, Dr. Aurora agrees to accept the stipulations of public reprimand. He agrees to pay an administrative fine of $5,000 payable on or before May 31st, 2026. He agrees to pay the sum of $500 for investigative costs. And that will also be payable on or before May 31st, 2026. And Dr. Aurora acknowledges that this will be reported to the National Practitioner Data Bank in accordance with federal law.
All right, Ms. Beggs.
Thank you. And my thanks to Mr. Zanino for working with me to reach what we feel is a
May just need to move closer.
better.
Yes, that's
All right, I appreciate Mr. Zanino's willingness to work with us on a resolution of this case. I think one of the very salient points to make on this case, which differs from the last case that you just heard, Dr. Aurora was not contacted directly with Youth Inc., the medical spa in question. He was a contractor with WeTreat, a company based out of Southern California, if I'm not mistaken, that arranges for medical director services for med spas and wellness clinics. So his contract was with WeTreat. WeTreat had a contract with Youth Inc. to provide medical director services and just assigned Dr. Aurora to act in that capacity, which included the approval of protocols and standing orders for Youth Inc. So his involvement with Youth Inc. directly was really through WeTreat. So there's a little bit of a triangle here. He was only acting in that capacity and actually only worked with WeTreat between July 2024 and January of 2025, when he learned that Youth Inc. was not following the protocols that he had approved and is no longer associated with either WeTreat or Youth Inc. in any capacity. So I just want to make that very distinction because this is a situation where this was a contractual relationship with a third party that assigned him to act in that capacity, and his duties were confined to what his contract was with WeTreat, the medical director service company. So we do feel that the stipulation that we've reached in this case is much more reflective of actually what happened in this case, that he did allow the drugs to be ordered. He was not aware of the GLP-1s and tirzepatide being ordered from a non-approved pharmacy. That was not something that he approved of and had no knowledge of. So we do ask the board to accept this settlement as it's presented. I know you do have questions, and I have to just preface this by saying I'm limited in what I can provide to you today because we do have the contested hearing set for the 3 APRNs. That'll be in June. So if I'm not able to fully answer your questions, I do apologize in advance.
And Dave Weiss, for the record, I'll put on the record too that he was cooperative in the investigation, which was necessary for us to figure out the breadth of the issue.
Yeah, and I guess just a general question for Mr. or Dr. Aurora. Does he understand the issues here? Like
I've talked to him and he does.
okay, absolutely. Okay, great. And then it sounds like in his case, he put together specific protocols or
Yes, so the way that the We Treat system worked was they would, I don't want to use the term template, but they would have standing protocols that a medical director would review, make sure it applied to the specific med spa or wellness clinic in question. He would approve those, and then those would be part of the package, for lack of a better phrase, that We Treat would provide to its client, which was Youth Inc. So, but like I say, Dr. Aurora stepped away because he realized what was happening both through We Treat and Youth Inc. was not in compliance with what needed to be.
yeah. All right. Any additional questions, board members?
Back and forth for the record. I don't have any additional questions and doesn't sound like anybody else does either. So I would move that we approve the stipulation for Dr. Aurora as outlined by board staff.
And Carr second.
Okay, we have a motion by Mr. Porath, second by Ms. Carr. Any further discussion? Hearing none, all those in favor?
Aye.
Any opposed? That motion passes. Thank you.
Thank you very much.
Are we ready to go back to Stelmacher? Okay, so I'll call for Michael Stelmacher, 5Q, agenda item 5Q for Michael Stelmacher.
Whatever you did last time to fix your audio, you need to do again. Yeah,
How about that?
that's it.
Okay.
Thank you. And then you're still under oath from before, and then I'll turn it over to counselors.
Thank you, Madam President. Laura Tucker for the record. I spoke with Mr. Stelmacher's attorney, Mr. Anthony Cortez. We believe we've come to an agreement that we want to present before you today. Pursuant to the board's direction, we'll update the stipulation to raise the fine to $5,000 from the $2,500 proposed. And then we also want to include a term that states that Mr. Stelmacher cannot serve as medical director where injectable dangerous drugs and controlled substances are in the possession of unlicensed individuals where Mr. Stelmacher is not physically present.
For 5 years.
For 5 years, sorry.
Okay. All right, thank you.
And just for the record, we didn't want to make it indefinite, so we just, if that's, I think you agreed to maybe indefinite, but we put a 5 year. Is that okay with you, counselor, or Mr. Stelmacher?
Yes.
Okay, great. I appreciate the revisions. I'm comfortable with that stipulation. So I would move that we approve the amended stipulation as presented by Ms. Tucker and agreed to by Mr. Cortez and Mr. Stelmacher.
I second.
Okay, second by Mr. Cobo. Any further discussion? Okay, hearing none. All those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes. Thank you for your time, and we wish you all the best.
Thank you for your time,
Thank
Madam
you.
President.
Okay, we're going to continue on our agenda next to 5R for Philip Rich. So if we have Dr. Rich, our representative. Oh, hello.
Good morning again.
Good morning. Okay, and with that, I will turn it over to Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. This is item number 5R, which can be found on page 4377 of the board book. This is case number 25-021-CS-N. The respondent is Dr. Philip Rich. His certificate of registration number is CS 02308. In the accusation, which can be found on page 4377 of the board book, we allege that Dr. Philip Rich engaged in conduct contrary to the public interest when he failed to check his patient utilization report prior to prescribing controlled substances and his prescriber report with the prescription monitoring program. We charged him with 1 count of unprofessional conduct for non-compliance with the prescription monitoring program. And we have a stipulation that we would like to present to you today, which can be found on page 4388 of the board book. The terms of this are that Dr. Rich must participate in PMP training with board staff within 60 days of the date of this order. And respondent agrees to pay an administrative fine of $5,000 and $1,000 fees and costs payable within 60 days of the date of this order. And with that, we present this stipulation to the board today for approval with an effective date of today, April 15th, 2026.
Ms. Beggs.
Thank you. Good morning again. We are in favor of the board's acceptance and adoption of the stipulation as presented. Dr. Rich is a practicing psychiatrist, so he is not prescribing controlled substances for pain or anything along those lines. His prescribing is primarily for Schedule 4 psychiatric medications. He is a physician who's been in practice almost 50 years, and so times have changed certainly since he began to practice. And frankly, he is looking forward to the training with staff on the PMP to ensure that he is in compliance with proper monitoring and proper reporting of the checks of the PMP. So we are asking that the board accept the stipulation as presented to you today.
Thank you. Board members, any questions for Ms. Beggs?
Crystal Freitas, I don't have any questions. This is pretty straightforward. So I think I would move to approve the stipulation as presented for Dr. Philip Rich.
Okay, we have a motion. Do we have a second? Second by Mr. Porath. Any further discussion? Okay, all those in favor?
Aye.
Aye.
Any opposed? Okay, that motion passes. Thank you. All right, we'll go on to 5S, and that is for Laura Oki. So if Laura Oki or representatives are here, if you could please come forward.
Hope you can see me. I'm Craig Perry, appearing on behalf of Laura Oki. She is not going to be present today for the stipulation.
Okay, all right. Thank you, Mr. Perry. With that, I'll turn it over to Ms. Tucker.
Thank you, Madam President. Laura Tucker, again for the record. This is item number 5S. It can be found on page 4394 of the board book. This is case number 25-112-CS-A-N. And respondent is Laura Oki, and her certificate of registration number is CS 24180. In the accusation, which again can be found on page 4394 of the board book, we allege that as medical director of a med spa, Skin Lab in Reno, APRN Oki gave non-practitioners unfettered access to dangerous drugs, dispensed drugs without the required dispensing license, allowed the storage of expired drugs with non-expired drugs, and allowed single-use drugs to be administered as though they were multi-use. The charges that were contained within the accusation are as follows. There were 4 counts. The first was count 1, failure to maintain security of dangerous drugs. Count 2, dispensing without a license. Count 3, holding for sale an adulterated drug. And count 4, failure to follow manufacturer's instructions. Ms. Oki filed an answer, which can be found on page 4407 of the board book. And we also have a proposed stipulation, which is not in your board book, but copies should have been provided to you in front of you. If you just about 30 seconds to pull it up. Okay, and in the stipulation, respondent Laura Oki agrees to administrative fine of $5,000 and $500 fees and costs, all payable within 6 months of the effective date of this order. And with that, we present the stipulation to the board today for approval with an effective date of today, April 15th, 2026.
Thank you. Mr. Perry, did you want to add any additional remarks?
Yes, just a few things, Madam President. So as Ms. Tucker has stated, she has taken full responsibility for the lapses as the medical director of this facility. As you might note in the answer with the defenses, all these not really defenses as much as they are just mitigating points, which you can review. This is a individual who had never been a medical director before. When she first began the job, she agreed to do it as a co-medical director, so she wasn't full-time when she started, and was assured there were other people that were, namely the other medical director who was going to be overseeing things. She at the time was attending a postmaster's FNP program, which is why it was part-time. Now, apparently it did become full-time, so she should have, become more aware of her duties and responsibilities. With regard to the initial allegation that she did not have a license to dispense, what happened is she had a license to prescribe when she went in to file for the dispensing license. As you might be aware, the applications are quite similar in the way that they look, and she thought that she was filling out the correct one when she was actually just refilling out one she had already had before. So she was unaware, it was not intentional, and that's what happened on that point. I will tell you that given the direction her career is taking, that she is not going to be applying for a dispensing certificate. She doesn't want to do that, and so that will not be part of her practices moving forward. And as far as a medical director, no desire to be a medical director either. I know that I've been in front of you in the past on issues where medical directors have had lapses in their overview or supervision. And so I've talked to her about that. So if that wants to be addressed, we can talk about that. But it's not part of the stipulation, however. But as far as paying the fine and the statement of the facts that is listed in the document, the stipulation and order, she is in full agreement with those terms.
Thank you, Mr. Perry. Okay, board members, any additional questions?
Did the Counselor, did you say that in addition to the fines, your client was willing to not be medical director? Is that what you just said?
I spoke to her and she said it's not her intention to do that. So the way we would say that in lawyer terms is, for an indefinite period, she has no plans to be a medical director. Things can change in the future. So I don't want to make it so that if you decided to add something in that regard, that it could be, she'd be forever precluded. But perhaps if she has more experience down the road, if her, plans or intentions were to change, that might be made available to her. But I think a complete ban, in the future would not be necessary or appropriate. But certainly she engaged in a job that she didn't fully appreciate what her duties and responsibilities were.
Yeah, for the board's information, my feeling is she falls into the same category as other medical directors that come before us. And she did a bad job as a medical director for allowing all this to happen. I think I would be in favor of some adding to the stipulation that either she's on probation or she can't be a medical director or for so many years or something. This is just as egregious as some of the other ones that come before us that we said the same.
Yeah, I would agree with you, Mr. Tomaso. I think that would be beneficial to the public, and I think that would also, it would help Miss Oki in the event she chooses to be a medical director in the future too. So I think an amended stip would be preferred.
Yeah, Adam Porth for the record. Yeah, unfortunately, the allegations are something that we see all too often. And until we put a little bit more teeth behind discipline for these medical directors of medical spas, I don't think that we're going to see any slowing down of this. So I would be fully supportive of something similar to the language that Ms. Tucker presented in the last amended stipulation as far as a prohibition of being a medical director for 5 years.
This is Laura Tucker for the record. Do you want me to read off the language? Would that be helpful?
Well, I think that you probably need to go offline and talk to him about it. I just want, just for the record, there, in practice, there's a concept of a medical director, but there's not a legal definition of that. And so you're fine to say that, but we're going to go back to, they can't, oversee a place where there's dangerous drugs. And then I think moving forward, we can incorporate this, which I understand why you're saying it and those things. And I just, for the record, we rarely see, I don't think I can think of any, but I think you should do it, a return of the professional into it. We definitely see a return of the unlicensed person, goes and gets another professional and does it. That is habitual, unfortunately. And Adam and I'll have a report later about what we're trying to do about it. But I think to Dick's point, it is. It's just we're not going to say you can't be a medical director because that's not a term that we have that we can reference to, but we can use a similar language. I would give him the same courtesy to be able to talk to his client and make sure that they have the ability to agree to it.
Okay.
Craig Perry for the record. It was about a month or two ago that I was before the board, Madam President, and this same issue arose with another medical director. And so actually it was a pharmacist who was head pharmacist and didn't have any experience. And in that case, the board decided to put a 1-year limit. Anyway, anticipating this was going to maybe come up, I did speak with the client already before the hearing. I said this might arise. So I already have authority to agree to that stipulation.
Good lawyering.
Great. Did you, Ms. Tucker, want to read the language then to confirm that we're all on the same page?
Yes, Laura Tucker for the record. So it would be, have to insert different names. Okay, so for a period of 5 years, respondent cannot serve as medical director of any practice, site, spa, or clinic where injectable dangerous drugs and controlled substances are in the possession of unlicensed individuals where respondent is not physically present.
And Mr. Perry, you're saying that that's something that you discussed and you're authorized to accept on behalf of your client?
That is correct, Madam President. We'll accept that stipulation.
Okay. All right, then I will make a motion that we approve the amended stipulation as presented by Ms. Tucker and as agreed to by Mr. Perry for Ms. Laura Oki.
Anna Carr, second.
Motion by Helen Park, second by Anna Carr. Any further discussion?
Yes, I'd just like to say, I think that's a good thing that this board starts doing because we're aware now over the last few meetings of how dangerous these spas especially have become. I think we've, like Adam said, we've got to take some action. This board just can't sit back and fine them $5,000 and it happens the next time. We got to take some action so people start thinking before they accept a position like this that they're going to could cost them. So anyway, that's all I had to say.
Thank you. All right, we have a motion. We have a second. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, that motion passes. Thank you for your time today, Mr. Perry.
Thank you.
Madam President, we're in the middle of dealing with lunch. You have one more, you can do one more if you choose to do it.
I think we could do one more.
Papyrus would be, yeah.
This, the Apria.
Yeah.
So we're gonna do 5T for Apria Healthcare. We have representatives here. Please come forward.
Madam President, my name is Jay DeVoy, I'm counsel for Apria Healthcare LLC.
Okay, will anyone else be joining you today?
No, nobody else is joining to present on the stipulation order.
I will turn it over to Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. This is item 5T, which can be found starting on page 4413 of the board book. Excuse me. This is case number 25-138-MP-N. The respondent is Apria Health, license number MP 00030. In the accusation, which can be found on page 4413 of the board book, we allege that Apria received a prescription in June 2024 for a patient's CPAP machine that was not delivered to the patient until August 2025. For a portion of this time, patient's insurance was billed for equipment and services he was not yet receiving. This was as a result of failing to timely resolve the patient's complaints and failing to properly bill patient's insurance. Additionally, Apria also failed to produce records as requested as part of the board's investigation. In the interest of compromise, the parties stipulated to dismiss counts 3 and 4 that are in the accusation. So the remaining 3 counts are as follows. Count 1, unprofessional conduct for improper billing practices. Count 2, unprofessional conduct for failing to have a system in place to resolve complaints. And count 5, failure to maintain and produce records. The stipulation is not in the board book. So I'll give you a few moments just to pick that up from your pile. Has been provided to you.
It has.
So as stated, again, in the interest of compromise, the parties stipulated to dismiss count 3 and 4 in the accusation. And the terms are that respondent Apria agrees to pay an aggregate administrative fine of $3,000 and $1,000 fees and costs payable within 30 days of the effective date of the order. And with that, we present the stipulation to the board today for approval with an effective date of today, April 15th, 2026.
Mr. DeVoy.
Thank you, Madam President. I'd like to thank Ms. Tucker and the board for working quickly. This came to Apria's attention and myself very late in March. We were able to get this on relatively quickly to have it resolved today. With respect to the 2 counts of the accusation that were dismissed, in the course of Apria's investigation of this, it was discovered that they had received either inaccurate or incomplete information from UPS. There was an indication that the CPAP machine that had been ordered was delivered to UPS, and UPS either indicated that it had been delivered or was inconclusive as to the issue that it had not been delivered to the individual patient. There was inconsistent information from that, and Apria was unable to get definitive answers from UPS to confirm what the patient was saying, just because they don't want to be on the wrong side of a payer where somebody's getting 2 CPAP machines and you have an issue where somebody's diverting medical equipment. Related to that, because of the way that operated, the other counts of the accusation that pertained to that had to do with the sufficiency of inventory to meet the order. As soon as Apria was able to resolve this in July of 2025, they had to be dispatched to immediately bring a replacement machine to that individual. So there was no concerns of inventory. Apria had a chance to review everything that had occurred with respect to staffing and having a proper administrator, which I know this board is very concerned with, and that had been resolved. So in light of those issues and Apria's efforts for compliance, on that basis, the board decided to dismiss those 2 counts of the accusation. As to the rest of the accusation, however, it's unarguably what happened here. Apria has used this opportunity to review its policies and procedures. It has policies and procedures to address all of this. And what Apria concluded is that this is an instance where seemingly everything that could go wrong had gone wrong. That's addressed in paragraphs 6C and D of the the stipulation order, which is on pages 2 and 3. And it goes into some detail, not only of the events that occurred, but also the curative elements that Apria had taken in response to this event. Specifically, there were a number of instances where insurance had been billed specifically for the CPAP machine itself in 2024, and then for CPAP related supplies in the beginning of 2025. Before the date of executing the stipulation order, April had begun the process of returning all of those funds to the patient's insurer. And in light of the need for further training based on the existing policies and procedures and having reviewed them and looking at the contents of the accusation and identifying which policies and procedures were implicated, April has begun the process of beginning further training for all individuals at this licensed location, which will occur no later than May 1st, 2026. Due to the need to have effective, meaningful training with appropriate personnel, staffing, oversight, and memorialization of that, there was a desire to build some time into it to make sure the training was effective and addressed all these issues and dealt with root causes rather than something reactive and backward looking to say, here's an instance that happened, don't let this happen again. And then there's some new issue that came up. So that is the substance of the stipulation, and APRIO is grateful that the board accommodated its desire to memorialize these corrective efforts in those two paragraphs in particular within the stipulation order for the board's consideration.
Thank you, and I appreciate the efforts to address the corrective action, so then to prevent these things in the future, and that discussion that you had with your client.
Thank you.
Board members, any questions for APRIA or Mr. DeVoy?
No questions for me, Madam President. I move that we accept the proposed stipulation for Apria Health.
You answered my main question as far as the entrance back. So I would second.
So we have a motion by Mr. Cobo, a second by Mr. Porath. Any further discussion? Okay, hearing none, all those in favor?
Aye.
Aye. Any opposed? Okay, the motion passes. Thank you.
Thank you.
All right, with that, we're going to break for lunch and we'll reconvene at 1 p.m. All right, we're going to continue with our Board of Pharmacy agenda. We're going to move to agenda 5W, 5X, 5Y, 5Z all together. So if I could have representatives come forward, this is for Life Pharmacy, Terra Pharmacy, and Nazakat Nigmatova.
It may be on Zoom. We're checking.
Good afternoon, Madam President and Board. My name is George Omar Khoury, bar number 15426 at Paradise Law on behalf of Ms. Nigmatova, Life and Terra Pharmacies.
And Madam President, before you get started, just as a housekeeping measure, this pharmacy name has been in front of you before. We saw it at the last board meeting as it relates to new ownership, and you approve the new ownership. At this point, in front of you will be a case related to the prior ownership. So you're seeing what happened before, and you've already done the downstream activity. So just putting that in perspective for you. Dave Weiss for the record.
Thank you. And this is Helen Park. Will Ms. Nigmatova be joining you today?
No, my client's not available for today's hearing.
Okay, I do want to disclose for the record that I'm familiar with Ms. Nazakat Nigmatova from her time at Rosen University, but I feel that I could participate fairly and unbiased in this matter. So with that, I'll turn it over to Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. These three matters, start on page 4460 of the board book, two matters. They are case number 25-360-PH-S, 25-360-RPH-S, and 25-370-PH-S, and finally 25-370-RPH-A-S. The respondents that we are discussing today are respondent Life Pharmacy under license number PH04561, respondent Terra Pharmacy under license number PH04648, and RPH Nazakat Nigmatova, certificate of registration number 20601. We have a consolidated stipulation to present to you today. This involves two separate accusations. For the first accusation, it's on page 4460 of the board book. I'll summarize them both together because they're pretty much the same set of facts, but let me know if you want anything specific about each one. But in both, we allege that respondent Nazakat Nigmatova was the owner of Life and Terra Pharmacies. In September 2024, without giving prior notice to the board pursuant to NRS 639.227, Nigmatova ostensibly sold Life Pharmacy to new owners. In September 2025, without giving prior notice to the board pursuant to NRS 639.227, Ms. Nigmatova ostensibly sold Terra Pharmacy to new owners. What then happened is that the putative new owners then began operating the pharmacies outside the knowledge of the board, including by using the DEA licenses associated with Ms. Nigmatova and the former pharmacies to order controlled substances. The pharmacies then continued operations without a registered new owner. That is, the new owner was not registered with the board. And they continued operations until January 2026. At that time, in January 2026, the board received notice from the DEA that it had seized the controlled substances at both pharmacies because no pharmacy owner was registered at these locations to dispense controlled substances under federal law. In February 2026, after the board reached out to Ms. Nigmatova, she declined to resume a managerial position at either pharmacy. And as a result, the board shut down both pharmacies at the pharmacy licenses that I read earlier. We had two different accusations, each with Ms. Nigmatova. For the accusation for case number 25-360, there were three charges. Count one was against Ms. Nigmatova for failure to submit a change of ownership. Count two was for permitting unlicensed practice for the use of her pharmacy license and DEA number. And then count three was against the pharmacy Life for pharmacy responsibility. For the accusation for case number 25-370, there were four different charges. Three of the charges involved Ms. Nigmatova and the pharmacy. So count one, again, was against Ms. Nigmatova for failure to submit a change of ownership to the board. Count two was against Ms. Nigmatova for permitting unlicensed practice for the use of her pharmacy license and DEA number. And then count four was pharmacy responsibility for the other counts against Terra. We've reached a stipulation that we would like to propose to put in front of you today. And this stipulation is not in the board book, but it is in front of you. So I'll give you just a few seconds to pull that up in front. If you don't, it looks like everybody has it in front of them. So this will resolve both cases with Ms. Nigmatova and then the former pharmacy licenses for both Life and Terra. So according to the terms, Ms. Nigmatova agrees that her certificate of registration number 20601 shall be suspended. However, that suspension is stayed, and Ms. Nigmatova shall be placed on probation for a period of 2 years from the effective date of this order, subject to the following conditions. So during her probation, Ms. Nigmatova shall pay an aggregate fine of $5,000 for the alleged violations, payable within 6 months of the effective date of this order. She will also pay an aggregate amount of $2,000 to partially reimburse the board for attorney's fees and costs, also due within 6 months of this order. And then also as a condition of her probation, she shall not engage in any conduct for which disciplinary action may be imposed. Upon the successful completion of these terms and conditions after the 2-year period, Ms. Nigmatova's certificate of registration shall be automatically reinstated without conditions or restrictions. In addition to the probationary terms, for a period of 3 years from the effective date of this order, Ms. Nigmatova may not own a pharmacy in Nevada for a period of 3 years. And then if she would like to own a pharmacy after the 3-year period is up, she must come in front of the board for approval to do so. And so with that, we present this stipulation to the board today for an approval date for approval with an effective date of today, April 15th, 2026.
All right, thank you, Ms. Tucker. Mr. Corey, did you want to add any additional remarks?
Yes, I just ask that the board accept this stipulation as written, and I would like to compliment Ms. Tucker's professionalism in working to amicably resolve this matter.
Great, thank you. All right, board members, any questions on the stipulation?
Adam Porth for the record. And then just to be clear, the actual pharmacy licenses then would remain inactive.
Yes, so that is correct. Laura Tuck for the record. So the pharmacy licenses for the former Terra and Life pharmacies, the two pharmacy licenses I read are already inactive. As Mr. Weiss stated at the beginning, there are new owners of the pharmacies, and those are actually under new pharmacy licenses. So also the two pharmacy licenses will remain inactive as a part per the terms of the stipulation.
I don't have any questions and I'd feel comfortable with this stipulation as presented.
Make a motion that we accept the stipulation as written.
Adam Porth, I'll second.
Okay, we have a motion by Mr. Tomaso, a second by Mr. Porath. Any further discussion? Okay, hearing none. All those in favor? Aye.
Aye.
Any opposed? That motion passes. Thank you, Mr. Corey.
Thank you.
All right, we'll move on to agenda item 5H for Raymond Graber. If we have Dr. Graber or representatives, if you could please come forward or let us know through Zoom.
Anybody on Zoom, Madam President?
Raymond Graber. Press *9, *6. If not, Mr. Zunino, are you prepared to move forward?
I am, Madam President. And I will note that this is the matter of Nevada State Board of Pharmacy versus Raymond Bradbury Graber, DDS. Dr. Graber held certificate of registration number CS 27126 that of course authorized him to prescribe controlled substances in Nevada. He did not renew that certificate of registration when it came due for renewal on November 1st of 2024. I think he also went inactive with the dental board. And to my knowledge, he has not practiced dentistry since he let that certificate of registration lapse. The purpose of this hearing, it's an order to show cause, and the purpose of the hearing itself is to determine whether he's basically satisfied the terms of probation that were imposed on him in connection with another case, an earlier case, that in that order is in your board book. If you return to page, I think it's 4130 of your board book, you can see this is the order that was entered in the other in a prior case, in a decision that was again, the case number is 23-340 CSN, and it was a case that pertains specifically to Dr. Graber, relating to a substance abuse problem that he appeared to have at that time. So at page see 4130, the terms of probation are outlined on the order, and those state a respondent Graber shall maintain attendance in a substance abuse counseling program with random urinalysis. Respondent Graber's counselor shall submit quarterly reports directly to the board detailing respondent Graber's progress, attendance, and urinalysis results. And then upon successful completion of the 5-year state suspension, respondent shall reappear before the board to have probationary conditions removed. And of course, it doesn't appear that that would happen because he didn't renew his certificate of registration. But I think if you were to find that, that he failed to meet these terms or satisfy these terms, I think you could, revoke his certificate of registration retroactively to October 31st of 2024. And then you could perhaps impose, like, as a condition that he would have to wait at least a year to petition for reinstatement, and that he would have to appear before the board. So that's a possibility. I do want to, because this is it's a notice, it's a notice of a hearing on an order to show cause, and it's a little bit different than the accusation process. So I would like to call Darlene Nassas as my witness to just establish the factual basis for the alleged probation violation. And then I'll submit it to you for decision.
Great. We'll call for Darlene Nassas. If you could state your full name for the record.
Darlene Nassas.
Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Thank you.
Darlene, I think everybody knows that you're employed by the State Board of Pharmacy, but for the record, can you tell me, are you in fact an employee with the State Board of Pharmacy?
Yes, I am.
And how long have you been employed by the State Board of Pharmacy?
5 years.
Let me ask you, is one of your job responsibilities to monitor compliance with the terms and conditions of probation?
That's correct.
Okay, so I'm going to ask you, I previously referenced page 4130. Do you have the board book in front of you? Okay, would you look at that? So I referenced these terms of probation that relate to attendance and substance abuse counseling. Let me ask you, what if anything did you do to monitor Dr. Graber's compliance with that condition of probation?
Yeah, usually I have like a tracker where I keep track of all the people that have to comply with quarterly evaluations. And with Graber, he wasn't compliant with the 2025 quarter four evaluation. So then I reached out to Mark Chase for an update. And then Mark Chase said he hadn't heard from Raymond Graber in regards to his evaluation. So he was trying to contact him and said to give him more time. And a few weeks passed and I didn't hear back from Mark Chase. And then I told board staff about him being not compliant.
So who is Mark Chase?
Mark Chase is the director of the Pharmacist Recovery Network for Nevada.
Is he someone with whom you routinely interact and talk to?
Yes, usually I get evaluations for our licensees for him that are enrolled with him.
Now I'm going to ask you I'll cover the notice in this case. And I know that you did not personally sign the certificate of service that's attached to the order to show cause in this case, but I'd ask you to look at it. It appears at page 4120. Will you look at that?
Okay.
So that's the certificate of service that's appended to the order to show cause in this case, right? And there's a signature that appears at the bottom. It's Aaron Miller. Do you recognize that to be Aaron Miller's signature?
Yes, I told my board staff to send out this order to show cause for this hearing.
So you have any reason to believe that this wasn't mailed as indicated on the certificate of service?
No, we did the tracking, and if you scroll down in the board book, it shows all the tracking information as well.
Okay, so let me ask you, go to the next page would be 4121. This indicates that the order to show cause was mailed to two different addresses. Is that right? Okay. And to each address, a copy was mailed certified and another copy was mailed standard?
Correct.
And is that standard operating procedure?
Yes.
Okay, and then let me ask you to look at the USPS tracking sheet that begins at page 4122. What is this? How do you?
It was for this location, which is that location, it was delivered to that address. And then for 4123, it was attempted delivery, but I guess there was no one there, so it returned back to the board office.
But there's an indication here that the order to show cause was delivered to the
Yeah.
Reno address, right?
Yeah, it was unclaimed, so then it rerouted back to us.
And as far as you know, was that Reno address the last known address that we have?
Yeah, those were the addresses that were listed in his account with us.
I have nothing further for Darlene, and I would just again, Rita, I think there are a couple of things you can do. You can make a finding that Dr. Graber did not satisfy the terms and conditions of his probation. I think possibly you could find that he did. I don't know if there's a basis for you to do that. If you find that he did not satisfy the terms and conditions of his probation, then I think it's for you to decide what, if anything, to do about that. And as I suggested, you could revoke the certificate of registration retroactively to October 31st, 2024. And I would submit that fines and things like that are not on the table here.
So procedurally, maybe for Todd, do we make a motion that the respondent was adequately and properly noticed? Should we start there?
This is Senior Deck Todd Weiss. Yeah, the first question would be whether service was properly effectuated. And then there would be another vote, a separate vote on whether the board finds the respondent did or did not comply with the terms of his probation. After that, I have some procedure. Greg, could you tell me again, was this part of a conviction on charges, or was this a stipulation to not have a hearing on charges?
I think there was a misdemeanor case that was pending, but this was, the accusation appears, and the relevant provisions appear at 4137. There was a charge of failure to timely report. So there was a conviction. He failed to timely report his guilty plea, was the charge. I think this might have been like a case where there was like a deferred prosecution, but he entered a plea of guilty, and I don't know if the sentence had been imposed at that time by the criminal court.
In 2024, did the board make a finding of?
And the stipulation, which appears again. 4130.
One 25.
41. So there's at page 4129, the finding is respondent admits the truth of each and every factual allegation. Respondent Graber admits count 2 of the alleged violations of law. Count 1 of the alleged violations contained in the action is dismissed. So we admitted count 2. And it was a standard kind of stipulation where he agreed that his registration would be suspended for a period of 5 years, but it was stayed and he was placed on probation. And the terms required him to complete a substance abuse counseling program. And that's where we kind of lost track of him. We're not sure whether he did or did not do that, but we have reason to believe that he did not, based upon Darlene's contact with Mr. Mark Chase.
Okay, so given that the suspension was stayed pending completion of the terms of probation, if the board finds that he did not comply with the terms of probation as contained in the stipulation, then the previously stayed suspension can be put into effect retroactive to the date of that stipulation. That's totally appropriate and that would be the right thing to do if the board finds there was no compliance with probation terms.
And let me clarify, I think when I was speaking earlier, I assumed that there was a revocation involved because of the length of the probation, which was 5 years. I didn't catch the fact that that was a suspension. So I agree with Todd. I think that the action would be a suspension consistent with the original order. But it's not, it hasn't been renewed either, so that adds a twist, right? You know, I would submit that probably as a practical matter, it makes more sense just to revoke it, but I'll leave that to you and, you know, and you can, because it wasn't renewed.
This is Helen Park. I'll start. I'll make a motion that the respondent was adequately and properly noticed.
Second.
Okay. Motion by Helen Park, second by Jay Jacobo. Any further discussion? Okay, all those in favor?
Aye.
Aye.
Any opposed? Okay, that motion passes.
Jay Jacobo, for the record, I make a motion that we make findings of fact that respondent Raymond Graver did not comply with the terms of probation as contained within the stipulation.
Second.
Okay, motion by Jay Jacobo, second by Adam Porath. Any further discussion? Okay, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion carries.
Jay Jacobo, for the record, I move that we revoke Raymond Graver's registration with a retroactive date of October 31st, 2024.
Okay, motion by Ms. Jacobo. Is there a second?
Adam Porth, second.
Second by Mr. Porath. Any further discussion? All those in favor?
Aye.
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 Any opposed? Okay, that motion passes.
I think as a final matter, you determine, you know, how long he has before he can submit a petition for reinstatement. So 1 year, anywhere from 1 year to 10 years.
1 year is fine.
Jay Jacobo, for the record, I move that respondent Raymond Graver's registration be deactivated for a period of, actually, how should I word this?
1 year from today's date?
Yes, 1 year for today's date before he is eligible for reinstatement.
Okay. Helen Park, I'll second. Any further discussion? Okay, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes. Does that complete that matter?
It does. Thank you, Madam.
Thank you. Okay, we're going to continue on to agenda item 5A, 5B. This is for Festus Ibanca. So we have representatives here. Good afternoon.
Good afternoon, everyone. Good afternoon, Madam President.
Right, so if I could have you both state your full name and titles for the record.
My name is Liborio Sawara. I am an attorney. I represent Mr. Festus Ibanca. Yeah, my name is Festus Ibanca. I'm a nurse practitioner.
Great. Mr. Ibanca, I'm going to swear you in. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Great, thank you. All right, Mr. Cant.
Rick Camp, for the record, prosecuting this matter on behalf of the state. These are two cases involving the respondent. First, we have case number 19-012-CS-S, a show cause hearing for respondent Festus Ibanca, APR and certificate of registration number CS 23430. In addition, we are also here on an accusation that was filed in case number 25-215-CS-S against respondent Ivanka as well. In your board book, you have the order to show cause beginning on page 3920 and the order that respondent is accused of violating or not complying with beginning on page 3924 of the board book. With regard to case 25-215, you have the accusation beginning on page 3931 of the board book, answer and notice of defense that was filed by the respondent through his counsel, beginning on page 3941 of the board book. And then you have several documents that form the basis for the new charges. And I guess I'll take you through that right now, specifically that the respondent was charged in federal court on several criminal counts. Once again, that charging document in the criminal action begins on page 3944 of the board book. The respondent entered into a plea agreement in that case, beginning on page 3951 of the board book. And then as a result of the plea agreement, a judgment of conviction was entered in that federal court case, beginning on page 3969 of the board book. With regard to the original order of discipline in case 19012, the respondent subsequently filed a petition for judicial review, and the Nevada District Court issued an order denying that petition and upholding the board's order. That order begins on page 3987 of the board book. The Nevada State Board of Nursing entered an order suspending the respondent's license to practice as a nurse. That begins on page 3994 of the board book. As a result of that, Board of Pharmacy staff issued a notice of suspension informing the respondent that the suspension of his license to practice nursing operated as an automatic suspension of his controlled substance registration with this board. That notice of suspension appears on page 4002 of the board book. I do want to note with regard to the accusation, the new accusation in 25215, a couple of things. One, unfortunately, the paragraph numbering was off, and I don't want it to create any confusion in the record. If you look at it, and that begins once again on page 3931. Jurisdiction, the paragraph is numbered 1, but then the factual allegations begin with 1. And then on page 3, when it lists the counts, count 2 is listed under paragraph 4. It's not numbered correctly. So when you get to the point where you're making findings of fact, conclusions of law, I'll guide you through that to ensure we have a clear record. But more importantly, and counsel for the respondent brought this up, with regard to the charge that respondent pled to in U.S. District Court, I state, I charged it under the factual allegations paragraph 2 that the conviction results from respondent falsely billing Medicaid for services that respondent did not personally provide and receiving reimbursement for those services. Counsel would like that the exact language that appeared in the criminal case to be stated. One, it was Medicare, not Medicaid. So if you look on page 3968 of your board book, the exact charge that respondent ended up pleading to is recited. And so I will amend the charging document to use this exact language and ask that you do so as well. So specifically, it was a conviction on a charge of willfully and knowingly did convert to his own use money from Medicare, an agency of the United States to which defendant knew he was not entitled, all in violation of Title 18 U.S. Code, Section 641. So with that, On the order to show cause, there were three bases for issuing the order. With regard to the respondents not complying with the original order entered in 19012. Two of those non-compliance of issues have been cured by the respondent. He has made payment of the attorney's fees in that case, and he has complied with the requirements for P&P training. The remaining issue is that one of the conditions of his stayed revocation in that case was that he not get any more charges filed against him. And with his plea in federal court on the criminal charge, he is not compliant with that. And so we are here both on that basis and then the new charge on 25-215 that his conviction in federal court on the criminal charge forms a new basis for you to discipline him. That's all I have in terms of the opening.
Okay, and with that, then I'll turn it over to Mr. Aguara.
Thank you, Madam President. I wanted to add to what Mr. Kent just said. I believe, and correct me if I'm wrong, at the last hearing in Las Vegas, council notified the board that my client had not complied with either of the two conditions imposed when he was placed on probation. As a matter of fact, that statement was inaccurate. He took both classes within 4 months, this board's order. It was the money that he somehow forgot to pay, but he has paid that. And I wanted to set the record straight. It's not like he ignored the board's orders until the last hearing. No, he had already taken the classes before the hearing in Las Vegas. Number two, Ms. Kent just stated that I believe case number 19-012-CS-S, that the condition, one of the conditions for the probation was that he not pick up new charges. He didn't. If you recall, and I brought the transcripts from when he was placed on probation, the case in federal court was brought up by Mr. Kent to the board's attention before the board voted. And since that date, he hasn't picked up any new charges. It's still the same federal case that emanated from back in 2018, I believe. Okay. That case has now been resolved. He pled to a misdemeanor. And for those of you who are familiar with the federal system, misdemeanor in federal court is the equivalent of basically saying we don't have a case. They rarely give misdemeanors. And I've been practicing for about 25 years in Nevada. I've never seen the feds give a misdemeanor. This is the only case where they, and I'm aware of where they gave one. And as one of these lawyers in that case, I can represent to you that when we presented the actual offer of resolution to the federal court, federal judge, she initially rejected. And her point was, how do you, in the charging document, allege, the amount of money you're talking about, and now you resolve it for $6,500. This case was resolved for misdemeanor, and the conversion amount was $6,500, which has been paid by my client. Basically, we got to a point where the prosecutors just told us, listen, if we dismiss this case, we would have to answer questions because of the resources that they had put into it. So I wanted the board to understand that in spite of, because I believe what the new case concentrated on is the charging document, the indictment. That indictment was dismissed for the new plea of a misdemeanor, okay, to be accepted. The government had to dismiss the initial indictment. And my concern with the language I saw in the two cases before you was that the language was taken from the original indictment, which ended up being dismissed. So the resolution, which I believe correctly read, is for.
Counsel, I just amended the charging document to reflect the actual language of what your client was convicted of.
I'm agreeing with you. I'm just giving the board a context.
You've amended the charging document. There's no prejudice to your client at this point in time.
I understand that. I'm agreeing with you. I mean,
Okay, let's continue moving forward.
okay, thank you. The only other thing that I wanted to add that I need to stress is that he hasn't picked up a new thing. And counsel will agree with me that the federal case was pending, okay, at the time that he was placed on probation. And there is not that, if anything, that case that was pending at that time was dismissed. Okay, the charges were dismissed and he pled to a misdemeanor. So it's basically the case was lowered to a much, basically a misdemeanor, and you guys know what a misdemeanor is. So I'm not going to go over that again. The only thing I asked the board to do is to take that into consideration that it's not new. The board was already aware of, even before you voted to put him on probation. And the misdemeanor plea is the reason, I guess, that counsel brings up the new case, because it's a conviction, albeit a misdemeanor. And what we asked the board to do is to follow what the nursing board did. They looked at it, and they decided, okay, 6-month suspension would be adequate. That's what they did. That suspension will be up next month, I believe in May. So he will have his nursing license back. And he hasn't picked up anything new since the last time you guys disciplined him. That's really what I wanted to stress.
Thank you. I'll turn it back to Mr. Cant.
Well, as clearly stated in the charging document, under NRS 639-210-7C, one basis for the board imposing discipline is, quote, conviction of a crime involving moral turpitude, dishonesty, or corruption. So that's the basis that I'm alleging discipline today, not, it doesn't matter, it's a misdemeanor. And associated counts for unprofessional conduct, and commission of acts that render registration inconsistent with public interest. In terms of putting on evidence, you have all the documents. You can take judicial notice of the criminal conviction and act thereon. So I have no other witnesses or evidence to present. I do have a memorandum of attorney's fees and costs in the event that you do impose discipline that you may recover pursuant to NRS 622-400. I have provided that accounting to counsel beforehand in the event he wishes to challenge it. But other than that, I have nothing further at this time.
And Mr. Aguara, do you have anything else you'd like to add at this time?
Just a question for clarification. So counsel, I want to make sure we're on the same page. And I want to make sure that the board is informed correctly. So are you saying that the charge involving picking up the new charge, are you withdrawing that charge and just proceeding on the conviction?
I'm not withdrawing any charges. I've amended the charging document to state the crime specifically as it appears in the federal record. But I'm not dropping any charges.
What I'm asking though is, do you agree with me that that's not a new charge? The case was already pending when he was placed on probation and it was brought to the board's attention.
Let's go through the status of the respondent's license, his registration. He received a stayed revocation in probation with terms in an order entered by this court September 4th of 2024. One of those conditions was that he have no new charges brought against him and he complied with all applicable laws. He subsequently pled and was convicted of a crime in federal court. So he's subject to a lifting of the stayed revocation and facing outright revocation of his controlled substance registration. That's why we're here. In addition to that, his registration is suspended because he doesn't hold an active license to practice nursing, which is required for him to be able to hold his controlled substance registration.
And I understand that if you rely on the conviction and the fact that he has a suspended nursing license, you're not going to get an argument from me. My issue is the language you keep using as one of the conditions of the probation, which is that he wasn't supposed to get a new charge. Okay, and what I'm trying to explain is that he didn't get a new charge. He did get convicted of an existing case, which was lower. Okay, he got a conviction out of that. And if that's the ground for why we're here, you're not getting an argument from me.
If I can hold you for a second, I think these discussions are for a different time. I think you've made your case. I'll turn it to Todd to kind of help the board. Brett can't be a witness, so I think Todd was probably going to jump in, but he wasn't a witness. So Todd will give you some, I think it's in front of the board to make a decision and you've made your case. So you don't have to, you have to prove it to the board, not to Brett, so.
Senior DAG Todd Weiss, yeah, this one's a little bit unorthodox because we don't really have a factual dispute. It's pretty much a strictly legal interpretation dispute. This board has to figure out. So I just want to make clear, your counsel, you don't have any witnesses or exhibits or anything other than what's.
So I do not.
Okay, so if I understand this correctly, and if I'm confused, let me know, but the question before the board now is whether your client violated the terms of probation by the misdemeanor plea in federal court. You're saying it is not a violation of probation. Brett says it is a violation of the probation, which would make the stayed revocation put into effect. Am I missing any other dispute, or is that it? What's before?
And for the record, I submit it's a violation of the terms of his probation in case 19012. Secondly, that's why I brought a separate charge in case 25215. It's an independent basis for you to take disciplinary action against the respondent.
Yeah, so I think the board will find findings of fact on each individually, and then that'll drive your path.
Yeah, I agree.
So do you want closing arguments or?
Any closing statements?
I have nothing further.
Okay, Mr. Aguirre, any closing statements?
Just a clarification, we're not saying that the conviction is not grounds for whatever the board wants to do. I'm just saying, I was trying to correct the record. It's not a new charge. It was already existed when he was placed on probation. I don't know what to tell the board, except that he hasn't done anything since you placed him or disciplined him and placed him on probation. He hasn't picked up a new charge. The only thing that he has done is resolve a case that was existing at the time that you placed him on probation. He resolved it in a way that was largely favorable to him by agreeing to plead to a misdemeanor instead of the 13 felonies that were charged. The government had no evidence of those. And on a procedural matter, and I'm glad that council amended the charges on the record, because we came in here believing that this proceeding would go forward on the language that has now been changed. To the extent that the board decides to impose additional discipline, I just want the board to keep in mind that it's not a new charge. And to keep that in mind, and also to take into consideration the action taken by the nursing board. That's the only thing I have to add.
Okay, thank you.
Thank you.
All right, I'll turn it over to the board.
Yeah, and let me just, let me tell you what I feel about this.
Sure.
It appears, Counselor, that Mr. Ivanka committed the federal crime that you're talking about. I think you're talking about the Medicare crime. In September of 2018, he was indicted in July of 2022 for that Medicare fraud. We took his, we put a stip on him, or that he's talking about in September of 2024 about we put him on probation in 2024. My question is, did he commit another crime after September 2024 to violate his probation? Or are you talking about the crime he committed in 2018? That's my question. Well, what else did he do after 2024? Do we have another charge?
Brett Camp for the record. So during the hearing in 19012, it was acknowledged that he was facing prosecution in federal district court.
Right. He was
that criminal case was pending when you entered the order on September 4th, 2024 in 19012. He subsequently, pursuant to a plea agreement, was convicted in that case on a single misdemeanor count.
Right.
But that was subsequent to the order you entered. So it's an independent basis for you to take disciplinary action against him, in addition to being, in my opinion, a violation of the terms of probation granted in the stayed revocation in case 19012.
If that's the case, what you're saying is he got convicted of it in 2025 is when he convicted him, after we already put him on probation. He got convicted of the crime he committed in 2018. Well, if that's the case, if you're saying that this is our basis for saying he broke his probation, then why didn't we, because I knew about that case and when we did this in 2024, I knew what happened about Mr. Ivanka. Why didn't we just say that then? Why don't we say, listen, we were on probation, but if you're convicted of the case that's pending, that's it. You broke your probation. Why didn't we say that then? We didn't, because we already knew that he was already under indictment. He was under indictment for that.
Yeah, he could have been acquitted. I mean, you knew what the outcome was going to be in that pending criminal case at the time that you entered the order.
But if we wanted, my feeling is if this board was going to tie, wait a minute, if this board was going to tie in his 2018 crime, we should have tied it in then, not now, because the way I read this is if he committed something after we put him on probation, he didn't. He committed it before we put it on probation. The fact that he was convicted of it or wasn't convicted of it, I don't think you should pay the penalty for that.
You have the basis. Hold on a second, be quiet. You got to go back to him because he needs a chance to rebut it. Everything you're saying can be true, but it's not a dialogue between you and Brett. We have the rules. Everything you're saying can be true and you can say it, but we have to go back to him because the question was asked to Brett and he has an ability to respond.
Right, so with that, Mr. Aguara, if you'd like to respond.
The short answer to the board member's question is no, he did not pick up the new charge. He just resolved that existed 2018 case, which was filed in 2022. He resolved it. He didn't pick up anything new after you put him on probation. It's still the same old case.
This is Senior Dag Todd Weiss. I think I can help guide the inquiry for the board here because this is almost a strictly legal question about compliance or non-compliance. So I know the non-lawyers in this room are gonna absolutely groan out loud when they hear this, but it's gonna come down to what language in the order. And that's like trying to post hoc what the intention was is not, we're not gonna do that here today. So Brett, could you please read us the term of the probation that you are alleging he violated, and I will give a recommendation based on that.
Certainly, just give me a minute to look it up. This is the order that you entered September 4th, 2024 in case 19012. It begins on page 3924 of the board book, and the discipline you imposed begins on page 3927, in which you revoked his certificate of registration CS 23430, and in quote, the revocation is stayed and respondent is placed on probation for a period of 3 years pursuant to NRS 639-255-1B, subject to the following conditions. Subparagraph A, pay $4,268.79 to partially reimburse the board for recoverable attorney's fees and costs. Subparagraph B, respondent shall complete 2 hours of training from board staff on Nevada Prescription Monitoring Program PMP compliance by September 4th, 2025. Subparagraph C, respondent shall complete 2 hours of continuing education on ethics by September 4th, 2025. And then finally, subparagraph D, respondent shall comply with all federal and state statutes and regulations regarding controlled substances and dangerous drugs and have no additional charges filed against him while on probation. Upon successful completion of probation, respondent's certificate of registration number CS 23430 will be fully restored. So that subparagraph D, when it says have no additional charges filed against him while on probation, that's administrative charges. That's what we're talking. We're not talking about criminal charges. We're talking about he doesn't get charged with additional violations by me, by the board staff. So that's what, when he got the conviction in the federal criminal case, that made him subject to discipline under NRS 639. Sorry, NRS 639, 210, subparagraph 7C, which says the board may suspend or revoke any certificate, license, registration, or permit if the applicant has been convicted of a crime involving moral turpitude, dishonesty, or corruption. So when he entered into the plea agreement and got convicted for the Medicare fraud, defrauding Medicare, he became subject. It's an independent basis, a new basis for you to take disciplinary action against his registration.
Right, is that conviction language actually in the order?
I'm sorry?
Is that conviction language in the order? Does it say shall not be convicted of a new crime?
No, it just said
should not get another charge.
If you go back to the order. Just say comply with all federal and state statutes and regulations regarding controlled substances and dangerous drugs and have no additional charges filed against him while on probation.
Okay, that's what I thought, but I had heard you mention convictions before. That would be a different animal. If it said you cannot give any more convictions, he was not convicted at the time of the 2024 decision, so that would have been a different story, but that's not what it says in the order. And I feel like, to be fair to all sides, we have to abide by the language in the order. And I understand you're telling me what your intent was, and it was being too administrative, but it's not really clear. It's hard to resolve an unclarity like that in favor of the board versus the licensee. Based on that language, my recommendation would be that the violations of the probation have not been violated since the charge in question was pending at the time of the 2024 board decision. But that's just my recommendation. The board can rule as they see fit.
So this is Helen Park. The way that I am reading the language from the previous order. I think what we're doing is, it sounds like there's confusion regarding like the charges being criminal charges or administrative charges. I don't read it as any additional convictions. It's any additional charges. And then when the respondent was convicted of that misdemeanor, that then started this administrative charge, which is a new that's new information. That's a new occurrence that has happened. It's tied to what happened before, but that conviction is new since that order was put in place. So I think, again, this is an independent basis to move forward on. That is how I interpret it.
Madam Board, for the record. So current status of his license is it is under a stayed revocation. But the separate action is that his APRN license is currently not active. So he can't have a controlled substance license right now until that matter is resolved. So the basis of whether or not we want to make his revocation active, I think is up for debate. What is not up for debate is that he is currently not eligible for a controlled substance license. So I think until that gets resolved, I guess I would argue that we keep his license or revoke his license until he has an active APRN license. And then we can go from there and have him reappear.
And a car for the record, I think, if I'm not mistaken, that his counsel said that his license is active next month, though. Is that correct?
That is correct. The 6-month suspension will expire next month. And I also, I believe, Brett, there is sort of a reciprocal automatic suspension by this board by virtue of his nursing license being suspended. So his DEA, okay, his registration is currently suspended by your board because of the nursing suspension.
Dave Weiss for the record. I think that you're going down a great path and you need to go down your, the issue that he's saying that it's going to be off, we don't have that in front of us and there's a process to that with the nursing board. And I'm not saying it's not true, but that we don't have that in front of us. So I do think like Adam's path of revisiting it in front might, then that gives them the opportunity to bring you back the documentation that it's it, and then you can address anything that's happened in the meantime that you want to apply to whatever conditions of licensure.
Rick Camp for the record. If I could just add, the law doesn't permit you to issue an indefinite suspension. And so the law provides for automatic suspension when the primary license is suspended, but then you have to address it at some point. You can't do an indefinite suspension. That's really a denial of due process. And so whenever you suspend a registration or uphold a suspension, you have to specify a period. So the notion that we can just have him indefinitely suspended as long as his nursing board license is suspended is not, I don't think, legally sound.
I don't think that's not discussed here. It's he can always come back and talk to you and say, I've settled all these things up. So you would put, to Brett's point, you have to put, if you're going to go down that path, you need to put a time frame, but you can also put conditions on that if he were to get his other license, that he could reapply at that particular time.
Do we need to take action on the show cause now?
It's for us, not for him. He's
The order of show cause did he or did he not violate the terms of his probation previously? The two things are kind of tied, but they're different. They'd have to be different votes, and it's confusing as that's going to be. So I think we need to resolve the probation question first. and then move on to what are we gonna do about his nursing license being suspended. Those are two different issues, both related to the criminal issue, but gotta take separate votes.
Let me just say this. Let me say this before you vote on anything or make a motion. You members of this board, did you know, be honest, you don't have to answer out loud, keep it to yourselves. Did you know that when we put him on probation, that was only if he didn't commit an administrative crime, not a criminal crime? Did you know that what Mr. Kane said? I know what your answer is. You don't have to say it. And the fact that our deputy AG said the word conviction wasn't in there, I'll tell you what, I didn't know it. I knew that he was indicted. When we put him on probation, I knew that he had been indicted for that Medicare thing. Well, when I put him on probation, just in the language, I thought just from 31 years in law enforcement, when a person's put on probation, it doesn't mean if something happened 2 years ago, if they got caught doing it, it counts now. Because you're setting somebody up, it's a trap. That's all it is. It's an unethical trap. And I've never seen it happen before in 31 years of my law enforcement career. So if you're going to say that he violated it because he admitted that he did it back then you set him up unethically. That's my feeling about it. So you better think about this, board, before you say that you knew that you knew that didn't count. That, yeah, if he was convicted of that after, well, you knew that when you put him on probation. Okay, I've had my say.
Thank you, Mr. Tomaso. All right, board members. I think our matter at hand is the order to show cause.
Just procedurally, you can have a discussion. Dick started the discussion. You can have a motion. Dick may want to make that, and then you can go from there.
Sorry, Adam Porth for the record. But within the order to show cause, it does discuss the matter of the State Board of Nursing order. So that's where I'm a little bit confused. It's like both items are combined there.
The title will help you. I think it's an up or down on the show cause. The other part doesn't relate.
You know, if the show cause order is tripping you up, you don't have to do anything on the show cause order. You can just focus on 25-215 and the new charges that I brought.
I mean, yes, they do have to give a up or down on the show cause order. It's before the.
Well, yeah, say we're not finding violation of the original order and we're moving on to the new charge. I didn't mean to confuse the issue. Part of the reason I issued the show cause order was because he hadn't paid sizable attorney's fees and costs award that you had entered, and he hadn't done the PMP training. But
he's done both of those now. He's done both of those.
Has he done the training and paid all of his fees?
That's correct.
Current on terms?
Yes, he has.
He subsequently did that in response to the show cause order, which is part of the idea of the show cause order is it can motivate compliance.
That's not entirely accurate. He did the classes within 4 months of the order. That was before the show cause order. Now, the money, the attorney's fees, he paid after you issued the show cause order. But he did the classes before.
He hadn't presented evidence to the board staff that he'd completed the PMP training. But we don't need to get caught up in that now. The fact of the matter is he's complied with those requirements.
Jacobo, for the record, I make a motion that we find Festus Ivanka not guilty of violating the terms of the probation pursuant to the order to show cause.
I can make it a little more simple for you. We can just vote to deny the order to show cause. It's simple.
You doing the vote now? Oh,
Need a second.
I second it.
Okay, so there's a motion by Mr. Jacobo, second by Mr. Tomaso. Any further discussion? Okay, all those in favor? Aye. Any opposed? That motion passes.
Jay Jacobo, for the record, I make a motion to make findings of fact and conclusions of law consistent with paragraphs. Can you help me with the page number? Sorry.
I'll walk you through that. Brett Camp for the record. Once again, I apologize that the numbering was off. And I got to get back to the charging document, page 39, 31. So first I would ask that you make findings, find that you have jurisdiction and make findings of fact consistent with paragraphs 1 through consistent with paragraph 1, and then as I amended it, instead of paragraph 2 and the factual allegations, that you would we'll use the language that appears in the plea agreement, which is on page 3968 of your board book, that quote, he willfully and knowingly did convert to his own use money from Medicare and agency of the United States to which defendant knew he was not entitled, all in violation of Title 18 U.S. Code Section 6. Jurisdiction in those two findings, I would ask.
So moved.
All right, so we have a motion by Ms. Jacobo. Do we have a second?
Second.
Second by Ms. Carr. Any further discussion?
Now, what does that mean? Tell me what that means if we find that, if we vote yes to that. What does that mean?
That'll help you.
Mr. Ross, are you asking if we make findings of fact? Law?
Yeah, what does that mean?
So this is a finding that the criminal plea is a violation of our regs. It's a violation of federal law.
Not as probation.
No, this is separate from the probation issue.
Just to be clear for the record, Mr. Tomaso, the probation issue is dead. You're just dealing with what they said today is that he pleaded guilty to the misdemeanor.
All right, any further discussion? All right, all those in favor? Aye. Any opposed? Okay, that motion passes.
Next, I would, Brett Camp for the record, ask you to make conclusions of law consistent with paragraphs 3. Well, yeah, this is where the numbering gets a little goofy. The applicable law paragraphs as stated in paragraphs 3 through 7 of the accusation, and find the respondent guilty on all 4 counts set forth in the accusation, once again amended to reflect the language from his plea agreement.
So moved.
Okay, motion by Mr. Jacobo. Do we have a second?
Anna Carr, second.
Second by Ms. Carr. Any further discussion? Okay, all those in favor? Aye. Any opposed? All right, that motion carries.
Next, if you're considering imposing discipline, I would like to have this memo of fees and costs incurred in this new action, 25-215, entered into the record as Exhibit 1 and passed out. Should give him a copy too. Thanks.
Mr. Agora, have you had a chance to review the memo?
Yes. He actually emailed these to me prior.
Any objections?
No.
Thank you. Okay. Mr. Cant?
Will be entered as Exhibit 1.
Oh, yes, so admitted as Exhibit 1.
So then, with regard to disciplinary actions, certainly if you're going to impose discipline, I would ask that you award the attorney's fees and costs in the amount of $670.37 as reasonable, necessary, and actually incurred. A fine may be appropriate, and you need to decide whether you want to maintain the stayed revocation or impose some other status on his registration. And we do have the issue of the status of his APRN registration, since it impacts his ability to hold the controlled substance registration.
Or do you want to attempt a motion?
I was gonna say, does board council have a recommendation?
Pardon?
Do you have a recommendation for discipline?
Yeah, I do. I think, just to be clear, Dave Weeks for the record, you have in front of you, something that you were not able to consider at the last meeting, which was he came in front of you, that indictment was not a conviction, and it's now a plea that turns into a conviction. So that's really what you're weighing on the license. And I think what Adam already said from board staff is to keep it revoked, set it for a time that you're comfortable with, but tell him that that he can come back when he settles up with the nursing board. Then at that particular time, then you can really waive this part of that condition of that, or alternatively, you can just waive it now. If you were to come in with with this type of thing related to Medicare fraud, you've seen it before. That's a couple years of suspension on the controlled substance license, not related to the probation. So I think those are the two paths that I would recommend. If you want to say you want to just go with the nursing board, then do that. Or if you want to just do this, it would be a 2-year revocation that we would typically recommend on that. And I'd give him the opportunity to rebut what I just said.
Let me just add, I'm sorry, Brett Kemp for the record. So operationally, we were talking about suspensions. The law does provide that if you suspend, you have to suspend for a specific period, but then the law also provides that the individual under suspension can petition you at any time to have the suspension lifted. So if you're trending in that direction because of the status of his APRN license, you could suspend it for a specific period, because then if he gets his APRN license back, he can always come back to you and petition for reinstatement.
The board staff's recommendations is 2 years based off of the pleading guilty of the misdemeanor Medicare fraud. He's certainly done longer, but he's already been some time without his license.
So Adam, for the record, I guess what I'm struggling with is that he currently doesn't qualify for the license that's suspended. So how can we continue to suspend a license when he no longer qualifies for it? I don't see any other path than to at least revoke it for a period of time until.
Yeah, I think you need to revoke it. But I'd like to get, as far as what the conditions or what the punishment would be, do you have your own recommendation for the board?
But I mean, what we were hoping the board would do is to continue the revocation, the state revocation, that because the criminal case was resolved on grounds that were very less serious than the regional charges, 6,500 compared to 20-something million that the feds charged, that turned out not to be quite what it is. And the conviction says conversion. And as some of you may know, there's a difference between theft and conversion. One involves money that you shouldn't even have with you, let alone keep. The other one is money that you rightfully held, but somehow you believed that it was yours and you should have known better, but then you used it. He has since paid that back. The federal court did not issue a fine. They just told him, just pay the $6,500 back. it back immediately, and that case ended. And with that in mind, what I was hoping that the board would do is say, hey, listen, yeah, you haven't picked up a new charge and you resolved an existing charge in a way that's favorable to you. Okay? Just stay out of trouble. We're going to keep you on this so that, you know, if you get in trouble again while you're doing this, then we're going to come down. And now, this is the first time he's been, the last time you disciplined him, it's been the only time he's been disciplined since he's been practicing. He's never been before you before, since then for a new charge. So with that in mind, we would request that the board consider keeping what was already there, which is, you know, your license was revoked, state the revocation. You've had this misdemeanor conviction. We've looked at the circumstances. We're going to keep your license revoked and keep the revocation stayed. Stay out of trouble. Okay, and that's just what we hope the board will consider doing.
Thank you.
Thank you.
For the record, I will note, if you're inclined to suspend, I would probably recommend that you suspend until renewal. So that's October 31st. Is it this year or next year?
Sure.
So yeah, that would be October 31st of 2026 would be the end of the biennial period of his current registration. And then if he wants to apply for renewal, he would have to present proof that he qualifies, that he's got his APRN license active and in good standing, so on and so forth.
Do you need me to restate our two recommendations, or do you have them?
I'd like to hear what the other he had on the recommendation, but how did you tie it into the nursing board? What was that? What was that?
So currently, he doesn't have an active APRN license. That's, you have to have that in order to qualify for a controlled substance license.
Right.
And so until he has an active APRN license, he no longer qualifies for this license. So I'm just having a hard time saying that we're gonna suspend or put on probation a license that
He doesn't have.
Yeah.
he shouldn't have.
Well, I think Counselor too said stated revocation, you know, he recognizes that it has to be a revocation.
Yeah.
So I'm trying to reconcile with the original probation terms, because it was 3 years.
If you can talk to Todd, please.
Sorry, Todd.
Well, yeah, anything you enter today is going to supersede the previously entered order, but I'll let Todd confirm that.
This is Senior Director Todd Weiss. That's correct. There's generally not going to be concurrent disciplines going on. So especially because that was a stay, whatever discipline you put on for this is going to override that.
Because if it was under the original terms, let me not look at Brett. The original terms of the probation, it would have been through September of 2027. So I don't want to shorten the term. Speaking to my other board members, I don't want to come across punitive for something that we've already addressed through the original terms of the probation. My feeling is that I would just want to continue the terms of the probation.
Yeah, just safely. So you did not address it because the conviction was not done at that time, and now you're fighting the conviction. You can do what you're doing, but you did not address it at that time. There was testimony that there was no conviction at that time. The conviction came afterwards, and you found him guilty of the conviction. Just to set the record straight.
For the record, I guess the only thing that I would want to address in that is that if there is a potential that the nursing board does not reinstate his license. And so I would want to make sure that our order would match that it was the state revocation for the remainder of the previous. And that in order for that to be lifted, you would have to meet the qualifications of licensure, but I guess would be handled. But
It's baked in.
it should be, but I just want to make sure.
Hey, Dave, question for you. His license is currently under summary suspension because he doesn't have a nursing registration. Is that correct? Right. So until that changes, he's gonna be on, his license is gonna be summarily suspended anyway, and that's not gonna change until his nursing license is reinstated, so.
Yeah, just procedurally, he would have to reappear unless, I mean, there's no path for us to grant it without him reappearing at that particular time.
You guys good with the original terms of the probation?
Ban on state revocation through.
Yes.
Okay.
I didn't hear that, so just make sure when you're saying the motion, it's clear.
So I moved out, we find, respondent Festus Ibanca, guilty and find him,
We already took it.
Oh, sorry.
We're on the discipline part.
This is just what discipline you are.
attorney's fees and costs, that they are reasonable, necessary, and actually incurred in the amount of $670.37 payable and due within 30 days of today's date or date of the order.
Tack on the order's effect, whatever you're doing is.
And order is effective immediately. And that, respondents, controlled substance registration is still revoked and the revocation is stayed, and we're going to continue the terms of the original probation as stipulated in the September 4th, 2024 order. And that was for 3 years from that date, which means September 4th, 2027.
All right, we have.
Discussion, I have a question for Todd. So if they're doing that path, then do you see that revocation is stayed and he just goes back in the suspension model? I'm not sure what the state of the revocation serves a purpose, and it may, for the world, we might not be able to define this when they look up his license or whatever. So I'm just giving that to Todd to think about. So back to Adam's point, you're revocating, but you're staying to what are you staying? He doesn't have a license. If you could just help the board with that.
Yeah, and to follow up on that, I once again, Brett Camp for the record, I would ask that you then suspend because he doesn't.
And Brett, just let Todd answer the question, please.
Qualify. Sorry, I would, if you're inclined to maintain the status quo, just say that his registration is suspended through October 31st of this year. And then if he qualifies to renew it, he'll renew it. If he gets his APRN license back next month and he wants to petition to have you lift the suspension, he can do that.
So Senior Dag Todd Weiss, so the way I understand what would happen is if the board continues the stayed revocation from before, his license will automatically go back into, his registration will automatically go back into good standing once his nursing license is rectified. There would not be a requirement that he have to appear again to get his registration back, which I believe is why Dave and Brett are asking for a suspension, because the way it operates right now, his license will go back into, his registration will go back into effect as soon as his nursing license is rectified. The stayed revocation is essentially a probation. It doesn't impact the current standing of the license, if that makes any sense.
Madam President.
Oh, yes, Mr. Guara.
I'm diabetic. I have to run to the restroom right quick, if that's okay with the board.
We'll take a break.
Take a quick break.
Thank you so much.
We are back on. We're back on 5A and 5B for Festus Ibanca. And then Senior Dag, do you want to make any additional comments?
Yeah, I just want to clarify. So, I mean, as you all know, he does not have a license currently. It is summarily suspended. His registration is summarily suspended because he doesn't have his nursing license. And that will be the case until he gets his nursing license back. So I think that's why you're hearing the recommendation for a revocation and suspension versus a stayed revocation, because currently there's no license to stay a revocation on. So, because of that kind of added wrinkle to everything, it may be easier to do a short-term suspension or revocation, forcing him to reappear before the board demonstrate that his nursing stuff has been rectified and that he's, eligible for a license. And at that time, if the board wants to continue the previous probation requirements until 2027, we can do that. And put that condition on the license. So based on that and based on what I'm hearing from Dave and Brett, what I would recommend is a suspension until the time of the renewal date in October. And requirement that you have to appear to renew his license at that time.
Mr. Aguara, just wanted to give you an opportunity to also comment.
Thank you, Madam President. My only input would be to, because I'm trying to reconcile, if there's no active license to revoke, then is there one to suspend? So I don't know. I mean,
Dave Weiss for the record. I think we can revoke a license that was obtained at a period. The issue is we don't have a way of really in the licensing software to tell the world what happened. So to be very clear in this instance, if they choose to revoke or suspend till the renewal period, then he either meets a condition and renew and it comes back and tries to renew it at that time, which they'll come in front of the board. Or like I told you already, if something happens before that makes him qualify, then we'll put him on the agenda for that, and then it can be addressed at that particular time. So this is really just a procedural for what we have the ability to be able to do when we're listing it. We can't list two things on the software. They have to pick the way that they want to go.
So let me make sure I understand what Mr. West is saying. So if the board suspends till October and he gets his license for the APRN license, say next month.
I'll put him on the next agenda when he notifies us in a proper fashion.
Okay. So the suspension is really not the punishment for the conviction. It's just
It's discipline related to the cause that they found him guilty of, which goes back to his misdemeanor pleading. So it is discipline. It will be reported as discipline.
Board members, are we ready to make a motion?
I'm still
We need
confused.
to withdraw the previous one.
Oh,
And also if we're suspending and then in October, in my mind, I understand he has his nursing registration reactivated and then he's eligible, but I feel like he's still under the terms of the probation.
I can help you with that a little bit, just procedurally. You do it till the renewal period, because then it goes away at the renewal and he'd have to reapply at that particular time. So that's the advantage of doing it to the renewal, because then it doesn't leave anything in limbo. So if something comes before, he'll come in front of you. If something comes after, his license will terminate because of non-renewal. It'll still say suspension on the website, and then he has to reapply at that particular. So it gives him a path forward either way. Does that make sense or does not make sense?
I'm not gonna lie, say it makes sense.
It makes total sense to me. I'll let Yen try to explain it one more time if she wants.
I think ultimately when he reapplies again for his controlled substance registration, he will have to appear before the board and you can impose any kind of conditions on his license, including a probationary status.
Or not grant the
Or
license.
not grant the license. So we can address it at that particular time.
So that means he would have to come here in October.
I mean, if that's what he chooses to do, apply again, yes.
Yeah, just to help, if what happens in May happens, then he can contact us and then we'll put him on the agenda at the next meeting after that. If it happens and he doesn't want to get his controlled substance at that time and he wants to wait till he renews and then he wants to try to renew his license, then he can come in front of you in that time. And if he wants to wait even longer, by his choice or whatever, then when he comes in front of you 2 years from now, he'll reapply and be in front of you. It just makes a very clear path for him to get back in front of you.
Why don't you make the motion, Yan?
Can I ask a question, please? So he can come back before October.
Absolutely. If he
gets his license.
we're going into the depths here. If he comes back and he doesn't qualify, I'll have a conversation with you that he doesn't qualify and I'll put him on the agenda, but it's unlikely that he'll get his license. So that's your choice. If he does come back and he qualifies, we'll put him on the agenda and the board will address it at that particular time.
So is the motion just as simple as to move that the Mr. Ivanka's certificate of registration for his controlled substances suspended until 10/31/26?
Second.
All right, so motion by Helen Park, second by Ms. Jacobo. Any further discussion? Okay, all those in favor?
Aye.
Aye.
Any opposed? That motion passes. All right, is there-
We're available to talk to you afterwards.
Thank you so much, madam.
Thank you.
Thank you very much, madam. Thank you.
All right, we're gonna move to our next agenda item, and that is gonna be 7B for Montgomery DME. So if we have representatives here.
No, we got Giselle.
Oh, I'm so sorry. We do have one more.
Giselle's been waiting patiently all day. You can't skip her.
Okay.
Come on up.
Agenda item 5AA for Giselle Ashley Gonzalez. And then afterwards, we'll do Montgomery DME.
Madam President, I'd like to recuse myself from this item as Giselle is currently employed by Renown.
Okay, so we'll note for the record that Mr. Porath has recused himself from this matter. Hi, good afternoon.
Good afternoon, Madam President, and Wolf.
If you could state your full name for the record.
Sal Gonzalez.
Okay, and if you could join me. Do you swear that the testimony that you're about to provide will be both truthful and complete? Okay, great. And then with that, I'll turn it over to Mr. Cant.
Brett Camp for the record. This is case number 26092, PTT-N, Giselle Ashley Gonzalez, PTT, certificate of registration number PT 28532. Charges begin on page 4517 of the board book. A cease and desist was issued against the respondent. That's on page 4525 of the board book. We have also included a copy of her original application for registration as a pharmaceutical technician in training that begins on page 4527. And then finally on page 4530, the respondent has submitted a statement. And so just briefly, the respondent falsely represented on her application that she was a high school graduate or the equivalent, and she was issued the registration. It was recently determined by board staff that she was not a high school graduate or the equivalent, which is a statutory a regulatory requirement under NAC 639-242-1B. And that's why the cease and desist was issued. And that's why she's before you today on the 2 counts. I do believe Ms. Gonzalez has some documents that she wants to provide to you that I've stipulated to their entry into the record. One is evidence that she recently just did complete her GED. 2, I think she has some character references. So I know she wants to address you and you'll have questions, but I did want to say we wanted to provide that to you.
Okay, great. Thank you. So Ms. Gonzalez, you want to make your opening remarks?
At the time, I sought advice from a leader in regards to the situation with my education and was advised to say yes, so that's why I'm here. And so I was in the process of getting my education further, which I did complete, just took a little longer.
Madam President, I do have the exhibits that the respondent would like for the board to consider for.
Okay. Yes.
But tell the board what you brought in for them to look at.
I brought my proof of that I passed the tests for the high school equivalency certificate and along with some professional reference letters.
When did you earn that?
Just yesterday.
And again, if you'll give her a copy, just so she knows, I see she doesn't have one, so.
So since there's no objection from Mr. Cant, we'll add it as Exhibit 1. Ms. Gonzalez, did you want to add anything, any other information about the documents that you provided? Okay. All right, then I'll turn it back to Mr. Cant.
Okay, so procedurally, what we have discussed, so it's almost like a stipulation, but we're in a hearing here, is that, Ms. Gonzalez recognizes that she didn't qualify to hold the registration number PT 28532. And in fact, NRS 639-281 subsection 2 says any license or permit issued by the board on information later found to be false or fraudulent must be automatically canceled by the board. That's what we're going to ask you to do today. Is pursuant to that, you're going to cancel her registration PT 28532. And then that also enables her to reapply for a registration on the basis that she now qualifies, that she holds the GED. So I don't want to get too far into findings of fact, conclusions of law and all that. I want to give her a chance to make any further comments on the resolution and or answer your questions.
Ms. Gonzalez, did you want to make any additional remarks based on what Mr. Cant just shared with us?
Do you have any witnesses that you want to bring on your behalf? You don't have to. Okay.
I believe in terms of her new application,
Yeah, I'll talk about that.
I Dr. Long had some requests she wanted to make
I just,
on that.
before you get that, I just want to tell you that I have a rule where I separate license from discipline, and you guys know about that. But Yen wants to talk to you about a path forward. It won't be part of your, it doesn't have to be part of your, what you find, but staff has questions related to it.
Yeah, thank you, Madam President. Yan Long for the record. I would like to request board to permit board staff to process a new application submitted by Ms. Gonzalez without her needing to reappear before the board regarding this particular matter. And I would also like to request that the board accepts the 1,500 hours that Ms. Gonzalez had acquired during her time when she was practicing as a pharmaceutical technician training, in light of the fact that we do have a public hearing tomorrow that does change the qualifications for a pharmaceutical technician in training. So those are my two requests as well to the board members.
And Yen can run you through that tomorrow. I guess it's mine, so I will. If that were to pass, she would have qualified to earn the hours. And so we're at this point, and again, we're asking you to tell us what to do. She can apply for tech and training and she would qualify for that. She also can apply for a tech if you say it's okay that we count the hours. So we're just weighing that the hearing that you have tomorrow, and you'll tell us which way to go.
Thank you.
So with that, if you want to proceed forward, I would ask that you find that you have jurisdiction and make findings of fact consistent with paragraphs.
If we can just have a closing statement before. Do you want to say anything else to the board? Okay.
Once again, I ask you to make findings of fact and find that you have jurisdiction consistent with paragraphs 1 through 3 of the accusation.
So moved.
This is Helen Park. I'll second. Any further discussion? Okay, all those in favor?
Aye.
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 Any opposed? Okay, that motion passes.
Next, I'd ask you to make conclusions of law consistent with paragraphs 4 through 10 of the accusation and find the respondent guilty on both counts.
So moved.
Anna Carr, second.
Motion by Ms. Jacobo, second by Ms. Carr. Any further discussion? Yeah, all those in favor?
Aye.
Aye.
Any opposed? Okay, that motion carries.
Next, I would ask that you automatically cancel registration number PT 28532 pursuant to NRS 639-281 subparagraph 2. that you impose a $500 fine. And then I'm handing out a memo of fees and costs in the amount of $586.34. Ask that you award them as reasonable, necessary, and actually incurred. They were provided to the respondent beforehand. That's the discipline I'm recommending.
And then just, when Yen dealt with it, but just for the record, when she got noticed that she didn't qualify for the license, she stopped that immediately that day. And I think Renown's kept you on in a different area.
It's not working.
Yeah, are you not working? You're on administrative leave right now?
Right.
Okay, thanks.
Move that we cancel registration PT 28532. However, I would like to waive the disciplinary fine. But I would like to find respondent responsible for the attorney's fees and costs in the amount of $586.34.
Do you want that to be paid by?
Is that something you can pay within a month or do you need longer?
This is just the $586.
$86,
She's waiving the fine.
It hasn't been voted
Yeah,
on
it hasn't
yet.
been, yeah.
Do you need 6 months to pay it or how much time do you need? Okay, there you go.
Due within 6 months of today's date and make the action effective today.
Thank you.
Okay, we have a motion. Do we have a second?
Anna Carr, second.
Second by Ms. Carr. Any further discussion?
Madam Chair, we also need to add that the fees are reasonable, actual, necessarily incurred.
Do you want to amend your motion?
Yes, please. I would like to add that those fees are reasonable, necessary, and actually incurred.
Okay, and is there an amended second?
Amended second.
Okay, thank you. Todd. Any further discussion?
And that it be effective immediately, sorry.
And that it's effective immediately.
Amended second.
Third.
Third.
And then for your discussion, if you can discuss how you want staff to deal with, she'll be able to apply tomorrow for one license. We just need a path for how you want us to do that. And then we will, I mean, we have the authority to do what we want, but we want it to do what you tell us to do. So. And in a vacuum, we would not give credit for the 1,500 hours, but we see the reason to do it.
Okay. You adopted.
Just need to, I think if once you vote, it'll close the hearing. So I think you need to do it now.
Good discussion. You don't have to amend your.
You don't need to make a motion. Somebody's got to, maybe the president tells us what to do, or you guys talk about what you want to do.
We have a motion on the table, and then I think our discussion is, do we accept the 1,500 hours for previous work? And I think weighing that we're going to have a discussion on it tomorrow and that she did work in that environment, I would be okay with accepting the 1,500.
Allowing the board to process her application.
And allowing, yes.
Yeah, I would be in favor of that. I don't see any reason why we wouldn't or shouldn't do that.
Okay.
I'm good with it. It's good.
All right, so we'll vote on our motion. So
We have one more request from us, from council. We're not, you just check us. We're not sure that you admitted it in the fees and costs. So we just want to keep the record clear.
okay, thank you.
And I think Laura knows because she's been standing them with her in her hands.
The memo of attorney's fees and costs will be so admitted as Exhibit 2. Thank you.
Thanks, Laura.
Okay, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes. All right, thank you. We wish you all the best.
Thank you.
Billy, come see me.
All right,
Come see me.
next we're gonna go to Montgomery DME. This is agenda item 7B. Hi, good afternoon. Thank you for waiting. If I could have each of you state your full name and titles for the record.
Thomas William Fisher, President, CEO, Interling LLC, DBA Montgomery DME. Miro Velasquez, Manager of IT Facilities and Fleet, Montgomery DME.
Jay DeVoy, counsel for the applicant. And also present is Yolanda Green, who can introduce herself. She's with Genu Care.
Healthcare consultants, yes.
Yes.
Thank you.
Okay, great. Thank you. So if you are not an attorney, I'm going to swear you in. Okay, do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes, I do.
Thank you.
Great, thank you. All right, I'll turn it over to Mr. Wiest.
Just for the, I don't know what healthcare consultants is. Can somebody explain that to the board? What the purpose of that is?
She is a consultant that her and her team, we brought on to help us make sure we were being adherent to all the laws, regulations, codes for Nevada to operate our organization in Nevada.
Okay, is it related to compliance or it's related to proper licensure?
Compliance, and then also helping us to do all the right things for licensure moving forward. And so we've actually retained them, not just in the interim, but through the licensing process throughout October. So this way, because we always had a licensing issue before, we wanted to make sure we were being proactive in doing the right things to have the right resources, to make sure we were having our license done correctly moving forward. So that's why we retained Yolanda and her team to make sure we were doing that.
The purpose of Yolanda being present today is to answer any questions the board has regarding her services and how the engagement of her company will aid with compliance respectively.
So Dave Weiss for the record, I think there'll be two components to my presentation related to the application. The first is, I think, my disclosure is this is not a discipline hearing. This was an unlicensed practice, which we did, which I'll describe. Or I'll probably kick it to Laura. She can describe the cease and desist and the cite and fine and the status of those. And if you're not ready, I can do it, but give you credit for the work that you did.
I am ready.
Okay.
Okay, Laura sorry. Laura Tucker for the record. So the current status of the cease and desist is that, so we have been working with Montgomery's leadership and.
I just had, like, we gave a cease and desist that said what?
Okay, sorry.
I'll do the rest of it. We gave him a cease.
Yes.
I said, stop
Sorry, Dave.
being an MDIC provider.
So the cease and desist. Actually, I want to give the exact language.
Take your
I don't
time.
have that in front of me. Can I?
Yeah, we'll come back to it. So I'll just do the background of it. So we discovered through a complaint that Montgomery was operating with a license. We went to go look at it. It looked like they purchased another company roughly 3 years ago. And then when that renewal came up, they did not renew that particular license. I think we have evidence that they changed the name from the prior place, and they're not here today. And they, and there'll be other cascades of, fallout from this. This is just them in front of you today. But I think with Las Vegas business, they changed it to Montgomery. And I think that there might be a new name too, or there might not. They can talk about that as we move forward on the application. I'll ask that question. And so when we discovered that, we looked into it, did our normal investigation things that we do, and discovered that yes, indeed, they were operating without a license. And so Laura gave them a cease and desist on that. And then secondarily, once we started investigating more, then she did a cite and find. And so are you ready now for that? And I'm sorry, I didn't give you a heads up.
Laura Tucker for the record. So on February 12th, 2026, we sent a cease and desist to Montgomery DME for the allegations that Dave Weiss just explained to you. And so we asked them to immediately cease and desist engaging in unlicensed sale of medical devices into or within Nevada. And we also gave them 30 days from the date of the letter to transfer any existing Nevada patients to other licensed medical device providers. At the time, we gave them the ability to continue providing services to existing patients until they were successfully transferred to a new licensed medical device provider. And we also told them that they were not allowed to accept any new patients at that time. And during the process of transferring over these new patients, we also asked them to provide weekly progress reports to two of our board inspectors, John Castaldo and William Kuykendall. And then we also we gave them the opportunity, if needed, to try to domicile their equipment until they were able to come before you and obtain a new license.
Thank you. And then the fine.
And then the fine. We'll get that one.
I'll go, but I'll keep going. So we have a relationship with the business licensing people in both the north and the south. And so the business license people, the agency, I think it was Las Vegas, but it might have been North, probably Las Vegas. Maybe it was North Las Vegas. Anyway, it doesn't matter. They visited the site with us, and then they gave them a notice that if they didn't have proper licensure in a certain amount of time, that they would lose their business license. That time frame would not allow the board to see that and approve the license in the meantime. So I think that the business license people recognize that, worked with our staff, and allowed that business license to go, and it's intact today. And then I will say that they did. There's always communication issues when we go through these things. They do several hundred oxygen patients, and then several hundred more of other things. And so converting all those patients to another provider would not have happened in 30 days. But I think they were compliant with the intent of what our cease and desist was, and they did begin to migrate patients out. And that's not a question today whether they did that or not. We haven't converted them all. And so depending on what action you take, we might talk about that at that particular time. If you were to grant the license, then we would stop that conversion. And then if you don't do it, then we'll have to either expedite that or deal with what you guys say they have. There is a law that says when if you don't have a license or you're going to go out of business or those kinds, that you have to work with the board and other people to migrate. We just can't have 600 people not having oxygen and being on. So I made the decision to allow them to keep operating. Again, we have all the other players in it will be dealt with through the investigation process, whether they're licensees or not licensees to the site and fine.
Yes. Laura Tucker for the record. And Mr. Wiest, would you like me to go over the findings or just the fine amount?
I think we've talked about the findings.
Okay. So we sent Montgomery DME a citation and fine on March 19th, 2026. In the amount, we assessed an administrative fine in the amount of $100 with respect to each of Montgomery's known respiratory patients that were reported to the board when we sent the cease and desist order. That was 628 respiratory patients in Nevada at the time. So the aggregate fine amount was $62,800. And they subsequently paid that fine to us. You got
the check.
Yes, I did get the check. About a week later from that.
And again, to demonstrate their compliance with this particular order. I still have the second part, which is some things that we found during our investigation that I'll talk about after this, but you can do a whatever testimony, but I think I'll pause and let them kind of describe I think they were shocked when we came, but they can give you the reasons for whatever happened. I'll turn it to you.
Yeah, thank you so much, first of all, for giving us time to kind of share our story here. When I found out, I think Romero called me later in the day, the board of pharmacy stopped by, and I was shocked. I was like, oh, well, what's going on? And that brought up the licensing issue from when the company was purchased or changed hands quite a few years ago. From that moment on, I was at the board of pharmacy Las Vegas by 9 a.m. the next morning, meeting with Laura and Mr. Wiest. And I came in with we are a good company because we've operated successfully. We have multiple locations throughout California. We're a regional player there, significant in the market. I said, we're here to be a good corporate citizen. And what do I need to do? Because obviously some things were done incorrectly. Some oversight did not occur. And it was my role to make it work, to get things fixed. And so that's why I showed up there. That's why also looking at it, we were there every week. I know we sent a tracker to Will and he was, got our data all the time. And we went from, 1,100 patients down to probably 700 patients, 600 patients right now to be in compliance. But I also showed up there to make sure it was getting done. And that's why I brought on somebody like, Jay, because when I first got the cease and desist, I had never dealt with something like that before. Luckily, I've been in a hospice for 25 years, running my own business and now Montgomery DME. And always made sure the I's are dotted and T's are crossed. It wasn't here. And so it's like, okay, what do we need to do to make this work? And that's why I said, we need experts in the Nevada market because we were a California-based company. We were not a Nevada-based company. That's why I brought on Yolanda and her team. Because we need to do a top to bottom refresh, reevaluation of every single policy and procedure we have to make sure it aligns and meets the minimum expectations for Board of Pharmacy Nevada. And so we've done that. We've begun that process because yes, we messed up there, but now it's what are we doing to make sure it doesn't happen again? That's where we came into play with her. And so I brought on Yolanda. Initially, it was going to be, okay, just help us do this. And that's why I was like, no, we need at least a 3-month oversight. Because if I'm in your shoes, my first question is, how do I know they're not going to do it again? And it's like, okay, first of all, we committed the $62,800 to saying we are in this market and we want to do the right things. Because if not, I'm sure ownership would have looked at it differently. But no, we want to be here. So we paid that fine right away without fighting. But bringing on Yolanda and her team to oversee us, not just for the next 3 months, but until the licensing in October goes through also. Because that's the key thing is, how does it not happen again? You don't just want to hear me say, okay, here's what we're going to do, but we did a complete revamp of everything. From now we have, the monthly, quarterly, semi-annually, annual licensing and expectation meetings to be able to meet the requirements for the Nevada Board of Pharmacy. And like I said, that's why I brought Yolanda on the call, because I thought it was important for you to hear from her, of what she's doing. And she tore us apart. She did a full top to bottom analysis to say like, okay, are there other things that we need to work on? And it's like, great, give us everything, because I need to know what we don't know. I need to fix what our gaps are. I can't fix it all myself. Like, yeah, I'm this president, but it's like, I need to make sure I build out the structure from a team standpoint that we're able to do what needs to be done in order to get things fixed. So that is what we're here to talk about today.
Please.
Yeah, so thank you for that, Tom. As we proceeded in to try to figure out what was happening in the business, we did discover an incident that was concerning to us. I want to be clear that this isn't discipline. I'm not presenting evidence, but when you weigh whether to give a license or not, or the conditions for the license, I have to fully disclose everything that I know to you. So I cannot hold that back. So we did discover a patient that was a hospice patient that was under their service. It was they may have been under service before with them or may not. I'm not sure if I know that answer, but this new service, the patient was coming from the hospital, needed a BiPAP. I think there was a BiPAP that was already out at the location, and the determination was to use that BiPAP until the proper BiPAP or a different BiPAP could come in. There was a hospice nurse at the home. There was discussion, there was some delivery of some supplies by a delivery driver. There was a discussion, we have evidence that there was discussion, or we have knowledge that there was not evidence, or we have knowledge that there was a discussion with the delivery driver. Nevada law requires that they have a respiratory therapist that's licensed in Nevada. They didn't at that time, and I think that goes back to Tom saying that they're trying to make sure they're in compliant, but there was a respiratory therapist that we think that I think we know at this point was licensed in California. There was a discussion between the delivery driver and the patient was left with that BiPAP, and there wasn't a process for adding oxygen. They're going to tell you their side of the story, and I'm not going to argue their side of the story, but the patient was not hooked up to oxygen and unfortunately expired that day. And I cannot say there was causality to it, but these things did happen. And I think that if they were to be licensed, they would probably find that they need a respiratory therapist that's in Nevada, and the respiratory therapist should be doing that setup if they determine that the nurse that was out there was not qualified to be able to do the proper setup. And with that, again, they know their side of the story. We just did a normal investigation.
Thank you so much for that. Yeah, with regards to the RT, once again, that's a thing we uncovered of that multi-state licensing. So we've already hired an RT. They've already started with us. They've been with us now. I'm going to say probably 3 weeks plus. We also have another RT and going through the licensing process. He's already submitted his application. There is a licensing number, that he received. So we saw that gap and it was okay, we're going to fix. So that's what we do, have staff based in Nevada to take care of that. With regards to that patient incident, yes, that was a patient that we actually had on, and I don't want to get in all the details, it's on that one. It's a very compromised health-wise patient. They were on service with us in the November, December time period. The prescription that was provided to us from hospice did not indicate supplemental oxygen. And from the DME side, we can only provide what is written on the prescription. And so we did not provide a setup that required that allowed for supplemental oxygen. And that's where it came. And we walked the nurse through the setup. The nurse gave the blessing and said, okay, you're free to go. Then a few hours later, we get the call of, oh no, we want oxygen to be bled into the BiPAP. At that point, we dispatched the delivery tech to go back. Unfortunately, he showed up he was a few minutes away when the patient passed. So it was within, I'd say 90 minutes to get that done. The patient was on oxygen when they passed. Patient was on oxygen via nasal cannula with a mask.
You did deliver oxygen?
Yes. So the patient was never without oxygen. It was the bleeding in through one tube versus underneath the mask. And that's how it came about. Kind of on a side note, that wasn't even supposed to be our BiPAP. I think, as Mr. Weiss mentioned, there was supposed to be another company that was delivering a BiPAP ST. Ours was a BiPAP. We let them know. The hospice nurse said, oh, don't worry, I'm going to get that from another company. I don't know if they ever did or did not, but they wound up putting the patient on ours, which we set up correctly, but it was without the oxygen connector because that's what was requested via the prescription. And we can't change that.
I would like to add some details. Jada Boyd for the record. I just would like to emphasize, because I know this is a point of significant concern for the board. It's a point of significant concern for Montgomery as well. I think it's difficult to overstate the medical complexity of this patient, who was an 82-year-old man who was previously discharged from hospice in that stint that Mr. Fisher was talking about that began in November of 2025. At some point, the dates of which are unclear because of the information from that original hospice that engaged Montgomery for this person's care for certain non-respiratory equipment, that sometime in December, that individual was discharged back to the hospital. And then at some point in late January, we'll call it January 27th, the investigation on this is not complete because there's been no litigation claim. We don't know all the people involved. But it appears that that individual, after being in hospice, being discharged to the hospital, being discharged out of the hospital to home hospice, on January 27th, receives the materials from Montgomery DME. It's set up correctly to the approval of that hospice's nurse. And then that evening, around 10 o'clock at night, there was a call that, I think it was actually 11 o'clock at night. There's a call that goes out to Montgomery DME. They solve the problem that's needed. They identify the piece that's required, go to get it. And then when the respiratory technician is about 9 minutes out of that patient's house around 12:30, 12:40 a.m. on January 28th, that patient died. And it's very unfortunate that it happened, but this is an individual that, to the best of our knowledge, expired within hours of being discharged from the hospital for the second hospice episode in the same calendar quarter. I just want to make sure that's clear.
I think also a thing to note was the assessment from the hospice themselves. They indicated to us they didn't expect the patient to make it through transport and actually make it home.
So now I've dealt with what I wanted to present. Just like a question moving forward, if you had a respiratory, I'm not talking about this case. So if you had a respiratory therapist and you came across a patient and that person was setting up the BiPAP and identified that they might need oxygen, supplemental oxygen, or some other device, you would contact the provider and say, hey, we're out here assessing the patient, and the needs may have changed between. I'm not talking about this patient. I'm just saying, moving forward, we want to make sure you're providing good respiratory care.
Yes.
And so you would contact the respiratory therapist would contact and say, hey, they've decompensated since the time and they might need this. You would put that in your procedures to be able to do that moving forward.
Yes, as long as it's at the direction of the hospital.
Yeah.
Because we can't make it.
The doctor.
Yeah, they've got to give the blessing.
But I mean, again, we would expect if you're doing a BiPAP, it would be, and again, the nurse could qualify, so I'm not saying that, but if there was a respiratory therapist there, and that might have been the nurse's job, in this case, I'm just talking about moving forward, they wouldn't say, well, we got the order and it's not good enough for them and we're not gonna treat the patient. So you would do that, okay.
Yep. And that's what, and the key thing coming out of that too ties into Yolanda. I feel like I'm putting a lot on her, but of making sure, as you mentioned, about having that policy and that operating procedure, building that in to make sure we have all that structurally set up.
So let's hear from Yolanda about her assessment and what she has uncovered and what she feels needs to be addressed.
Well, good afternoon. I'd like to just give you a little overview of what GenuCare Healthcare Consultant Firm does. We work with a multitude of medical practices, medical companies, hospices and home health, and long-term care facilities on a national basis as well as on a local basis. Our office is based out of Phoenix, Arizona, and we do have clients that currently reside in the state of Nevada, and we do provide compliance and oversight. In our when we were retained by Montgomery, they shared with us some of the details that they've been encountering, and we reviewed the violation list that they had. And immediately, we reviewed their policy and procedures. And Melissa Greer is also our Vice President of Operations. She's on the call as well. And we took a look at their policy manuals and said, we probably need to update those fairly quickly. They did have some dated policies that we felt like needed to be improved upon. In terms of their overall situation, with this occurrence that they had, and almost a sentinel death situation, we really enforced a policy to ensure that there is a registered respiratory therapist if there indeed is going to be a BiPAP, even if the hospice nurse is capable of doing a BiPAP machine, which would be within the scope of practice for that individual. In addition to that, we did take a look at again, all the violations. We did prepare a corrective action plan for the entity so that we can ensure that they will not make these mistakes again. And in that corrective action plan, it's kind of been from A to Z in terms of the licensing deficits that have occurred, as well as change of information notification of all the governing authorities, such as yourselves, Medicare, Medicaid, and any of their hospice organizations that they do contract with. So, giving proper notice of change of information. And then compliance standards and just, ensuring that their accrediting organization is aware of the change of information that's conducted, and essentially just ensuring that there will not be a lapse in licensing on a go-forward basis, and then addressing all the other and additional operational matters that have occurred within their violation report that you guys had prepared.
Thank you. And then I think in the beginning, Mr. Fisher mentioned that you'll be staying on to continue to provide oversight for a certain period of time. What was that time period again?
We're going to keep Yolanda and our team through, because my understanding, it's end of October every year, to go through that time period just to make sure we have one full cycle with her, that we have all of our I's dotted, T's crossed, and proper structure in place to make sure, next year, or for all the other licensing, we actually have a rigid policy and operational plan in place.
Until the next license, when the next registration is due? And then during that period of time, then what will GenuCare be doing on a regular basis to provide oversight?
We'll be providing education. We'll be requiring governing body meeting minutes. Also providing any kind of webinars that's needed and required for the staff that is within the organization. Also offering education on clean and dirty procedures, quality of equipment. How do you identify inadequate equipment? Who are their vendors? Who are their contracts with, ensuring that those contractors are licensed and accredited as well, and that they are partnered with appropriate people in the industry in order to deliver adequate and appropriate care to the hospice patients.
Great, thank you.
Mhm.
And then in terms of it's difficult because you were not licensed to practice, but in your previous practice, what was your average amount of patients?
Per day, or our average census. So if we were to combine California, 10,000 per day.
What about in just Nevada?
1,100, 11 to 1,300.
Yeah, for us, it was just for the record, it's difficult to measure because people go and get one thing and then they don't get any. That's why we tied it back to the oxygen patient, because a hospice patient may need one thing, and then is that still one of their patients? So we struggled with, that was our own struggle when we first started talking to them, is like, where are the patients? What are they on? That kind of stuff. So I'll let him answer the question, but I think that he'll also say it's a moving target every day. Or maybe his attorney's telling him not to answer it. It's a moving target.
It is a moving target. And that's why, we did the weekly trackers. We worked through how we laid that out to make sure the data was clear and concise and made sense. You could see the trends. I think we're down 30% plus, from start to finish. And, we worked with other providers also in the area to see if they could help take the capacity coming from us, because, once again, we go back to that North Star, being a good corporate citizen. We didn't want to leave our hospice agencies hanging, because that has a significant impact. And then if that part gets messed up, then there's the rest of the healthcare system has challenges of getting people out of the hospital. So we worked with everyone just to make sure there was some fluidity. I know we had a letter too that went out with the help of Will and Laura's, indicating this is what happened, here's what we need you to do about transferring existing patients, no new patients. So we're trying to do everything we could just to stay in compliance to make sure that we're abiding by the guidelines.
Let me be a little more specific. I wanted to get a sense of how many patients are on oxygen or how many oxygen patients you typically.
That's right. You're looking probably around the 600 mark.
Okay, so then my question to you and GenuCare is for a patient census at approximately 600 and some patients, how many respiratory therapists would be appropriate to meet the needs of those patients?
I think when you look at that, the use of, let's say, a BiPAP machine or those type of things, very few and far in between. I mean, you're looking maybe that's one a month if something like that was to come up. It's not a common product, at least from our perspective. Maybe some agencies do use that more, but for the way we see it, it's just more comfort care, especially with the standard BiPAP. So one would be sufficient, but we also have hired a backup just to make sure. And then as we see if the patient needs change, because sometimes hospices change and they go higher acuity patients, then we'd make the adjustments to get more RTs as necessary.
And so GenuCare, would you like to add anything to that?
Yes, so I think Tom is aligned with roughly 2 respiratory therapists that are registered. The utilization is extremely low for hospice patients and respiratory therapists in that space. So you do have to have one on board in the event for a BiPAP machine, but that is atypical. So I would echo what Tom is relaying to you, that it is a very low utilized product. Usually it's a standard oxygen concentrator that is utilized for a hospice patient. And so I would agree and echo that 2 respiratory therapists would be sufficient and adequate for 600 patients.
Okay, and
I have one more thing, if that's okay.
and
For clarity, I think that it is within the standard of care, and we know, like, we're giving out the license, that a respiratory therapist would set up a BiPAP or a CPAP. Would say that if a qualified nurse that said he or she was qualified to do it, would under law be able to do that too. But for an oxygen concentrator, it's within the industry standard for a trained technician / delivery driver to be able to go set that. So I don't want to make you think that every oxygen setup would require a respiratory therapist. I think they'll go through there. The respiratory therapist should be looking at the orders. The respiratory chair should make sure they're correct. They may want to look at what the pulse ox says. So I mean, there's a care component, but for the setup, it would be the industry standard that a technician / delivery driver could set that up.
it sounds like Mr. Fisher was saying that you already hired one and you have one pending. So your plan is to have 2 RTs on board?
Yeah.
Very good.
Apologize, Jada Boy, for the record, just for legal reason to point this out. Within the definition of life-sustaining equipment in the NAT Administrative Code, I unfortunately don't have the citation on.
Concentrators are not defined as that.
Yeah, correct. They're specifically outside the scope of.
I agree with that totally. That's why I said the point that I said.
Great. I just want to make sure we tied it back to regulation.
I maybe be able to quote no, I agree with that statement.
Thank you.
All right, let's talk about your MDIG administrator. Can you tell us about your MDIG administrator and the qualifications and their qualifications?
Caesar's been in the industry for that 1,500 plus hours. So he meets the expectations or the minimum experience level for that. He's going to have significant oversight to be able to make sure we are doing the things that we need to be from a compliance standpoint. I say it like his role, and we've kind of redefined his role, and Yolanda helped us build that out just to make sure that administrator also aligns with the compliance officer and works correctly in the Nevada, let's say, umbrella. So that's kind of where I think she comes in. That's where I was leaning on her to be able to help out and assist with that, to make sure that we are doing the right things from a compliance standpoint. Like I said, from us, it was okay, does he have the experience? Does he have the ability to do the job? Does he meet all these other minimum requirements? Yes, so he has the blessing, but now it's the execution to be able to have that in the real world.
All right, and then have not heard from Mr. Velazquez. Did you want to make any comments, or what is your role in the company?
I'm the facility manager. Moving forward, I'll be kind of keeping track quarterly on the licensing issues, just making sure that everything is licensed and up to date.
Yeah. Ramiro has been actively involved with the inspection team. I think working weekly with everybody. He was assisting me on quite a bit of things I hear just to make sure, like I said, our I's are dotted, T's are crossed. We're using properly licensed vendors, and so forth.
I'd like to add also, they are on a quarterly audit reporting mechanism that we will be monitoring as well. So that is something that we have built into their corrective action plan.
Very good, thank you.
We did find situations where they were utilizing wholesalers that were not licensed with us, and we'll be taking the appropriate action on that. They were also using licensed wholesalers. The oxygen themselves came from a licensed wholesaler.
All right, board members, any additional questions?
Adam Porth for the record. No questions, just a comment. I do feel like it sounds like there are some lingering regulatory concerns. So I would be okay with approving the license, but I would like to see some additional inspections.
How many?
Yeah, if I can add a comment to that, Ms. Green seems really competent, but we haven't vetted her, so we can't use that. So unfortunately for us, we'll have to use our own inspectors. I would request, and I know improvement is ongoing, but if we can get a copy of that report, we could then inspect to that too, that we could make sure that compliance was high.
So maybe quarterly inspections as well as copies of GenuCare's inspections.
I just think a snapshot of where it sits now will be good enough for us.
I apologize, Jay Devoy for the record. With the inspections that you're requesting from GenuCare, is this the current gap analysis? Because I'd want to make sure we can cleanse that of any kind of.
These would be inspections by the board of
prospective ones. Okay. Well, my understanding the request was for what GenuCare produces, which is fine prospectively.
So it's both. So we want the board to do their independent quarterly inspections. And then also if we could obtain a copy of GenuCare's inspections.
That's my understanding as well. Just want to confirm that it would be a prospective obligation. That's all.
Yeah, we welcome GenuCare to be with us when we're there, and then that can kind of work together if that's something that you guys choose to do with them. So you can have whoever's there when we do the inspections.
And we're happy to be on site for the inspections.
Okay, and then the other part too that I just you had mentioned, GenuCare had mentioned some dated policies. So I would be interested in seeing an updated policy or training plan, or perhaps both, maybe a training plan for the RT and updated policies.
Just going to the inspector.
The inspector.
Yes.
I think you have to amend your.
Okay, I would amend my motion. I would move that we approve new DME application for Montgomery DME pending favorable inspection, as well as a requirement of quarterly inspections at the expense of the business from board staff, and a requirement that we have access to GenuCare's reports for the duration of their engagement with Montgomery DME. As part of that inspection process, we expect to see updated policies and procedures.
And a RT training plan.
And an RT training plan.
Okay, motion by Mr. Porras, second by Ms. Jacobo. Any further discussion?
Just for you, this will all be put in writing by Laura. So you'll have this all in writing, and you can watch the video back if you choose in about a week, but we'll put this all as a copy of your license and deliver to you in writing.
All those in favor?
Aye.
Aye.
Any opposed? Okay, that motion carries. All right, thank you. All the best.
Thank you.
Madam President, I recommend that we take a quick break.
Take a break.
Let Todd stay or go. You're welcome to stay, Todd, and then we'll try to formulate what we can get through for the rest of the afternoon.
Take a break.
Thank you.
I already moved it up one.
We have, Madam President, if I can make a quick note, and you know this, but I'm just telling the public and the board, due to the thought that we would be a little bit earlier done with our discipline today, we have asked several people to, if they wanted to go today, they could, knowing that the meeting's going to be short tomorrow regardless. And so you'll do your best to get through all those people. I don't think that you will make it. But you'll try to get to everybody that you can today. The people that don't get seen today will be tomorrow after the public hearing and workshops.
Thank you, Mr. Weiss. With that, I'm going to call for agenda item 8C for Lux Infusion 13. If we have representatives here, if you could please come forward or let us know on Zoom.
Joe Dodge, are you there too or not there? Not there. Okay, thank you. Yeah, I knew you weren't gonna make it.
Hi, good afternoon.
Afternoon, Madam President.
Just-
Members, back again.
Thank you, Mr. Stilling. All
I'm
right.
here, I'm here because I was here this morning, but I also represent Lux and its owner Biomatrix. The principles of the company will appear online. I think there are 4 people who are involved. I'll introduce them by their titles, and then I'll let you all go on and ask them questions.
Great, thanks.
Or Mr. Dodge or whoever.
And then
First-
we'll wait for the 4 individuals to join.
Yes, and I see some of them up. So there's Joe and I see Morgan. So the individuals I have on the list are Jonathan Chan, who's the managing pharmacist, the new managing pharmacist. Kim Moore, who's senior vice president of pharmacy operations for Biomatrix. And you'll see why she's important because she was involved in some work with Joe Dodge December and January. Morgan Harbour is general counsel for Biomatrix, and Robin Hansen's a licensing specialist, who I think completed the application. So if there's any questions about that.
Okay, so it looks like we have all 4 present.
Great.
Okay.
So I'm here. There might be some questions about what was going on previously that I was involved in too, but with that, I'll let you all go.
Okay, so I'm
Thank
going
you
to
much.
swear everyone in, and as part of that process, if I could have you state your full name and titles for the record. If we could start with, at least on my screen, I see Miss Morgan Harbour in the top center, and if we could go from that order.
Sure. Morgan Harbour, Chief Administrative Officer and General Counsel for Biomatrix.
Okay, thank you.
See Kim.
Allison or Kim?
Kimberly Jensen Moore. I am the Senior Vice President of Pharmacy Operations for Lux Infusion.
Okay, thank you.
Allison Croft, VP of Compliance and Quality.
And then Jonathan Chan, the new managing pharmacist or pharmacist in charge.
Okay, so I will be swearing in Ms. Croft, Moore, and Mr. Chan. If you could join me in raising your right hands. And then I'm assuming Ms. Harbour, because you're general counsel, you do not need to be sworn in. Okay. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Yes.
My apologies for not introducing Ms. Croft.
Okay, and then with Mr. Dodge, do I swear Mr. Dodge in? I think I do.
Yes.
All right, so I'm sorry about that.
No
Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Thank you. All right. I'll turn it over to Mr. Kuykendall.
We have a change in ownership and name change application for Lux Infusion 13, previously Total Infusion Care LLC. This is item 8C and begins on page 4762 in the board book. This is a specialty home infusion pharmacy that will perform sterile compounding. Can someone just please explain the change of ownership that took place?
Bill, are you doing that or do you want me to?
I think it's, you have more
Okay.
firsthand knowledge that.
Sure. Biometric Specialty Pharmacy LLC purchased Total Infusion Care on November 7th of 2025.
And then the next question here is there going to be any staffing changes specifically based on this ownership change?
I'm having a hard time hearing. Is anyone else having a hard time hearing him?
Yes.
Yes.
Is this better? Can you hear me?
It's the same, William.
Want to come over here?
Okay, is this better?
Yes.
Can you hear me?
Mine's better.
Sorry about
762.
the next question here, is there any staffing changes specifically based on the ownership change?
Kim, do you want to answer that piece?
Yeah, we did have a material change in the business that, at the time that we purchased the business and subsequently after we had a, annual Board of Pharmacy inspection, December 22nd, we made a change with respects to the managing pharmacist that went from Mohammed Porte-Moore to Jonathan Chan. Jonathan, I don't know your exact start date, but he's been with us, for approximately 4 weeks. Is that correct? Or maybe a little bit more?
Yes, that's correct.
Okay.
Perfect, thank you. And then I just want to confirm on the application, it also lists Jonathan Chan as the designated representative, is that right?
Yes.
And then for Jonathan Chan, what is your experience with being a pharmacist in charge? Jonathan, can you hear me?
He's muted. I don't
He's
know if someone
muted.
can unmute him.
There we go. Okay. My experience as a managing pharmacist was in a retail setting. That was about 7 months before this change. And my experience in compounding was about 2 years and some change.
Okay, and then have you completed any formal training with sterile compounding?
Not currently, no.
And then where were you working where you had this experience with sterile compounding?
It was with Total Infusion Care from 2021 to about 2020, beginning of 2024.
Okay. Has there been any changes to policies and procedures based on this ownership change?
Yes, a complete overhaul.
And then can you explain some of them?
Yes, so there has been a procedural change when it comes to the clean room suite. The clean room is being managed through Simplify 797. That has a go live date as of Monday this week. So that would have been on 4/13 of 2026, where everything is documented using Simplify 797. All the training competencies, CEs are also documented as of 4/13 going forward using Simplify 797. We have a new quality improvement program that has started with revisions and additions of new policies and procedures in relation to the clean room suite, staff competencies, as well as training.
Okay. And then has there been any service changes based on this ownership change?
In relation to like patients or?
Yes,
No.
patient services.
No.
And then the last inspection that we did for Total Infusion Care was in December 2025. The findings indicated significant deficiencies. The PIC, who is also the designated person for sterile compounding at the time of inspection, had limited knowledge on revised USP 797 requirements. Looks like environmental monitoring requirements, aseptic technique, and garbing assessments weren't being done appropriately.
Documentation of ongoing training of staff were not able to be found, and cleaning logs weren't being correctly filled out. Compounding records were not being correctly filled out, and SOPs weren't being routinely updated. What changes have you implemented after this inspection in December 2025?
Well, I can speak to that. I mean, they've been considerable, essentially. So we had as you said, we had the inspection on the 22nd of December. Within a 3-day period, actually 4-day period, we deployed a national sterile compounding expert, a consultant through the National Sterile Compounding Institute, who literally spent an entire month on site at Total Infusion Care. And as part of that initially, so in addition to the deficiencies that were outlined by the inspection, we also did our own internal gap analysis so that we could have a complete understanding of the gaps that existed within the business. And from that period, and we worked very closely with Mr. Dodge to provide documentation of the changes that we made in the business. And those business encompassed introduction of our existing policies to Total Infusion Care because they were lacking and they were not consistent with the 797 guidelines, establishing a designated person in accordance with USP 797, making her certified to read microbial sampling, making sure that she partook of training that made her competent to take that designation. Not only did she do critical point training, didactic training, she received an NHIA certification to serve as that. We made sure that the entirety of the staff, instead of just kind of bridging the gaps that we saw in competency, we insisted that everyone that was in a position to either be directly compounding or indirectly in the clean room, everyone went through initial competencies. So everyone had to go through aseptic validation training. They had to take didactic training through critical point. So just essentially redid everything. As Jonathan spoke to, we introduced Simplify 797. Even though it just went live, we were using that product almost immediately to provide the basis of the didactic training and to begin aligning with everything that was outlined in that software program. We updated our surface sampling map to include, I mean, as I said, there was the gaps inherent in the business. One of those was the surface sampling and not having adequate representation of the sites inside that compounding suite. We updated that map and extended it to 10 unique sites. I think that's the entirety. I don't think there was anything I missed. Nope, I think that was everything. Joe, did I miss anything? I worked, we had four periods of deliverables to the Board of Pharmacy, and we met those, worked very closely with Joe. If there was anything I missed, Joe, please correct my misunderstanding.
Sure, I'll just jump in for a second. I know William's going to ask most of the questions today, but I was involved in the process in December, so I'll just give a brief overview to the board members so they understand what process took place. So just as a reminder, we sent out notification late 2024 to all pharmacies that we were going to start enforcing the revised USP 797 guidelines early 2025. So I appeared at the pharmacy in December of 2025, expecting that they were following the revised USP 797 guidelines. It became very clear very quickly during the inspection process that the current pharmacy manager did not have the knowledge related to the revised guidelines, such as they hadn't identified a designated person, which is, 101 for the revised guidelines. They were still talking about low, medium, and high risk products versus the categories. So I identified during the inspection process that there was a significant lack of knowledge at the entity. They didn't have policies and procedures in place. They weren't doing the required monitoring that was required to make sure that their environment was sufficient to produce sterile products. So I engaged with the local staff initially. I believe that they engaged with Mr. Stilling very quickly. As they mentioned, they did move quickly in getting me the documentation that was required, and I was requesting a lot of documentation to make sure that the public wasn't at risk because we were going to make the determination whether or not they could continue sterile compounding. They did bring somebody in on December 26th, so the day after Christmas, and an outside entity was assisting them with the process. I met with that person personally as well to make sure that I felt that they were qualified to provide the correct guidance moving forward. Total Infusion Care met all of my deadlines as far as providing me with the documentation request. Based upon that, we made the decision to allow them to continue sterile compounding. Obviously, there's limited things I can talk about today related to that because there may be discipline moving forward based upon the people that were involved in that process. But I felt that everybody from the new ownership and Mr. Stilling were cooperative in providing me with the proper information in a timely fashion. And I can answer any questions that anybody may have as well. Thank you.
It made me work on Christmas. They didn't say anything about December 26th. I will say that working with this group was really pretty incredible. They, once they found out there was a problem, luckily they have pharmacies around the country. They had operating procedures and expertise to implement this as quickly as humanly possible.
I just
have a question for Joe, just to be clear for the board. Do you think that there's a current investigation going on?
The investigation's complete. I don't think we've sent an accusation out at this point yet.
Is it about this location or a different location?
It's about this location.
And the board will have to weigh that.
And I just want to be clear that the time between the ownership change and the inspection was very short. And so I don't know what I can't speak to what's going on there, but I suspect that it had more to do with the prior owner than the new owner. I mean, the new owner did own the pharmacy technically when the inspection was done. That's about all we can.
Yeah, that's
can
fair.
say.
Bill. For me, it's not everybody's innocent until proven guilty, but the board staff needs to tell the board what's going on with the applicant.
And I just want to make sure they understood the timing and who was involved.
Mr. Dodge, could you provide us with some more context?
I don't think we can talk about the investigation, so I think your path forward is to table it until, if that's gonna weigh in your decision, then you need to table it until we finish that particular, because we cannot talk about an open investigation until it goes through our processes.
Can I ask a question? I think the question here, I think for the board is there's a change of ownership to a new company who, according to Mr. Dodge, did everything that was asked of them and has the pharmacy up and running in accordance with 795. They've hired a new PIC. They hired a consultant immediately. And so it's absolutely appropriate to consider that there is an ongoing investigation. On the other hand, it's also important to consider that this company is now operating at the level it needs to operate. And if Mr. Dodge has anything contrary to that to say, I welcome him, because we really worked hard to get those things in. It was just a few weeks that we had to do all that.
Yeah, that's very fair, Davies, for the record. Just to be clear, I mean, the board can take whatever action
That's
they want
right.
to take. I'm not saying, and I'm saying it's proven guilty. I just wanna make sure that the board knows what's going on. So,
And I can certainly provide a little bit more insight. Certainly an investigation was open based upon the issues that were found during that inspection process. It's working through our system right now. Ms. Tucker may be able to say where we are in the process currently, because I believe that she will be the attorney that's involved in the process.
we're not gonna do that.
This might be asked, oh, sorry,
No, go ahead.
excuse me, Madam President, may I ask? Of
course.
Very simple question. When did the ownership change take place?
November 7th, 2025.
Okay, thank you.
November 7th or December 7th?
November 7th.
November 7th.
Great, thank you. I just needed to get that clarified. Thank you.
If I could add, the inspection that existed at the time of the ownership change, when they look back, it had passed, but it was before the implementation of the new 795 or 797.
I want to say that the inspection was done on 12/22/25, and they said that the ownership change occurred on November 7, 2025. So a little bit less than 2 months.
When did we receive the ownership change?
The application was submitted on, looks like January of 2026.
No,
Sorry.
it was submitted, it was received on November 24th or 25th of 25. We had subsequent, we amended the application.
Who is speaking?
Oh, I'm sorry, this is Robin Hanson.
Oh, and
There we go.
Robin Hanson, can you identify yourself? What is your title?
Oh, I'm Robin Hanson. I'm the regulatory consultant for.
Oh, I need to swear you in. I didn't realize you're speaking on behalf of the company. If you could join me in raising your right hand, do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes.
Great, thank you. All right.
Yeah, I apologize. It looks like the application was submitted on November 19th of 2025, but they have subsequently amended it with Jonathan Chan being the designated representative and the PIC more recently. So.
Okay.
Right, and also a name change. Yeah, those two changes. The supervising pharmacist change, the DR change, and name change.
Correct.
So for board staff, there hasn't been an inspection since the December 22nd. They just submitted supplemental materials, Joe.
That is correct.
To say,
That is correct.
yeah, to say supplemental materials, I mean, I think they basically provided virtually everything that you would look at to determine whether someone's in compliance with 797, new SOPs and the competencies, et cetera, the things that Ms. Moore explained before.
And I just have a few more questions. William Kuykendall for the record. Is the previous PIC Mohammed still employed with Lux Infusion 13?
I'm sorry, is he still, can you repeat that? You're a
Is
little
he
faint.
still employed currently with you guys?
Yes, he is.
And then is there any concerns for you regarding your new PIC, given that his sterile compounding experience was obtained at Total Infusion Care, where the most recent inspection report identified compliance issues?
No, because at the time that he was employed at Total Infusion Care, there was, I think they were in much better standing at that point. There had been a lot of staff turnover and I believe kind of a degradation of practices there. And when we look back at their ACHC accreditations and their past boards of pharmacy inspection, during that time, we didn't see any of the deficiencies that we certainly saw in 2025. So I do not have any concerns with respects to that.
Again, just to be clear, that time period, the old 797 was in place. And I think in February of 2025 was when the new one. So there was a short time period that the 2024 inspection had been done in December, passed, but it was under the old 797 standards. Come February, the new ones are in place, but apparently weren't in compliance with those. When one of the things Mr. Dodge asked for was for the then current PIC to go through, I can't remember, 30 hours or something of training so that he was up to speed for 797 while Biomatrix was putting all these other things into place. So there was kind of a mesh. They did not want to just check boxes. They really did put things into place. And so, anyway, so
I don't think Joe mandates training, so I don't know.
I think, Joe, did you ask, didn't you request?
Yeah, I absolutely mandated they had 30 hours of
Yes.
training specifically to revise USP 797.
That a requirement of USP?
I don't know if it's a requirement, but I think he wanted to make sure that he was up to speed on those current standards.
Sorry, so just to make sure, the PIC, Dr. Chan underwent 30 hours of CE pertaining to 797?
Yes, he did, and it was submitted.
Sorry, my requirement was for the prior pick, not Mr. Chan.
Oh,
Yes, yes.
The current pick at the time.
But I would like to add that Mr. Chan is being sponsored to go to NHIA next week. I think it's next week, Jonathan, next week or the week thereafter to so that he can pursue a special credential that is specific to sterile compounding. It's like an immersion experience for him. And we are sponsoring him to do that out of, of course, out of the importance of what we'd experience there at Total Infusion.
All right, no further questions for myself. I'll turn it over to the board. Thank you.
Members, any additional questions? I think I'm just a little unsure how to move forward.
I feel like I'd be comfortable moving forward if there was an inspection after the new PIC was already taken over. I don't feel like the pending accusation really weighs in on my decision currently, but
well, we don't have any information
Yeah.
on it now. Okay. Any other?
I would agree, Jay.
Agree with moving forward
Yeah.
with an inspection?
Yeah. Sorry, Adam Porth for the record. I do feel like there was deficiencies noted. I think they've demonstrated that there's been a lot of work that's gone in to rectify things. We have no idea who this pending inspection involves, so I think we can't even really consider that at this point. I think.
did y'all maintain your PCAP accreditation during the entire time? ACHC?
We don't have PCAB, we have just ACHC, and we did maintain ACHC. They did maintain ACHC. That was part of when we first went to acquire them. They had passed their ACHC accreditation, maintained that. And I believe since 2019, they've had that accreditation at least. And then again, just to reiterate, all board inspections up until that point were clear as well.
I'm sorry, it's Crystal Freitas. I just have a question. Could you tell me again when Jonathan Chan was going to go to that training and what training that was?
It's the sterile compounding training, and that's next weekend in Denver, Colorado at the NHIA conference for 2026.
Okay.
So Dodge, do you have anything to say?
I've said everything I need to say, Mr. Tomaso.
Well, I kind of agree with Adam and Jade that, first of all, I don't think it'd be before us. I don't think that the executive secretary would allow this to come before us if he thought we were going to err on this one. So I'm for just what Adam says, give him an inspection.
Is that a motion?
Pardon?
Is that a motion?
Oh, that's a motion.
All right, we have a motion by Mr. Tomaso. Is there a second?
I second.
Second by Ms. Jacobo. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes. Right.
Can you repeat the motion? For sure? Is that it's approved pending inspection? Okay, it's just, sometimes it's just hard to hear in this room.
Great, thank you. All right, we'll move on to our next.
Thank you so much for your time. and
Thank you.
consideration.
Thank you.
Go to agenda item 13A for Francis Ann Cuesta. If you are here or online, if you could please come forward.
Hi, how are you?
Hi, if I could have you state your full name for the record.
Francis Ann Puesta.
Okay, I'm going to swear you in. If you could join me raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Okay, great. Thank you. All right, I'll turn this over to Mr. Weiss.
Francis, do you have an attorney that's helping you?
Oh, yes, Miss Lynn Beggs.
There she is.
Great.
Okay,
Good
Madam
afternoon.
President, I got my computer shut down, but I'll go without it. So, you have in front of you an application for an APRN. It starts on page 5112. There is a disclosure. The disclosure, I think, is there's, just questions about the disclosure because of the nature of how it happened in Texas. She was a RN. I can tell you now in front of you, you have all the disclosures and you can look at those disclosures, but there was an action by the Texas board that was related to documentation with controlled substances out of various machines and wasting. I did talk to Lynn today because I think my concern going into this was, is there a possibility of diversion and those kinds of things? So that'll be my first question. Have you ever had a history of controlled substance misuse?
No, no, sir.
Okay, so the things in Texas were really just record keeping issues?
Yes.
Okay, and at that time you were and they were like low volume things, one Xanax, 5 Percocets.
Yes.
But moving forward, you're elevating yourself now to an APRN. And so you were an RN at that time. And do you understand that the record keeping gets higher when you're the prescriber than you
Yes.
are when you're the RN?
Yes,
And
yes,
you're
definitely.
committed.
I really learned my lesson after that, being a new immigrant nurse here in the States. With the proper training and the education that I learned throughout the years, I'm very much able and very careful in handling narcotics particularly.
Yeah, and I apologize. I still have my board book up. My memory tells me it was 2017 that
Yes.
those things happened. Okay. And so for me, I think I don't have any other questions, but I just wanted to kind of put those things on the record was my goal.
Yes.
I'll turn it to the board to ask any questions.
Ms. Puesta, this is Helen Park. Are you planning to practice here in Nevada?
Yes, yes, Madam Chair. Yeah.
Okay, and tell us about your plans of, where you're going to practice and the need for controlled substances.
So I'm currently practicing in St. Rose Hospital here in Henderson, Nevada, on Siena campus. I'm working as an ICU RN, but I'm gonna be employed with our neuro interventional radiologist, Dr. Kustanian. He's asking me to obtain a CS registration and a DEA license so I can fulfill my duties as an APRN. Because I believe in some procedures we will have to sedate some patients to do some angiogram and stuff. Yeah.
Okay, great. And then are you familiar with how to use and access the PMP?
I got through it with the school, but I haven't accessed it yet. But I made a membership through it before applying for the CS registration.
Okay, and then you're aware that you need to check your records
Yes.
do you know how often?
I haven't gone through that yet.
Okay.
I haven't
It's-
reviewed that one.
It's at least once every 6 months, but it's going to be
Once.
very important for you to review
Right.
driving
Right.
records. Yeah.
Yes.
I would say more frequently, but at least at a minimum once every 6 months.
Once every 6 months. Yes.
Okay, board members, any additional questions for Ms. Puesta? I don't have any additional questions.
Do I, Anna Carr, for the record, I would move that we approve this application for Ms. Costas.
Second.
We have a motion by Ms. Carr, a second by Mr. Porath. Any further discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes. Great, we wish you all the best.
Thank you. Thank you so much.
Thank you very much.
Thanks. Thank you. All right, we're gonna go to 13B, and that is for Jeffrey Gross. So Dr. Gross, if you're online.
Heads up.
there Dr. Jeffrey Gross online?
We're looking.
I'll see him online, Madam President. Yeah, we do not have him online right now.
Okay, all right, we'll continue on. Do we have anyone from specialty?
Madam President, if we could just, the reason I asked that to be pulled, I just, in full disclosure, he applied, it required an appearance. The staff made a clerical error and granted it. We discovered, Yen and I discovered that today, and he does not get to have that controlled substance registration until he appears in front of you. So we will take the appropriate steps to address that. And it was, that we're human, we rarely have them, but there was a clerical error. Somebody turned it on when it shouldn't have been turned on. So I'm not saying that relates to anything that him being here or not, or whatever the deal is, but we felt, Yen and I felt that we needed to disclose that to you. So we're disclosing it now
Thank you for,
as part of that, and we will address it today.
appreciate that. Okay. All right, do we have anyone from Specialty Care RX? And that's agenda item 8E. Specialty Care RX.
Billy, no, go here so they can see you, maybe.
Hi, yes. Blanca Monterosa for Specialty Care RX.
Okay, great. Will there be anyone else joining you today?
Not at the moment. One of the owners of the LLC was present from 1 to 2:30, but he had to go to other meetings.
Okay. Are you comfortable moving forward then on your own?
Yes.
If I could have you state your full name for the record again.
Blanca Monterosa.
Okay, thank you. And if you could join me in raising your hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes.
Okay, great. Thank you. And then I will turn it over to Mr. Kuykendall.
Thank you, Madam President. We have a change in ownership application for Specialty Care RX, item 8E, and begins on page 4895 in the board book. This is a retail community pharmacy located in Las Vegas. There is another Specialty Care RX located in Orange, California. That a change of ownership application was submitted on the consent agenda. That item is for DDD and starts on page 3695. The Las Vegas Specialty Care RX was last inspected in July 2025 with no significant findings. And then Ms. Blanca, would you be able to provide a summary of the change in ownership for us?
Yes, absolutely. So the two locations are now going to be owned by the parent company BPJ, that's Boy Paul John LLC. The Las Vegas location, the legal entity name is PBC, Paul Boy Charlie LLC. And that location, as of January 15th of 2026, is now owned by the parent company BPJ. The Orange location, Orange County, California location is PGBB LLC, so Paul Girl Boy Boy. And that one, as of February 15th of 2026, is owned by BPJ.
All right, thank you for that. And now with this ownership change, will there be any staffing changes with the Las Vegas pharmacy?
Not at all.
Will there be any changes to policies and procedures with this ownership change for the Las Vegas pharmacy?
Not at all.
And then will there be any changes in services to patients with this ownership change?
Not at all.
All right, that's all the questions I have. I'll give it over to the board. Thank you.
Thank you.
Board members, any questions?
I just have a question for board staff, wondering why one was on the consent agenda and one is here before today. Is it because they're physically located in Nevada? Or was there some other reason why they needed to appear?
I'll have to look at that, it'll be just a moment.
Something we could probably follow up later.
Yes.
Okay. I don't have any.
I'm sorry. I do have a comment. I did receive an approval for the licensure for the California location earlier today, so I'm not sure if you guys need to know that for the record, or if I need to do anything different.
No, that's from the state of California?
No, from you guys,
Oh,
from Nevada.
us.
Mhm.
Okay, for your California locations.
Right. And it does have an
I'm just
effective date
wondering
as
because
yesterday.
I don't see any
Right.
disclosures or anything
Yeah.
that we would need to consider.
I move that we approve ownership change, for specialty care pharmacy.
Second.
Okay, we have a motion by Ms. Jacobo, second by Mr. Porath. Any further discussion? Okay, all those in favor?
Aye.
Aye. Any opposed? Okay, the motion passes. Thank you for your time today. We appreciate it.
Thank you.
All right, we're gonna continue forward and we'll go to agenda item 7A for Dignified Medical Equipment LLC. If we have representatives here or online, if you please come forward or raise your hand.
Hi.
Hi. All right, if I could have you both state your full names for the record.
My name is Man Simon.
And my name is Yordanis Diaz.
Okay, and then will there be anyone else joining you today?
No.
Okay, I'm gonna swear you both in and we could do it together. You could raise your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes.
Yes.
Okay, great. Thank you. All right, I will turn it over to Ms. Young.
Thank you, Madam President. This is Skylar Young for the board. Agenda item 7A starts on page 4545 of your board book. This is an application for a new medical products provider. It will be a Nevada facility located in Las Vegas. And ma'am, what was your last name? Stevens?
Oh, my last name is Diaz.
Diaz, okay.
Diaz, yes.
Got it. Thank you. The sole owner and operator is Mr. Simon.
Yes.
First, Mr. Simon, what products will you be providing?
The products.
Like what's our order? This
Yeah.
one? It's wheelchairs, walkers, diapers, and bags, and that stuff.
And I'm looking over your employment right now, and it looks like you are a caregiver and you have the PCA, so you have a certificate in personal care aid, is that correct?
I'm sorry, there's like an echo. I'm sorry, can you repeat that?
Can you hear me from here?
Oh,
With
yeah,
this
that's a
one?
lot better. Yes.
Okay. So he has his PCA, his personal care aid certificate.
Yes.
Is that right?
Yes, for the home care.
When did you receive that certificate?
Oh, wait, a certificate? No, he's a home care provider for a company. He doesn't own the company for the PCA services.
So in his title, he says that he's a PCA caregiver. So I assume he has his certificate?
The PCA home care, it doesn't require a certificate other than the CPR. Maybe that was put in incorrectly.
Okay, so do you have any other certificates related to medical care?
No.
Can he provide some job duties that he has with being a caregiver and any of the products that he wants to provide if he has been using those with his patients?
Yeah. So for your patients, what do you do for them?
Well, for the job for home care?
Yeah.
Yeah, like I take care for him. Like I help him with the diapers, washing and moving from and wheelchairs, transferring and that stuff.
And you've been a caregiver since 2020?
I'm sorry, I can't hear you.
You've been a caregiver since 2020? Is that right?
Yes.
I do have a question about the businesses. He's worked for Above the Rest Home Care, Heartfelt Personal Care, and All Valley Home Care, but they all have the same address. Are they related in some way?
I believe they're the same group of owners. I don't know if they're all the same owners, but they're all kind of connected.
Okay. He mentioned in his application he's going to be providing prosthetics. Have you worked with those products, sir?
Prosthetics is like the wheelchair, the brace, like for Francisco's knee brace.
What do you mean?
So have you worked with prosthetics before? No, he hasn't.
No.
Mm-mm.
So mostly, I think what I was hearing is diapers, and you said
Diapers.
wheelchairs?
Diapers, pads, wheelchairs, medical supplies, like diabetic supplies and safety equipment.
So can he explain more about the diabetic supplies he's worked with?
What diabetic supplies have you worked with your dad for the sugar?
Like you mean the test and
Yeah, like like with the socks and the testing and yeah.
yeah, like I help him with all the stuff like socks and his clothes and
No, the test for the sugar, the test strips.
the test. Yeah, like in the morning, early in the morning when I go first, I test his sugar and his high pressure too, and how his feel.
How many patients have you worked with since 2020?
I work like to I think it's 4 patient.
Okay, and is that on a part-time basis? Four patients?
How's that like when you give him the hoursly? Like
Yeah, it's part-time.
it's part-time, like it's not full-time because you give him some hours and I'm go over there.
As far as the products you're going to be providing, do you have a wholesaler that you're working with currently, or you know where you're going to get your products?
We were waiting on for licensing but we are researching some wholesalers. They are definitely going to be licensed medical supply distributors and manufacturers.
And Ms. Diaz, what is your role in the company?
I'm just going to help with paperwork and licensing and contracting.
Do you have experience with that, with licensing and day-to-day operations?
Yes, I do.
Can you? Okay, thank you.
I own an insurance agency and then I also do Medicare, and so I contract with a lot of the companies, and I'm very familiar with the contracting part and compliance as well.
Yeah, you're not mentioned in the application, but we'll note that you're going to
Yeah,
be
I don't know if I need to submit an application. Yeah, I don't know if but I'm not going to be in the day-to-day, so I don't know how that works.
Mr. Simon, how do you plan on servicing your patients? Are you going to go to their home?
Yes.
How do you plan on getting more patients than the 4 that you currently work with?
So you're going to do like the community events and relationships with doctors and facilities.
All
Yes.
about the customer.
Ms.
Yes.
Diaz, I'm
Mhm.
sorry, we would like to answer the questions, please.
Oh, yeah.
Yeah, like with from doctors and like the home care. If I know like somebody home care, he give me like some people needed help for that stuff.
I don't have any questions. I do have some concerns about just eligibility, really, with working with the products that he's mentioned in the application. But I'll pass it to you, to the board.
So this is Helen Park. I do also share some concerns about just your qualifications for an MDEG. And so we have specific qualifications that you must meet, which includes the 1,500 hours of verifiable work experience related to the products that you would like to provide. Based on your testimony today, I do not think you, per your testimony, have direct experience with prosthetics. I think that we clarified, right? You said you do not have a prosthetics experience. I think the other products that you had listed, Diabetic supplies, I'm uncertain whether or not you meet the qualifications for working with diabetic supplies. It does not sound like you have enough experience there. I think you likely have experience with the diapers and incontinence and maybe some of the assistive equipments. And I just have to look through your hours in terms of your work experience. I do think it's unusual that the three companies that you listed, as noted by Ms. Young, are all of the same address. And then we don't have any hours associated with that to confirm that you meet the requirements. So that's kind of where my concerns are at this time. Yes, Ms. Diaz.
I was, because I think he wants to stick more with like the bed liners and the diapers and the incontinence supplies. And also, concerning I think on the application, it had listed the hours for each company that he worked
Madam
with.
President. Yeah, that was on page 4563 of the board book, has the listed hours.
4563, okay, I'm looking at another page.
But if we could remove the prosthetics from the application, I don't know if that's something that we could do.
So you want to amend your application then to remove the orthotics and prosthetics?
Yeah.
And you want to still be providing assisted equipments, diabetic supplies, and incontinence supplies, is that correct?
Yes, mostly just incontinence supplies, yes.
Okay, do you want us to remove the other assisted equipment and diabetic supplies?
Do you want to remove the diabetic supplies from the application? Yeah.
Yeah.
Yes. Just the diabetic supplies, the assisted equipment and the continence supplies can stay on there.
Go back to that qualifications for those types of equipment?
I do. I'm wondering why Ms. Diaz needs to read. It's not like it's a language change, but is there a reason why you are talking to Mr. Simon for clarifying what I'm saying, or?
Yeah,
So
Mr.
it-
Simon,
it's
you're on
mo-
the application, so we would just want you to provide answers to the questions because it's directed to you.
Unless you're having a trouble understanding me or any of the board members,
Is there a reason why I'm talking?
Oh yeah, like I'm sorry, I try to do the best, but my English is not 100%. Like I speak and do some stuff, but some question I don't understand 100%. If no, like spell it to me, like get to I understand.
okay, I understand. But but Ms. Diaz is not doing any
Misleading.
yeah, translating is the word I'm trying to say. She's not translating anything to you.
I think I just break it down like to a simpler, like some of the questions, like the longer sentences so I just kind of break it down to a little bit to make it understandable.
Are you at all worried about how he's going to speak and communicate with the patients he's serving if it's hard for him to communicate?
I think so, but I think mostly there will mostly be his language, so it won't be that much of an issue. But I am planning, if we do get licensed and everything, to maybe be more hands-on.
Okay, and what's your first language?
Arabic. I speak Arabic and Assyrian.
Are you going to then find patients then?
Yeah, I know a lot of patients here speak my language, Arabic plus the Assyrian.
Sorry, I just wanted to confirm, did they want to remove diabetic supplies from the application as well?
Yes, please.
Just assistant equipment and the incontinence.
And the board staff can amend that. I have one question, if you don't mind, Madam President. On your application, Mr. Simon, you provided in your personal history application and your administrator application, your work history. And as Madam President brought up, in your work history, you listed that you work for All Valley Home Care, Heartfelt Personal Care, and Above the Rest Home Care. And they all list
basically same address with different suite numbers. So can you just confirm that these are,
Al
Sorry.
Valley, it's before, it's not in the same address.
okay, yeah, they're different suite numbers. I just want you to confirm that is correct. You didn't make an error in how you were reporting your work history?
So the address is correct, yeah.
Yes.
Okay.
And I think for the record too, it says PCA caregiver, and I think it should be just caregiver.
And when you say PCA caregiver, what is that title? What is PCA caregiver?
The home care.
What
The
does
home-
PCA stand for?
What do you,
PCA is the other word for
You
home.
list your title as PCA caregiver.
Home care
What do you-
worker.
yeah, it's a home care. Yeah,
Mhm.
like I'm with them like a home care.
Yeah, in your title, you listed that you're a PCA caregiver. What does that mean, PCA caregiver? What does PCA?
Oh, sorry, personal care assistant.
Okay. So you were providing individual care, your personal care to these individuals that you were treating at these facilities?
Correct.
Yes.
But you weren't treating them at the facilities, you were treating them in their homes.
Yeah, I go to the house.
Okay.
Yeah,
Okay.
when you give him, like I told you, like you give him the hours and see how many hours, and I start go to his house and do the hours.
Okay.
I think what's confusing is that PCA is a certification. And so the question is, does he have the PCA certification?
No.
No, I think that's a typo
I
then.
think that's what's confusing.
Mhm. No, he does not have a certification for PCA.
Ms. Diaz, do you have ownership in the company?
No.
Does the company have a location like an office, a building, a warehouse or something like that? Or do you work out of your house?
No, we have the office.
Is this the address on Losi? Is that the office?
No, it's a East Warm Spring. It's a 3175 East Warm Spring Road, Suite 128, Las Vegas, Nevada 89120.
4546. That's the address.
So, oh, I'm on the wrong.
Mr. Simon, one follow-up question. As a MDEG, which is a license you're applying for, will you be obtaining prescriptions for these products that you will be dispensing? How you said that you'll go to hospitals and that's how you'll gain business, but how do you plan on supplying these equipments to patients?
The prescriptions is what she's asking about.
The one I ordered, like to the customer, you mean?
Mm-hmm.
I didn't understand that 100%, the question.
So he will be getting prescriptions and then placing those orders and fulfilling those orders and delivering those orders.
Okay, great, thank you.
Mm-hmm.
Hey, well, I think based on the testimony today, I would feel comfortable with the limited products that we've identified today. So again, that would just be the incontinence supplies and then assistive equipment.
Okay.
And then if I understand correctly, there is a language barrier, but Mr. Simon is working towards providing his services to a specific population that speaks his primary language.
Mm-hmm.
Is that correct? Okay.
Yes.
Okay, so I would feel comfortable with this application. If you choose to add any additional products, you would have to notify the board.
Absolutely.
Absolutely.
All right. Board members, any additional questions?
I think it's a given, but it's pending a favorable inspection.
Good point.
I second.
Okay, so we have a motion by Helen Park, second by Jay Jacobo. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, that motion passes. All right, we wish you all the best.
Thank
Thank you so much.
Thank you. All right, we'll continue on with our agenda. We'll go to agenda item 7C for Sora Health LLC. We have anyone here from Sora Health LLC or online?
Hi, that'll be me.
Hello. If I could have you state your full name and title for the record?
Sure, it's Mimi Deng, CEO and founder for Sora Health LLC.
Great, I'm going to swear you in. If you could raise your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Great, thank you. Okay, and Ms. Young.
President, this is Skylar Young for the board. Agenda item 7C starts on 4586 of the board book. This is an application for a new medical products provider. It will be a Nevada facility located in Las Vegas, serve patients by prescriptions. Hello, Ms. Dang. First, can you tell us what products you're going to be providing?
Yep, we're going to provide primarily continuous glucose monitors by two manufacturers. Under Dexcom, it would be Dexcom G6, Dexcom G7, and then under Abbott, it would be Freestyle Libre 2 Plus and Freestyle Libre 3 Plus.
Are those the only products you're going to be providing then, the glucose monitors?
That's
And in
correct.
your application, it does say that you work, or you previously worked at Dexcom. Is that how you became familiar with the product?
Yeah, I was there for 6 years, so I'm familiar with both products, with one being the one I worked with and then the other being the main competitor at the time.
Can I interrupt? I'm so sorry, but I was able to get Dr. Gross on, and I hate to do this if the Todd's okay, but I think we need to go to Dr. Gross because of the condition that I gave. And I don't think we'll have time for this. We'll do it tomorrow, but I think it's better that we do Dr. Gross. And I was able to get him on.
So we cannot continue with Ms. Dang?
We'll make both, I don't think. But if you want to stay late and do it, I think Dr. Gross's will be more than 15 minutes.
If I may, Mr. Weiss, this applicant, I'm not worried about her. She's very well qualified.
Then you can proceed. That's fine.
So I can just present it to you guys, but the hours are there and she's worked with products that she's wanting to provide. I didn't.
You should take your time, but I just be aware that Dr. Gross is
you.
there.
Okay. I did review Ms. Dang's experience as well, and I think with her previous experience at Dexcom, I don't have any concerns about her qualifications as an MDIG administrator, particularly with the products that she is looking to provide. So I do not have any concerns with this application.
I agree, Madam President. I would move that we approve MDEG application for Sora Health.
Second.
Okay, we have a motion by Ms. Jacobo, second by Ms. Carr. Any further discussion? Hearing none, all those in favor? Aye. Any opposed? Okay, that motion passes. Thank you, Ms. Dang, for your time.
Thank you, appreciate it.
All right, we'll move to Dr. Gross, agenda item 13B.
Dave Weiss for the record, before you get to Dr. Gross. You have an item in front of you. Yen's going to run it through you. Dr. Gross did nothing wrong with the fact that we gave out the registration. Dr. Gross did nothing wrong with the appearance. It was on his schedule for tomorrow. I talked to his scheduler. He was with patients, and so he was courteous enough to jump on today so that we can address the issue. And I didn't get to talk to Dr. Gross, but Dr. Gross, we gave you your controlled substance registration in error. It was an error on our side, nothing that you did wrong. And then you went and got you didn't know that, so you went and got your DEA registration. But staff thought it was important to address it today so that we can deal with it. And I didn't, talking to our attorneys, I didn't want to take it away necessarily or in a particular fashion that would cause some harm to you professionally as we cause the issue. So we're just trying to work through. And if you don't grant it, we have a very clear path forward. The fact that we granted it in error should not weigh into your fact whether you grant it or not. And Yen will take you through the item.
And then, if I may, I'd like to just swear Dr. Gross
Yes, of course.
before we proceed. Dr. Gross, could you please state your full name for the record?
Jeffrey Gross, MD.
Okay, great. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Great, thank you. All right, Dr. Long?
Thank you, Madam President. Yan Long for the record. Dr. Gross, I'm going to just walk the board members through your application. You provided several disclosures, and that is the reason why you're appearing before the board today. Dr. Gross's application appears on page 5134 of the board book. He is applying for a controlled substance registration for schedules 2 through 5, I believe. There was some minor changes to your application, so it may have been 3 through 5, but 2 through 5. So he provides several disclosures, and I'll kind of go through them in chronological order. And Dr. Gross, please let me know if I've made any mistakes in citing what happened through your documents.
Just one other thing. He did have discipline with
Yes.
us, and part of that discipline is he needed to appear before he reapplied. And that's where we had the issue. And so Yen's going to say the disclosure, he's reapplying, but he was required by a previous order and can go through that discipline, or it's probably disclosed. But that was the requirement that he appear. So I just want to make sure that's clear.
All right, so on or about August 7th of 2020, Dr. Gross pled guilty to and was convicted on 1 felony count of conspiracy to violate patients' rights to honest services. The conviction resulted from allegation charges that Dr. Gross conspired with the owner of Pacific Hospital in accepting bribes and or kickbacks for patient referrals to the hospital for spinal surgeries and other procedures between 2008 through 2013. Pacific Hospital has since closed. They closed in 2013. The indictment included 90 overt acts by Dr. Gross and others involved to demonstrate the deliberate and intentional acts of payments of kickbacks to Dr. Gross and others in exchange for patient referrals to the hospital for surgeries, MRIs, and other services, paid for primarily through the California Workers' Compensation System. Dr. Gross performed and or referred kickback team to surgeries and services comprising at least 19 million billed, for which the affiliated hospital was paid more than 5.5 million. As part of his guilty plea, Dr. Gross admitted he was paid at least about $623,000 in connection with his kickbacks. So that was in August 2020. On May 21st of 2021, Dr. Gross was sentenced to 15 months in prison, ordered to forfeit his $623,000 and pay, I believe, a restitution of $45,000. And upon release from imprisonment, he was to be placed on supervised release of at least a 3-year term with conditions. It appears Dr. Gross started his prison sentence around August 2021 and was released January of 2022 to a halfway house in Las Vegas, followed by a period of home confinement, and was released from home confinement and placed on supervised release July 5th of 2022. And Dr. Gross, have you completed all the terms of your court order at that point?
Yes, I have.
Thank you. Then on September 16 of 2022, Dr. Gross entered into a settlement agreement with the Nevada Board of Medical Examiner. His license was suspended with an immediate stay, and he was placed on probation for 48 months. And he was required to submit and pass 5 sections of the Ethics and Boundaries Assessment Services examination, perform 20 additional CEs, perform 300 hours of community service. And so that was a 48-month probation. Have you completed all the terms of your settlement with the Nevada Board of Medical Examiners?
I have.
Thank you. In November of 2022, the Utah Board of Medical Examiners, they license their individuals through DOPL, Division of Licensing of Department of Commerce. They also revoked Dr. Gross's medical license. They stayed the revocation and placed Dr. Gross on a 3-year probation. It was related to the felony conviction. Have you completed the terms of your Utah order, Dr. Gross?
I have.
Okay. And then in September 8th of 2023, the California Medical Board also revoked Dr. Gross's license related to the conviction in federal court. Are you licensed with California Medical Board at this point, and are you going to obtain licensure with them?
I am not currently licensed with the California Medical Board. I currently do not have plans to seek relicensure in California.
Okay, perfect. And then on October 17th of 2024, Dr. Gross surrendered his DEA registration by executing a DEA Form 104 entitled Surrender for Cause, consistent with the terms of Memorandum of Agreement with the DEA executed on October 17, 2024. And it was related to this felony conviction. Is that correct, Dr. Gross?
Yes.
And in your MOA, your Memorandum of Agreement, it states that you cannot apply for a DEA registration for a period of 1 year from the effective date of the agreement, which was October 17th of 2024. That means that you couldn't apply for a DEA registration until October 17th of 2025. Is that correct?
That's correct.
In or about January 15th, 2025, Dr. Gross did enter into an order with the Nevada Board of Pharmacy relating to this felony conviction. Dr. Gross's controlled substance registration was revoked in that he couldn't apply for a reinstatement of his registration for a period of 1 year. Dr. Gross was ordered to pay a fine of $5,000 and was ordered to pay a fee of $1,000. Dr. Gross, have you paid your fine and fee to that particular order?
Yes, I have.
I think our records show that you have not paid your fine and fee to us for that order. So we don't have your fine and fee for that.
It's a surprise to me, and it will be immediately rectified if that's accurate.
Okay.
Yeah, board staff, if you have records of it, we can look at it too. So that's why we're asking you under oath.
Okay. No, I'm embarrassed that it's even a question. So if there's something that was missed on my part, I will rectify that immediately by any means you tell me.
And so that is the history of Dr. Gross. I do have some questions for Dr. Gross. Since your felony conviction and time served, Dr. Gross, what have you been doing for employment? I know that you finished the items of your board order with the medical examiner with Nevada. You said that you're currently practicing and you're seeing patients. So how long have you been practicing since your felony conviction and the time served?
Since my plea agreement, and except for the times that I was either at the 6 month away and at the halfway house and home confinement, I have been actively returning to my patient base. So actively seeing patients, caring for people, otherwise uninterrupted.
And what time frame would you say you resumed practicing?
The very day that I was released from home confinement, I believe I got back in the office.
Okay, so that would have been July 5th of 2022?
Yeah, I don't have a calendar if that was a weekend. That was the Monday following that, perhaps. But shortly thereafter, I returned immediately to that which I do best.
Okay. And do you currently practice in your own practice?
I do.
Okay. And what is that practice? What is the name of that practice?
It's called Spine. It's a DBA for JD Gross Medical Corporation, a professional corporation.
And how have you been able to prescribe to your patients? Do you do surgeries for your patients?
I don't prescribe controlled substances because I'm not authorized to prescribe controlled substances. So I work on other treatments, non-controlled substances. I'm not a big prescriber anyway, even before the plea agreement. I don't do any surgeries, although I do some injection procedures.
Okay, and I did notice that your JD Gross Medical Group on your application, it's a DBA of Recelebrate. Can you tell me what does Recelebrate mean? You said you're doing injections. Are these like stem cell therapy injections currently that you're doing?
No, there are regenerative biologics that are not stem cells. They might be proteins or growth factors that you might find in platelet-rich plasma, PRP.
And are these like FDA approved products that you're utilizing in your practice?
Well, I use vitamin D and many things that aren't approved for marketing claims, but we are fully compliant with the FDA. And everything we use, we obtain commercially through regular suppliers like McKesson and other FDA registered suppliers.
Thank you. And how do you bill for these services when you perform them? Are they, just you're taking cash payment for them? Are you billing insurances for these services?
I don't bill insurance, so most of my patients pay cash.
I do want to point out the Inspector General did state that he cannot apply for, he has an exclusion period of 10 years from being able to accept Medicare or Medicaid or federal insurance for any patients. That's all I have. I'll turn over to the board for any additional questions. Board members, any additional questions?
I don't have any questions. I mean, I think Dr. Gross has paid his debt to society. The crimes didn't really have anything to do with controlled substances to begin with, so I wouldn't have any issues with approving this application.
Second. I do want to mention that in the clerical error, we did issue him his controlled substance registration, and therefore he went and obtained a DA registration. He's limited to Schedules 3 to 4 currently with the DEA. I just want to note that on record, and he can't request for Schedule 2s until October 2020.
That's a condition of
The DEA memorandum of.
Got it. Okay.
You can make it a condition of yours just to match if you choose to.
Adam Porth, for the record, I would move that we approve controlled substance application for Dr. Jeffrey Gross to match the stipulations of the DEA memorandum of understanding.
And then do we need to also make sure that he settled up with any of the prior fines that he owes?
Yes, that will be correct.
I don't think you need to make it part of your thing. We'll do a show cause if there's any issue. I think we'll give him the benefit of the doubt that he says he pays it and we'll go look for it.
Right, so motion by Mr. Porath. Second by Ms. Jacobo. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, that motion passes. All right, thank you, Dr. Gross. We wish you all the best.
Thank you.
Dr. Rose, sorry for the quick call, but appreciate you
Oh.
jumping on.
We made it work. Thank you all.
All right, thanks.
Bye-bye.
Okay, public comment?
Yeah.
All right, so as our final order of business today, we'll open up the floor for public comment. If anyone here wishes to make a public comment, please come forward if you are in the room or if you're online or on Zoom or on the phone, please raise your hand or press *9 to have your line unmuted. Oh, please come forward.
Please come up to the
Come to the
table.
mic, please. That's okay.
So sorry, my name's Mark. I just first have attended one of these meetings, and you guys do a wonderful job, and we really appreciate you in the community for all your hard work in keeping this community safe.
Thank you for your comments. We appreciate that. Public comment on the line.
Yeah, just again, while we're pulling that up, if you have public comment that's related to a workshop item or a hearing tomorrow, we request that you wait for that item to be called, but we're happy to hear public comment. And I think we had somebody from this morning, so hopefully.
Yeah.
Can.
Is there anyone else online?
Two, yeah, we'll get them.
There are.
Yeah, two, sorry. iPhone with no other number, we have unmuted you if you can identify yourself.
Hi.
Yeah.
My name is Emily Smith. Good afternoon. I can see that you guys have been here all day, and I really appreciate your work that you do for our community. I've never done a public comment either, so please excuse me if this is not proper, but I'm here because I'm desperate. Again, my name is Emily Smith. I'm a mother of a child who depends on a critical, sustaining, temperature-sensitive biologic. And I'm here because the law requires these drugs to be refrigerated, but it doesn't currently mandate that they be monitored during transit. And the gap in the law leaves parents with no objective proof of safety. I understand that you guys cannot adopt a new regulation today, but I'm here to request that you formally begin work on this issue and agendize it for a future workshop. To start this process, I've emailed the executive secretary a formal position to adopt the regulation under NRS 233B.100 to the team bc@pharmacy.gov. This is not just about a worm box. My daughter's medication is a protein, and if compromised by Nevada's extreme heat, it can denature. If I administer it, my child faces high risk of anaphylaxis and allergic reaction, which could cause irreversible damage to her body and end her ability to receive her treatment at home. The stakes of guessing temperature are permanent. Despite these risks, I have been pressured by pharmacies to trust theoretical studies that offer no proof of what happened to the medication when it was stuck in a hot truck or sitting in a warehouse for several days. I am told that a squishy gel pack, if it still feels cold, is proof of safety, but squishy means the cold chain has already started to fail. I was even told by a pharmacy director that if I continued to refuse these questionable shipments, they would no longer work with us. I have been threatened with the loss of care for my child because I refuse to risk my child's life on a paper guess or a touch test simply because the law doesn't require a better standard. A squishy bag is not science, and a study doesn't account for a 3-day warehouse delay. My petition asks Nevada to adopt language similar to Texas Rule 291.12, mandating physical temperature indicators to move the conversation from the pharmacy's opinion to objective fact. I have submitted this formal petition today to trigger the 30-day review period under NRS 233B.100. And I'm asking the board to protect Nevada children from anaphylaxis and medical coercion. No parent should be bullied into giving their child a potentially dangerous drug. I implore you to expedite this to the best of the board's ability. My child's safety and the safety of all Nevada patients depends on it. Thank you.
All right, thank you for your comments.
Yeah, Madam President, Dave Weiss for the record. I mean, you don't typically respond to public comment, but you're allowed to. So if you want to, or if you want me to say something, I can.
Yeah, I think it's hard not to respond sometimes.
I don't mind. If you want me to do it on your behalf.
Go ahead if you.
So we did get your email. It's today. We got it today. It's, we're in this meeting, so sorry for that delay, but that we're limited staff. I think the law, and the board will tell you this, the law does require the drugs be delivered to you in the manufactured storage requirements. While it doesn't say by what fashion that is, this is something that actually comes up every summer, and I'm glad that you brought it to our attention today. So if you put your contact information on your email, I'll contact you personally tomorrow. We also can, you can make your request for regulation, which the board will process as required by law. But I think in the meantime, I'm willing to talk to you, and it's a very complicated matter, which you already know, so we should probably do that offline. And this is Dave Weiss for the record. I appreciate your public comment, even though you've never done it.
You did excellent. Yes.
Can I, Brett Camp for the record, can I just add one other thing? Because the speaker obviously did some research on how to submit a petition, but it also has to conform to NAC 639-140.
Yeah, I don't, we'll address it. So I'll call you tomorrow afternoon.
Great. Do we have anyone else who wishes to make?
We have one more.
Okay.
Hey, sir, my name's Dr. Kelly Turner. I was advised to show up today in where I was originally scheduled tomorrow. Do I just sign on tomorrow? My only concern is I'm driving across the Southwest, California, Arizona, New Mexico, and I fear I might not be able to have a phone signal.
Yeah, so the board meeting's done for today. Staff will contact you after this meeting on your contact information. So they're watching this. They'll contact you and tell you what's going to happen. And we'll make every ability to give you a more finite time if we can to make sure that you can stop and call in. So we'll do that. So.
Roger that. I'll sign on tomorrow and follow as permitted via telephone signal, but there's some dead areas in Arizona and New Mexico that I got to cross.
All right, Dave Weist, over.
Thank you.
Roger that.
Yes, specialty care RX in Orange County. It's really
Certainly.
You are correct. The laws in NAC 639215 states that if they're applying for a license to operate a pharmacy in this state for the first time, they have to appear before the board. So since the Orange County location is not operating a pharmacy in this state, we can put them on consent.
Thank you.
Yeah, just for the clarification, in this state means operating a license in this state. So they could be required to appear, but the board can also the board staff could put it to. So I just don't want to, in the state comes up all the time. In the state means licensed in the state when it's referenced in other part of the law.
All right, great. Anyone else in the queue for public comment? No? All right. Well, with that, then we'll adjourn our meeting for today and we'll reconvene tomorrow morning at 9 a.m.
Did Dave
Thank you, everyone.
Stevens?
Yeah.